Hello. Hello. I hope you heard the music. Good morning. Good morning, Carrie and Neil and Lee. How are you, darlings? Happy Tuesday. I was a little late. I didn't mean to be. I really was just sitting there like an idiot. Just flipping around. Hi, Oomph. I was just flipping around, flipping. Actually, I didn't flip. I don't know what I'm talking about. Look, I have a new picture for you. Hi, Neil. I made a new picture for you. Hi, GP. I watched the Bad Faith. Oh, isn't it so good? Isn't it so good? It's so good. Oops. Stop it. Stop moving. Anyway, I hope you had a good night. I hope your night was good. I had a good night. Got some good sleep. Need to pour my coffee. I even didn't smoke all of I left most of a joint last night. So now I have a joint ready for this morning. Oh my god. I'm so special. I hope everybody else has what they need for this morning. Oh yeah. Oh my god, the smell of this coffee is just intoxicating. It really is. Good day. Good day, sunshine. Good day, sunshine. Good day, sunshine. I found this great picture of Mickey Mouse kicking a kid at Disneyland. Pepper Saltina, I love you very much. Pepper Saltina, I love you very much. um, I hope you're having a great day. Like, I don't know. I just woke up and I'm like, well, here we are. It's Tuesday. I don't really know. Um, but yeah, I think there's things we want to read, and there might be something to watch today. That is no, it's Damn it! I knew the picture wasn't going to be good enough. It's very hard to find. This is Clitta. That's Clitta. Wait, let me make her head bigger. Hold on. Make her head bigger. And then sad Clitta. Mean Mickey. I love that. I watched a 3-part series called The Making of Lachlan Murdoch. Ooh, it's available on YouTube at ABC In Depth. More right wing than Rupert? No. I don't know what to do about these people anymore. Why don't they want to do things? Why are they so fucking greedy? Like, this is like greedy times 7,000. There, I can't turn her head. This is one thing about this program. I wish I could, like, rotate the picture a little bit. I like Mean Mickey, though. Wait, I gotta show you the real picture because the real picture is just fucking awesome. I don't know. Is it real? This must be AI, right? This has got to be AI. Hold on. I'm going to call it Mean Mickey. Just because you said that. Hold on. Let me find this picture. It's so fucking funny. I just fucking love it. Yeah, here we go. I don't know why this makes me laugh so bad. I don't want a kid to get kicked. I don't. I love kids. Why does this make me laugh so much? It looks like Tina Peters after too much cell back Chablis. Cell block Chablis. It just adds a new flavor to Pinot Grigio. Dun dun. Yeah, it is. It is. It's Tina Peters getting kicked out of Disneyland. Mm. Anyway, I thought that was funny. I just love this picture. I don't think it's real. I hope it's not real. I don't want any kid to get kicked in the head. That's for sure. Nobody wants that. Nobody wants that. I do have a rather dark sense of humor, though. Rather gallows humor. I hope that isn't real. Both Rupert and Lachlan Murdoch were progressive in their youth. Why? Then why are we here? Then why are we here? I really want to believe that if I became a billionaire, I wouldn't lose all my sense of humanity. Mickey's shoe. I know. It's funny because it's not real, yeah. Although, I don't know. It looks like it really launched that kid. I'm kidding. Anyway, I love that picture. It's not real. Damn it. I mean, no, I didn't mean that. Oh my God, I just sounded like a horrible person. I didn't mean to. I'm just disappointed because, never mind. I'm going to stop talking about it. I don't know why I'm disappointed. I just thought it was real. That's all. And I'm like, what happened after? What happened after that happened? Oh my God. I'm going to make this a little smaller. Yeah, I don't. God. And we had a good space last night. If you were able to join us, I hope you did. If you didn't, I understand. You can't spend 24/7 here, But the space was good. How far did he fly? He flew pretty far. Mickey Kicky. J-Rance! The space was fun last night. We told the tales of J-Rance and the hamster. And J-Rance with a glue gun. That's one of my favorites. J-Rance saved her house from being destroyed by Milton by using a glue gun on a window panel. It was great to be with you. It was great to be with you. Oh my God. Yeah, so what is it, Tuesday? What is today, Tuesday? She's a glue gun warrior. And she's gonna stick it to you. She's a glue gun warrior. I just wrote you a song, J-Rance. Well, Pepper named it. So, that's it. And your Hammy. Hammy's back. She's a glue gun warrior. And she's gonna stick it to the bad guys. A glue gun warrior. I'm gonna make you an 80s hairband anthem, J-Rance. We'll tell the tales. The glue gun warrior. I really like that. Yes, clever use of a glue gun. Yes. Keep your house from falling down. It's pretty amazing. Okay, so what else? Oh, Trump's meltdown yesterday. I'm so sorry. I don't like to give in to his abilities to manipulate the news cycle, but here I am doing it. Stick it. Sticking it to the bad guys. I was very happy for the space last night. Great info and community. I know, really good. Just a good group. Good group of people. Good information. Good conversation. I really enjoy those. I'm really glad that kind of came together. I invite more people to come on up and talk and say what you want to say. Be what you want to be. Do what you want to do. Gal, good morning to you. We were just making an anthem, an 80s hair band anthem for J-Rance and her glue gun. She's the glue gun warrior. That's the start of it. Pepper named it. Pepper helped. Pepper helped. I like good laughs. Right? I mean, just really good people. Like, we're really good people. Has anybody checked on us lately? Because we're really good. And let's see. That Trump thing last night. Okay, listen, Max, that's what I was going to talk about. I they are all bizarre, right? They're all like unhinged, that he says terrible things. We know. Last night was so special. Like, it was so special. I've never seen him. Yes, exactly. Put that glue gun to good use there, Jay. But I'm telling you right now, that was the most bizarre. There's a Zoom that looks interesting that I'm going to hop on in 15 minutes. Oh, sweet. Thank you. Thank y'all. Yeah, I was gonna look at some stuff for this morning. I felt like we should watch something if there's something to watch. There's a Zoom. Okay, let me take a look at it. One-on-one. Oh no, this is not it. That is not it. That is not it. Do not mess with me. That is not it. Oh, there it is. Oh boy, it looks like it's good. Hold on. It's the final countdown, and you're going to regret it at the final countdown. Hold on. I think Nathan Wade is testifying. Is he? Okay, so listen. Thank you, because I'm not really up on shit. Hold on. I'm gonna find some stuff, because this is good. Because I need to drink coffee and I need to smoke some weed. God damn it. Priorities, bitches. I'm really proud of myself for not smoking the main part, like my last joint last night. I'm really proud of myself because now I got something to smoke right this morning. Okay, sorry. I digress. Hold on. I didn't see anything this morning, but it's just because I wasn't paying attention. It's the final countdown. She's a glue gun warrior. Oh, God. What? God, the Young Thug trial has been going on as long as I've been on YouTube. The Zoom is with Judge Ludwig, the Supreme Court's role in the upcoming election. Ooh! What? Yeah, where is that? Hold on, Joni. Hold on, Joni. Here we go. It's the final. Oh, it's Democracy Docket. Fun. Oh, we're definitely gonna. Hold on. Hold on, darling. Hold on. I'm gonna RSVP for it. Hold on just a minute. Doodle-doo-doo, doodle-doo, doodle-doo-doo. I wonder if I can. Oh yeah, I can. I did this before. Doodle-doo. Thank you. I walk away and people slip in. Hi, Jay Rance, Max Flower. Max, where are you? Oh yeah, the Trump thing. I mean, really. Okay, listen. Let me give you my speech. We're going to watch that thing. Thank you, Gal. We're going to watch this thing with Judge Ludwig and Democracy Docket about the role of the Supreme Court in the so the thing last night. So, as with every Trump rally, someone faints because they've stood in line outside in the elements for however long, usually hours, and then they get stuffed into a box to stand there listening to really bad music. And then finally, he's late, so they've all been standing there kind of absorbing each other's carbon dioxide. And it must smell terrible. And then inevitably, of course, one of them drops like a fly. And so silence and like looking for the doctor and him sitting on stage awkwardly, looking over. So that's fine. That one gets kind of wrapped up. And then literally within minutes, another one drops. So the same thing, silence, awkward. Him and Kristi Noem on the stage, awkward. During the second one, he decides that what this situation really needs is last rites. So imagine fainting, waking up, and hearing Ave Maria playing as you look up at the bright lights, as Gal said last night. Imagine that. But then it gets weirder because he yells backstage during, or maybe after Ave Maria, that was the wrong version and that what he really wanted was the one where the guy sings. The Pavarotti. Okay? So I think it's even simpler than that, actually, GP. I think it's that, J Rance, sorry, J Rance, thank you. I think that he literally likes those songs and it's like a kid that wants to perform during, the parents' dinner party. Like, watch me. And he'll be like, oh, this song's really cool. I want you to hear this song. It's really cool. So I think that's what he's like. Crispy Gnome. That's amazing. Oh my God, Max, stop. That's so amazing. Crispy Gnome. That's it. That's who she is. Mixed with random boomer music. Yeah, no, totally. So he yells at Justin backstage that if he doesn't find the right song, he's going to get fired. And then Justin, I guess, finds the right song and then starts doing, yeah. And then they play that song, the Pavarotti version of Ave Maria. And he's literally standing like one of those when you have a bottle in the ocean and it kind of bobs up and down. That's kind of like what he's doing. It's, like he's bobbing, weaving. And Christy is definitely trying to, keep it together. But at one point, you hear her hot mic as she's standing next to him, and he says something to her, and she's like, oh, no, this is fine. So you can tell that he's like, is this okay? Are we all right? And she's probably like, oh, yeah, this is fucking great. It was so bad. Yeah, springtime for Hitler and Germany. Yeah, it's the producers. That's what we've become. So then it gets weirder because Trump, and that song's over, and then he decides he wants to play the pasta commercial song, pasta sauce song. No apologies or na na. That song, whatever that song is. Yeah. Dad, we gotta go. Yeah, it was like the lost grandpa. This was like my father. Like, we've got to leave. Stop talking to people. We've got to go. Time to say goodbye. That's right. That's what the song is called. I don't know what I call it. It's the pasta sauce song. So anyway, so he plays that one. But then he's got a couple of other songs that he wants people to hear. Literally, okay, so his answer to 2 medical emergencies at his event is to keep them there longer. Exactly, Max. He was 4 questions deep in this town hall. It had just started. And it completely derailed. And I saw a man who was literally physically brain melting in front of me. Like, I thought it was going to spill out his nostrils. Like, he literally looked like this was an episode. This was an episode. It just is so, it was so bizarre. And it's not, he can't hold it together. And the thing about it is that he doesn't have anybody behind him who can even attempt to get him to hold it together. It's almost like they're just letting him go and banking on the cheating, accusations. But they're just like, you know what? Just let him do it. It doesn't matter. Nothing matters. He's not going to win the right way. He's going to, he's going to take power. So it doesn't really matter what he does in public, I know the people on the stage behind him that he never acknowledged until he like walked over there. They want JV Vance. I mean, he is so boring. I don't know. I cannot. I mean, Vance to me is like, except for the fact he's got like a Dr. Evil behind him, Peter Thiel. Except for that difference, he is basically Michael Dukakis. I mean, really, literally. I just think, yeah, if he takes power, it won't be for long. I can't imagine. This really seems like they're using him to win because he's the only one the base he's the only person the base likes. Like, he's literally it. It's so bizarre to me. It's so bizarre. I don't know. It was so weird. I know, evil misogynist Dukakis. I don't know. I never really paid much attention to Michael Dukakis. I'm going to be honest with you. I voted for him because he was a Democrat, but that's about it. Sent his truth for. Oh God. Oh my God. I can't. It's so funny to me. I can't. Wait, let me see. Oh my God, Jack Posobiec. Oh my God, this is his assessment of last night. Thank you, gal. I had a town hall in Pennsylvania last night. It was amazing. The Q&A was almost finished when people began fainting from the excitement and the heat. We started playing music while we waited, and it just kept it going. So different. But it ended up being a great evening. Didn't you have a great evening? He had a great evening. Did you have a great evening? He had a great evening. Wow. He's crazy. Jack Pozo says, my parents, brother, and cousins were all at the Pennsylvania Town Hall last night, and they loved it. No, Jack, are you kidding me? They loved it? Crazy. Crazy. I want to follow these people. Court accountability count? Ooh, wow. Boy, they don't have many followers. Oh, they just joined. Wow. Not very popular. Well, how very popular are you kids? Best karaoke ever. That's right. Best karaoke ever. Me and my girlies got down with the karaoke last night. Yeah. We were singing Nessun Dorma and all that shit. All that opera shit. I love opera all of a sudden. That's what he says. No, I don't. I don't. I don't know. I'm really curious to see what happens election night, the day after election, etc. I'm really curious. No singing, right? Yeah, it's karaoke without the singing. He just wants to listen to it. Shh. That's what he'd be like. Shh. Don't sing it. Nessun dorma. Shh. Nessun dorma. El principe. Yeah. Oh my God. I can't. When we start up this thingamabobber Zoom, I'll smoke some weed. But I'm gonna tell you, this is it just cracks me up. I'm sorry. It just cracks me up. How do we get here? How do we get here? How did we get here? I wonder. Let's see. I'm gonna have to move Mickey Mouse. Mickey and Clitta have to move. Where is that? Mickey, you're Mickey. You're so fine. You're so fine. You move my mind. Well, let's see. Where should I put you? Actually, Mickey, I'm going to set you off to the side, and then I'm going to put Sad Clitta right here in the collage border. Let's see. Let's do that. Yeah, she can be right under. Well, right by the Kraken. We'll just have her peeking. Oh, yeah. Look at it. It's becoming quite the border. Actually, we're building quite the border. I love it. I like the Clarence Thomas picture. Let's see what else is happening. God, I'm like a little slow today. I'm sorry. I'm just a little bit behind. Well, okay. Don't say anything. Okay, hold on. Let me go to that. Where can I go? What can I do? Oh God, I have stuff to read too. But hold on. Do 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 do. Wait, where am I? Oh my God!
Recording in
Are you really this
progress.
slow?
On the Supreme Court's
Lolo,
role in the
hold on.
upcoming election. We're so pleased today to bring you a set of top political and legal voices addressing this important subject. I'm Norm Eisen from the State Democracy Defenders, and my job is to introduce today's events, to lay out the agenda, and then
Nice.
I'll pass it to our first panel. We know that the election subversion movement and its strategy runs right through the judiciary because of the 63 failed cases that they brought in 2020 and the explosion of pre-election litigation that they've brought. We've never seen anything like it in American history. Public trust in the safety and security of our elections is imperative, but as part of securing that trust, we need to prepare seriously for the risk that the justice system, and in particular, the MAGA bloc on the United States Supreme Court that has delivered terrible decisions favoring the former president in a series of cases, perhaps most outrageously Trump v. U.S. We must be ready and steadfast to make sure that we do not see a continuation of that pattern. And that is why we are bringing you this all-star set of panelists today talking about the issue and what every American must do to be ready for this post-election litigation season, the risk and the responses. And there's no one better to kick that off. We'll have two panels. There's no one better to kick that off than I'm proud to call him my friend and my colleague, Judge Michael Ludig, who's going to be interviewed by one of the greats of the legal journalism field, Dahlia Lithwick. Judge Ludig served on the U.S. Court of Appeals for the Fourth Circuit for 15 years as an appointee of former President George H.W. Bush, confirmed by the United States Senate on a bipartisan basis. He'd previously been in senior roles at the United States Department of Justice and in the White House, the latter under former President Ronald Reagan. He was a law clerk to then Judge Scalia on the U.S. Court of Appeals for the District of Columbia, and a law clerk and special assistant to former Chief Justice Warren Burger. And there has been no more forceful or courageous voice, conservative, liberal, or otherwise, than Judge Ludig, who burst upon the national consciousness in the January 6 hearings and has been such an important voice of conscience and patriotism ever since. He'll be introduced by our friend Dahlia Lithwick, senior editor at Slate, the author of their Supreme Court dispatches and jurisprudence columns for decades. She also hosts Slate's award-winning biweekly podcast, Amicus. And is a best-selling author, including her recent book, Lady Justice, Women, the Law, and the Battle to Save America, an instant New York Times bestseller. Two better folks to kick us off for the first portion, and then we'll have our all-star panel, so stick around.
Agreed.
When Dahlia and the judge finish their fireside chat. Dahlia, Judge Ludig, over to you.
Thank you so much to Norm. Thank you to Court Accountability and Defend Democracy. And Judge, it's just always such a treat to be in conversation with you, even, here we are 3 weeks before the election. And I think I just wanted to start by asking you this one framing question, which is, if we start from the presumption that the Supreme Court has kind of already weighed in on the upcoming election, I'm quoting you telling the New Republic's Greg Sargent after the immunity case that already you knew it's unlikely that Trump will ever be tried for the crimes he committed in attempting to overturn the 2020 election. So I guess I'm wondering, even before we get to the sort of prospective conversation about what's coming, how much, if at all, does the fact that the court has made it impossible for there to be real accountability for 2020 figure into the court's role already in the upcoming election?
Dahlia, thank you for that question, and thank you, Norm and Dahlia, for the opportunity to be with you today. Both of you are, at this point, are dear friends, and it's really an honor for me to be on with the two of you. Yes, of course, Dahlia, the Supreme Court has already weighed in on this election. It has done all within its power to ensure first, and successfully, that the former president would not be tried before the 2024 presidential election. And then secondly, it has done all within its power to ensure that the former president will never be tried for the grave offenses that he committed against the United States on January 6th and thereafter, both of which ensure to the maximum extent possible that the Supreme Court could ensure that Donald Trump will be elected to the presidency on November 5th, 2024. That's a lot, and we can parse through each and every one of them, but the headline, if you will, to what I just said is that the Supreme Court has done all within its power to ensure that Donald Trump is elected president of the United States again, and that gives us every reason to think that it will do whatever is necessary between now and January 2025 to ensure that Donald Trump is the next president of the United States.
Judge Ludig, I don't want to spend a lot of time on the 3 cases that the court has heard, because I think you've so kind of fulsomely critiqued them over the course of the summer. But I do want to give you a minute to reflect on all 3 of the Colorado ballot case, the Fisher case, and the immunity case that Norm discussed, only because I think you've described each of them as not just kind of, I think you described the Colorado case as a decision that disfigured the 14th Amendment. You described Fisher as, in your amicus brief as like through the looking glass, the law of Humpty Dumpty. And the immunity case, I think you actually, I saw you describe it as the Dred Scott of the Roberts Court, insofar as it put the president above the law. But I wonder if, without going too deep in the weeds of your critiques of that trio of cases, Judge, if you would just talk for a minute about sort of any through lines you see between, how the court set about doing what it did in all three of those cases.
Dahlia, speaking first to the Colorado case and also the immunity case, Trump versus United States, I consider both of those decisions as a betrayal of the Constitution of the United States and of America at this particular juncture in American history. Turning first to the Colorado case, there's no question whatsoever under the plain terms of Section 3 of the 14th Amendment that Donald Trump became disqualified from the presidency on January 6, 2021, and is to this day disqualified from the presidency. What did the Supreme Court hold? It would be impossible to say what the Supreme Court held. What we can say, though, is that it refused to decide the issue. In effect, in the end, sending the case to the Congress of the United States to decide, in the first instance, literally every single one of the 4 or 5 fundamental constitutional issues that are raised under Section 3 of the 14th Amendment. The Supreme Court of the United States was established in the Constitution in order to decide cases exactly like the 14th Amendment case. And then in deciding that case, as you alluded, the Supreme Court disfigured, I don't think I used that word, but that's apt. It rewrote Section 3 of the 14th Amendment, and therefore the 14th Amendment itself, in ways that were indisputably not intended by the framers of Section 3 of the 14th Amendment. Turning to the immunity case, the Supreme Court literally held that the President of the United States, and in particular, Donald Trump, the former president, is immune from prosecution for essentially all crimes, any and all crimes that he committed or would commit if he's elected in November. That is, any crime that he committed that was arguably in furtherance of his official responsibilities as President of the United States. Before Trump against the United States, not one single person since the founding of the country, and especially not one single constitutional scholar or student of the Supreme Court, had ever as much as suggested that a president of the United States would be immune from prosecution for any crime whatsoever, let alone for every single crime that he or she commits. We know that this decision was written solely for Donald Trump to ensure that he would never be prosecuted and convicted for the grave offenses that he committed on January 6th. It would never have been written but for Donald Trump. Then the third of the trilogy is Fisher. I don't regard Fisher as in the same category as the other two cases, frankly. I disagreed with it for the reasons that I set forth in our amicus brief with my colleagues that we can go into. But I would, for today's purposes, I would call Fisher nothing more but nothing less than a typical Supreme Court decision. Though, in the context that we're talking about today, it was a further insurance that Donald Trump will never be convicted of the charges for which Jack Smith has indicted him.
So, Judge, to the extent that our task this morning in this conversation is to try to understand the extent to which things have changed in the intervening 4 years since, as Norm Eisen said at the top, 63 cases, the court refuses to get involved in any of the election cases. The story we tell about the 2020 election is that the justice and judicial system held, that it worked. And I think the question that I want to animate the rest of this conversation is, has that changed? To the extent that you think it's changed, how much of that is a function of those decisions we just talked about? Are we in the same world where we can be confident that if whatever the Bush v. Gore or whatever case, I know the next panel is going to talk about what those cases look like, go to the Supreme Court, can we be confident that the same court is going to behave in the same way? Or do we have this new data that suggests, as you said, that the court seems to be at least somewhat invested in protecting Donald Trump?
Oh, well, Dahlia, of course, that's the question of the day. But first, I don't really agree with your thesis, and for this reason. I've said this publicly many times now, but it's not been picked up because it's so far down the line of priority. But I do not believe January 6th would have ever occurred had the Supreme Court stepped up in the fall of 2020 and decided the independent state legislature theory. Once the court refused to decide that case, which came up from many courts of appeal, several courts of appeals, including from relating to Pennsylvania, I think was the final, and the court decided to deny cert. The die was cast for January 6, 2021, and then of course, as soon as possible after that, after January 6, 2021, the Supreme Court took the case and the issue and decided more against Harper in a way that I believe would have prevented the January 6th. But putting that aside for the moment, the next caveat that I would make is that that we don't have the same court today that the nation has had for almost 250 years since its founding. So it's not, for me, so much a question of do we have the same court today as we had in 2020. It's simply that we have a much different court than we've ever had in our history, and then specifically on the issues that will come up between now and January 6, 2025. And as to that court, there should be no question whatsoever as to where it will be going in the cases that do come before it between now and January 6th.
Okay, well, that's quite despondent making. I guess I had hoped for a slightly more ambiguous answer, but I don't disagree with you. I do want to ask you, when I read your thoughts in advance of the cases that we've discussed, the trilogy of cases, with the understanding that Fisher is a very different, a different kind of case, but you rooted all of your analysis and your interpretive strategies, in originalism, in textualism, in text and history and meaning. And it does raise, I think, for people who think about you as somebody who has really broken away from the conservative legal movement, it raises this question of, Is the court just getting originalism and textualism and text and history and meaning wrong? And I remember once asking Justice Stevens in an interview how he became, a left flanking member of the court, and he said the court moved around me. And I sort of want to ask you the same question. Did the conservative legal movement move around you in terms of the meaning of textualism and originalism in history?
No. The current Supreme Court doesn't follow, if it even believes, in originalism and textualism anymore. We know that as a matter of interpretive fact, if you will, from, if nothing else, the two of the three decisions that we talked about. There was no support whatsoever in the Constitution of the United States or the laws of the United States or in originalism for the immunity case. By the same token, there was nothing in the Constitution or laws or originalism or textualism that supported the Supreme Court's indecision in the Colorado case. Today,
Yes, Gal.
what we know is that the Supreme Court picks and chooses the times when it wants to rely upon originalism and even textualism to meet its objectives at that moment. I said, actually, when the Supreme Court decided the Bruen case, the Second Amendment case out of New York, that the only silver lining was that originalism was a dead letter. And that turned out, in my view, to be more than prescient. But it began with the Bruen decision, which was, I also wrote an amicus brief with my colleagues in, and it was purely based on originalism. And the court's decision, written by Justice Thomas, was unrecognizable to me and my colleagues as an opinion of originalist interpretation of the Constitution of the United States.
Yes.
Judge,
Let me know your
I've
question. I'll put
heard
it
you
in.
say over and over again that the single most salient issue for you thinking about going into the 2024 election is democracy, continuing democracy, peaceful transfer of power, the rule of law. And I wonder if you think that the American public fully understands the enormity of that question, or if it's just too much of an abstraction. And then I guess my part B, this is a Stephen Breyer multiple part question, but my part B is, do you think the court fully understands that democracy, peaceful transfer of power, and the rule of law are very, very much the thing that is at risk in this election?
I love that question, Dahlia, and literally right before I came on today, I finished an essay that we'll publish soon on the election, American democracy, and the rule of law. And the highlight of that essay is that Donald Trump and now the Republican Party have corrupted American democracy and the rule of law. And therefore the question, and therefore the election in November is a test of Americans' commitment to their democracy and rule of law. Now, turning to the Supreme Court, not only do I not believe that they understand that, I believe they fully understand it, and they categorically disagree with it, Dahlia. There's nothing else that would explain the decisions that we've been talking about. And by the way, it's not for today, but I've attended these oral arguments in these cases, and some of the questions from some of the justices betrayed that very thing, that those justices at least don't accept that any of this is about American democracy and the rule of law. Now, they're simply wrong, and it's reprehensible in my view for any judge, frankly, any person, to say that this election is not about American democracy and the law and the rule of law. Now, turning to the abstraction point that you raised,
We got it.
I have written, and it may have been, I think, in my endorsement of the vice president, that the political talking heads and the political operatives tell us all the time that American democracy and the rule are too abstract for the American voters. Well, I don't believe that's ever been true, but if it has, it's certainly not true today. Donald Trump tried to overturn a presidential election in 2020. That's perhaps the gravest offense that can be committed by a president of the United States. And today, he and his Republican, obeisant Republican Party persist in their false claim that he won that election. And Dahlia, today, the former president and his Republican Party refuse to tell the American people that they will accept their vote and their will in the election that's coming up in only days. The American democracy and the peaceful transfer of power are the fundamental tenets of our constitutional republic. And Donald Trump and the Republican Party today are threatening America. They're holding America hostage for another January 6th when they say that they will not respect the will and the vote of the American people unless Donald Trump wins. That's abhorrent, but many, many millions of people, Americans who are Republican or Republican leaning, I believe they like that position that's being taken by Donald Trump. For the life of me, I cannot understand it. But I can tell them one thing: this is the moment, the man and the moment in American history that our founding fathers and the framers of our Constitution feared more than anything else in the world.
Judge Ludig, I just want to add my voice to Norm Eisen's to say I don't know of a lot of people who have done more than you have and staked more of your skin in the game to make this very point. And it's just always a treat to be in conversation with you, and always really just an honor to see the work that you've done. So thank you for joining us. And with that, I'm going to turn us over to Mike Sachs, who's going to shepherd along the second panel. Thank you, Judge.
Thank you, Dahlia. Thank you, Norm. And wish I could stay with you, Mike Sachs, but you're going to have fun talking to Mike.
Thanks, Judge.
Enjoy the rest of your day.
Thanks, Judge, and thank you, Dahlia. Wonderful panel, wonderful Q&A, and always a pleasure and often quite scary to hear what they have to say about what's coming up and what has already happened in our legal system and our political system leading up to this election. I'm Mike Sachs. I'm a senior advisor with Court Accountability, and this panel is going to be a pretty strong, quite strong exploration of the election interference threats heading up towards the Supreme Court as we speak. Joining us with us right now is Aziz Hook. He's a scholar of U.S. and comparative constitutional law. His recent work concerns democratic backsliding and the regulation of AI. His award-winning scholarship is published in several books and in leading law, social science, and political science journals. He also writes for Politico, The Washington Post, The New York Times, and many other non-specialist publications. In 2015, he received the Graduating Students Award for Teaching Excellence. He's at the University of Chicago. He has active pro bono practice. He's on the board of the American Constitution Society, the Seminary Co-op, the New Press, and the ACLU of Illinois. Welcome, Aziz. We also have with us Lisa Graves. She's the Executive Director of True North Research, Court Accountability's sister investigative watchdog group. Lisa works with journalists and others to shine a light on those fueling regressive agendas targeting our freedoms. Lisa is one of the nation's foremost experts in exposing how special interests distort public policy and try to thwart the public's interest in a thriving democracy and a healthy planet. And Lisa is also the president of the board of the Center for Media and Democracy and a trustee of the Park Foundation. Also joining us is Adam Bonin. He extensively represents clients in campaign finance, election law, pay-to-play, official ethics, and lobbying compliance matters, and has been a leader in efforts on behalf of the rights of online speakers. He's been successful on both sides of the ballot access battles, successfully representing candidates for office and defending their right to appear on the ballot, as well as removing others from the ballot whose signatures have been procured fraudulently or unlawfully, and has successfully aided clients in post-election recounts and litigation as well, including 2 tied elections for local office. And then finally, I hate saying last but not least, but it especially applies here, is Madiba Denny. She is an attorney, columnist, and professor whose work focuses on fostering an equitable multiracial democracy. Denny is the deputy editor and senior contributor at the critical legal commentary outlet Balls and Strikes. In her previous role as a counsel at the Brennan Center for Justice, she provided legal and policy analysis regarding a range of democracy issues, including the census, the courts, and attempts to disempower communities of color. Welcome all, and everyone watching at home. I wish they give them a hearty round of applause that we cannot hear because only you can hear us. But we all hear it and are happy you are joining us to watch this panel. Now, I want to start with Aziz. Aziz, your recent Politico piece is called "Why the Supreme Court Might Case the Final Vote for President." Now, of course, that conjures up Bush versus Gore flashbacks from 24 years ago. Are we staring down another scenario now where the Supreme Court might pick our president above and beyond the will of the people?
Hi, Mike, and it was a pleasure to hear Judge Luttig and Dahlia just now, and that was a real treat to hear, in particular, Judge Luttig's diagnosis and description of the situation. I think the way that I would build on what they said would be to maybe lay out the pathways whereby the Supreme Court could take up a case that was decisive with respect to the 2024 presidential election. I think that the specter that looms over that question is, as you said, Bush v. Gore. And Bush v. Gore is indeed the canonical or the most obvious pathway for the court to take up an election-related case in short order and issue a ruling that decides the election. Bush v. Gore, recall, was an appeal of a federal law question
We just read this
from
the really
Florida courts directly to the Supreme Court. This is the meat and potatoes of what the Supreme Court does. It hears cases concerning contested questions of federal law from either state courts or federal courts. And certainly, as Norm Eisen has shown in the tally that he is keeping on just security of election-related cases, there are almost a dozen cases floating around in state and federal courts raising federal law questions which might impinge upon the election. But since Bush v. Gore, there have emerged at least 3 other pathways for the court to interfere or to pluck an election dispute out of the political process and decide that case in a way that is outcome dispositive with respect to the election. And let me lay those out because I think it's helpful for people to know just what the lay of the land is. So the first concerns questions of state law. Now, most lawyers or law students will know that the Supreme Court is a federal body, and its jurisdiction, its power to decide cases, is limited in almost all cases to federal law questions, questions of federal statutes or federal constitutional law. However, in a case called Moore v. Harper, which Judge Luttig mentioned, the court, for complex reasons that I won't go into, held that there was some class of cases in which a state Supreme Court issues a ruling on state election law, and the Supreme Court can intervene and say that the state Supreme Court's ruling on state election law is so wrong that the federal Supreme Court has the power to reverse it. So Moore v. Harper has a kind of loaded gun in it, which allows the federal Supreme Court to transform a question of state law into a question of federal law that it can decide. And the boundaries of this transforming category are entirely unclear from the text of Moore v. Harper. So that pathway where state law issues can become federal law issues, can become things the Supreme Court can decide, simply did not exist at the time that Bush v. Gore was decided. So that's the first pathway. The second pathway is, I think, an inadvertent side effect, of reforms to the Electoral Count Act. The Electoral Count Act was a statute passed in 1887 that, as its name suggests, describes the way in which electoral college votes are counted in the days after an election.
I think.
The 1887 statute, however, was hardly a model of congressional draftsmanship. It was a very confusing and poorly drafted measure. Congress amended the Electoral Count Act in 2023 and imposed much needed clarity. However, one of the changes that they made to the Electoral Count Act creates at least a possibility of litigation and deep uncertainty. Under the pre-2023 Electoral Count Act, when a state submitted its slate of electoral college votes to Congress, it had to do so by a safe harbor, which was in early December. I believe it was December the 5th. And if the state failed to meet that safe harbor, it's not that its electoral college votes were not counted, it's that those votes were no longer treated as being conclusive as a matter of law. The recent amendment to the Electoral College Act, however, says that a state must submit their votes by a safe harbor of December 6th. And the statute does not, unfortunately, say what happens if electoral college votes are delivered after December 6th. That gap in the statute creates an important kind of legal uncertainty. It creates uncertainty which invites efforts to delay the certification of electoral college votes, potentially in states that are decisive with respect to the Electoral College. Think here of both Georgia and Arizona, where you've seen something of this, of the groundwork being laid for this, although there's been pushback even in the last couple of days from the Georgia courts. But you can imagine a case where a state fails to submit its slate by December the 6th, and where the question of whether a tardy slate of electoral college voters is counted comes up to the Supreme Court through the judicial review provision that's in the Electoral Count Reform Act. That's pathway number 2. Pathway number 3, and I'll try and do this really quickly, is as Judge Luttig explained, the Supreme Court in the Colorado primary ballot decision essentially punted. It declined to say whether former President Trump was covered by Section 3 of the 14th Amendment as an insurrectionist because of his role on January 6th. It punted because it said, well, that decision is for a federal, not a state actor to make. And it pointed to the fact that in the process of determining whether a senator or a representative can be seated, each House of Congress has exercised authority pursuant to Section 3 to decide whether somebody can be seated or whether they must be excluded under Section 3. Now, if one House can exercise that power, why can't two? Why can't the joint session of Congress that meets in the wake of the election exercise the authority under Section 3 to decide that somebody is an insurrectionist under Section 3 and therefore not eligible to take the oath of for the presidency? Obviously, it's unlikely that Congress, as presently constituted, would take that vote. However, there are mechanisms within the joint Congress for a minority, 20%, to raise the issue and perhaps force a vote on the question. And where the vote fails, it's not entirely clear that that minority would lack the power to challenge the joint session's decision in a federal court. Indeed, there is a provision in the Electoral Count Act that seems to allow that kind of substantive challenge and litigation on the merits of the question. And were that to happen, one can imagine the question that the Supreme Court punted back in the Colorado case, coming back to the court essentially on January the 7th for resolution before January the 20th. And for all the reasons that Judge Luttig said, I think we know how that case is going to turn out.
Yeah, it's something you don't really want to
certainly put the court in a hot spot.
Yeah, that's one of these moments where if you're relying on this court to save democracy, you probably are a little too late. But Aziz, thank you for that rundown and that piece. I can't recommend highly enough to those watching here. We can put it in the chat, the link in the chat for those who want to read it. I now, because Aziz was talking about the cases in general, I want to go to Adam because you're in Pennsylvania on the ground floor right there as these battles are being waged. And what Aziz talked about earlier, the first bucket of cases he's talking about are these Moore v. Harper challenges where state courts are interpreting state law, but the Supreme Court could very much jump in and say, yeah, but you got it wrong, state court, and you got to have the state legislatures handle this issue. So I want to ask you, that's one way to get these cases to the Supreme Court. How has that affected the Pennsylvania litigation that you've either been witnessing or been involved with so far?
Sure. First of all, thank you so much for having me here, and I'm thrilled to be with such amazing panelists. And yes, I'm based in Philadelphia, Pennsylvania, during a presidential election year, which very much, it's like Tevye's line in Fiddler on the Roof. We understand that you're our chosen people, but could you maybe choose someone else next time? We know we're at the center of the storm, and there's a lot going on. And yeah, these Moore v. Harper issues have come up before and will come up again. 4 years ago, amid COVID, our state Supreme Court interpreting our state constitutional protection of that all citizens have a right to vote in elections that are free and equal, used that as a justification for extending the receipt deadline for mail ballots from Election Day to 3 days after Election Day. And the U.S. Supreme Court split 4-4 and therefore holding the decision in place, with the 4 dissenting justices believing that our state Supreme Court had gone too far in interpreting a state constitutional provision. And yet we have every reason to fear that that's going to happen again, as to other things. Election season in Pennsylvania doesn't start after Election Day, and we are dealing with a variety of cases right now, both on offense and on defense. On defense, 6 Republican congressmen have brought suit in federal court, challenging the way that we handle military and overseas absentee voters this year, as to what, saying that they should be required to give more proof of citizenship than what Pennsylvania is doing, which the state believes is absolutely consistent with its obligations under federal law. So they are trying to throw out military and overseas ballots right now. There are Republican challenges to the use of notice and cure for defective mail-in ballots. You know, when you send in your envelope and it comes in and a voter forgot to sign the ballot or forgot to put the current date on the envelope before sending it in, whether those states, you know, whether there's an obligation to let that voter know before election day so that they could take steps to try to secure their rights, either through casting a provisional ballot or otherwise. That is being challenged. There is offensive litigation that's going on that's trying to establish that there is a due process right to have that notice before election day. There are cases about whether it is required that if a voter finds out that their ballot is defective, that they have the right to cast a provisional ballot and have that counted because your first vote was never really cast. I mean, that's all already under works. What happens after election day is anyone's business. 2020 was a perfect storm in a lot of ways because Pennsylvania had a new law allowing for anyone to vote by mail, which was enacted in October of 2019, well before COVID. It was a law that, you know, had like any major piece of legislation, had a lot of open challenges to it, you know, both on the details of how it was to be interpreted and on the macro level, as we saw after Election Day, as to whether it was constitutional at all for the right to vote by mail to be extended in that way. We had a series, and I predict another series of internal Bush v. Gore-ish challenges as to whether, you know, as to whether variances in how counties apply this law, Act 77, as to whether that deprives anyone of equal protection rights. During the 2020 cycle, a lot of these cases were litigated, and the courts, and I have to say, including Republican federal, you know, Federalist Society approved judges, all sort of said, you know, Bush v. Gore does not constitutionalize every jot and tittle of state election administration. So they've allowed some play in the joint so far, but we don't know what's going to happen this year. But yeah, I mean, everything that we are litigating and everything that our courts are deciding, you know, we have a intermediate appellate court, the Commonwealth Court, which specializes in electoral and governmental related matters. We have a state Supreme Court, you know, with 7 justices who now have all been through the storm of election litigation before. I think.
And Adam, can I interrupt you for there for a second? Because your state Supreme Court in recent days and weeks have almost fallen on a grenade to voting against voter rights, really. So to prevent these cases from being plucked by the Supreme Court to make, I imagine, worse Moore v. Harper law. And there's like this contest between the Pennsylvania legislature, which is still, I think, at least partly Republican, and the state Supreme Court, which is majority Democrat. And like there's like real politics stuff going on too, just to keep these cases from getting to the Supreme Court. At least that's my read.
Yeah, oh, absolutely. It was deeply frustrating. We've had a recurring issue under Pennsylvania law with regards to so-called undated ballots which are voted by a voter, received by their county board of elections on time, timestamped as being on time, but where the voter neglected to handwrite in the date of voting. And the statute says, you know, the voter shall fill in, sign, and date the ballot. There have been challenges both under federal statutory law, U.S. Constitution, and under the state constitution most recently, that free and equal elections clause, as to whether this was, you know, more burdensome than is necessary to further any state interest, because no one has really identified any state interest in this. And there was a strong, bold 4-1 decision from the Commonwealth Court about a month ago saying, yes, the free and equal elections clause means that this statutory term cannot be used to disenfranchise voters. And yeah,
then the Supreme Court of Pennsylvania said, we're getting out of this. We're staying out of this.
We're getting out of this.
The
It's
U.S.
too close
Supreme
to
Court. The U.S. Supreme
use,
Court is now considering the same very issue on the federal side. And so like this is like, and what we're talking about here, Adam, it seems like these are small things, but like this is stuff at the margins in which elections are won and lost, which is why the Republican National Committee is bringing these suits, not the ballot sleeve one that was brought by voting rights plaintiffs, but across the country, a lot of these issues are brought by the Republican National Committee in the Trump campaign in order to make different gains at the margins in close states. And sorry to interrupt there, Adam, but I do want to get to Medib on this, because we're also seeing the RNC bringing suits in various states. Mississippi, where Trump is going to win, Mississippi, Nevada, which is going to be more of a battleground state, saying that these states which have state laws that allow the election administration to count validly cast votes, mail-in votes that arrive after election day for a certain amount of days, 5 days, 4 days, a dozen days, what have you. This was an issue in the 2020 election, but it's now one that the Republican National Committee is bringing suits in these various areas. And the Republican National Committee lawyers before the Fifth Circuit, which this case was argued in the Mississippi case a few weeks ago, were saying, well, originalism demands that the election ballots have to be counted on and by election day, and no later. These state laws are unconstitutional. So it was always thus for a really tactic that emerged from Donald Trump's head 4 years ago, that like how does originalism comport with this raw and rank and newfangled partisanship?
That is a great question. I do always find it really entertaining when originalism is presented as a reason why something new has to happen. So for viewers who may be unfamiliar with the concept, originalism is this legal theory that is really promoted by the conservative legal movement that says that the meaning of the Constitution is fixed in time, it's frozen at the moment of enactment, and however it was understood then, allegedly, is how we have to understand it now. And so we excuse me. So in these cases, the RNC and other like Trump-aligned organizations are now making the case that under originalism, we can't count validly cast ballots if they were not received by election day. So these are ballots that were postmarked, sent, but arrived afterwards. And the Republicans are saying that when Congress passed these election laws, they required ballots to be received by election day itself. That was the original public meaning then, so it has to still govern now. This is foolishness for a couple different reasons. One is that it's not necessarily true that this was actually how things were done, considering this is like a novel argument that's being made. And second, and perhaps more importantly, even if it was true, so what? There's not really a legitimate reason why this should be the governing standard. It doesn't actually make sense to prevent states from responding to the needs of their constituents and doing some sort of common sense decision making to let folks who properly cast their ballots still have their votes counted. It doesn't make sense to say that the Constitution, which is in theory at least supposed to facilitate the nation's democracy, actually has to prohibit valid democratic participation. And this, I think, really sort of underscores the point that I make throughout my book, The Originalism Trap, about like how originalism is really just used in order to entrench the conservative legal movement, to keep them in power and to withhold power from a majority of the electorate.
Yeah, I mean, it's no coincidence really that we're hearing these hyper-partisan arguments wrapped up in these originalist or hyper-partisan positions wrapped up in these originalist arguments, because they're intertwined, right? There's this project is all part of the same ecosystem. And Madiba, you've written about that in the book that I see emblazoned behind you, The Originalism Trap. Like, give us some, like, just a small bit of that historical background, and then I want to bring in Lisa Graves, who will really give us a deep peek under the hood of what's been going on here and how this isn't all just a coincidence.
Yeah. So originalism really developed as a backlash to the successes of the civil rights movement, and has been used to give a legal sounding cover for standard reactionary politics. And this has been used more and more as groups like the Federalist Society really promoted originalism and mainstreamed it and got it accepted to be the now dominant method of legal interpretation. And we've seen this used in a bunch of different ways, but I'll specifically talk about the voting realm for now, to basically allowing conservative justices to say, if I claim that this thing happened before, now it's fine, and now it has to happen presently. And they're using past injustices to validate present ones, and to try to like lock in unfair, undemocratic situations, and saying that like that's actually what the Constitution requires, even though provisions of the Constitution, like the Reconstruction Amendments, were expressly designed to prevent things like this and allow a multiracial democracy to flourish.
Reconstruction amendments that the Supreme Court has done a fair share in gutting, most recently including the Colorado ballot access case that Trump brought, in which the insurrection clause was rendered a dead letter by at least 5 justices of our Supreme Court. Madiba, this is a pattern that we've been seeing, and now has been supercharged and almost magnified since 2020. And Lisa, this is where I want to bring you in, because one of the cases we're seeing now are the Republican National Committee's voter roll purge cases. You're seeing these across the country, and in one of them, the State Board of Election is removing one of these cases, I think in North Carolina, over to a federal judge who happens to be Richard Myers II, a Trump appointee who has belonged to the Federal Society and the Christian Legal Society since 2004. And he also was one of the first people to gut the 14th Amendment's insurrection clause back when Madison Cawthorn introduced it after January 6th. And it went way further than the Supreme Court actually did. So this removal from state court to federal court might be a random assignment to this particular judge, but the possibility of this happening wasn't really by chance, was it, Lisa?
No, and thank you so much, Mike, for that introduction. And it's a joy to follow Madiba and be part of this panel. And it's been a joy to work with you and Alex Aronson at Court Accountability. I just want to say, I guess to draw the lens back to your point, and I think some of the other points, there's no doubt that there's judge shopping going on by these, people who are devoted to making it harder for Americans to vote, and in essence, trying to use the courts to put Donald Trump into office. I want to talk a little bit about some of those groups, and as you said, Mike, sort of the origin story here, because it's not just happening in a vacuum. What we have is a whole ecosystem that has been created to try to make it harder for Americans to vote. And I would be remiss if I didn't say, just to pause and say, what a different world it would be if Judge Luttig had been put on the U.S. Supreme Court instead of John Roberts, given what Roberts has done and the machinations he went through in order to keep Donald Trump on the ballot in this election, and to make it impossible for the criminal case to go forward, the trial to go forward before the election this year. But when you look at what's happening, it's not just Trump litigating. It's these groups that are very closely tied to Trump that are moving these cases forward. So, for example, you have a group that calls itself Restoring Integrity and Trust in Elections, RITE. Who funds it? One of Trump's biggest funders, Steve Wynn, the casino billionaire. Who leads it? A guy named Derek Lyons, who was the right-hand man, the staff secretary, basically, for Donald Trump during the Trump administration, and who clerked for Brett Kavanaugh. Brett Kavanaugh actually had that role as well in the George W. Bush administration. But Derek Lyons is not just that guy. He's also the guy who worked with a thing called the Judicial Education Project, which, not to have too much alphabet soup, is another group that's involved in these cases through its alias, which is known as the Honest Elections Project. So you have people who are at the center of this litigation, who are bringing these cases, doing this judge shopping, trying to change the rules for voting as people are in the process of voting. And they have deep ties to the money infrastructure that helped capture this U.S. Supreme Court. So you have Leonard Leo, obviously, is the person who's been most closely tied to the Judicial Education Project, which, as I said, has this alias, the Honest Elections Project. Leonard Leo has helped inject more than $170 million into the Judicial Education Project alone. We believe that money has come from the big trust that he received a few years ago called Marble Freedom Trust, which is the $1.6 billion gift Leonard Leo got after he helped capture the U.S. Supreme Court. So here you have litigation moving toward the Supreme Court that's being fueled by the man who helped get some of these judges installed on the Supreme Court, and by operatives who have worked closely with him on basically laundering the big lie from 2020 through groups like the Honest Elections Project, trying to make it harder for Americans to vote through changing the state laws and then using the courts to litigate them. We're seeing that litigation from RITE and Honest Elections Project in a number of states, including Arizona, in the Mia Familia case. We're seeing it in Montana, for example, where they've jointly submitted an amicus brief, basically trying to move that door open from Moore v. Harper to let the Supreme Court say that state courts that protect voting rights cannot do so, that legislators have the final and only say about our voting laws. And this is all happening in the context of a U.S. Supreme Court that, as Judge Ludig set forth, so clearly has put its thumb on the scale of justice in these rulings in immunity and also in the Colorado case, in the Fisher case. And let me just conclude with this, which is you have a U.S. Supreme Court where, not only do you have members participating in those decisions who should not be in those decisions, like Clarence Thomas, with Jenny Thomas's active role in trying to subvert the 2020 election and even instigate these fake electors in Arizona and Wisconsin. You have Sam Alito with the revelations of his role and his wife in terms of flying these insurrectionist flags after January 6th and more. You have 3 justices on the Supreme Court who actually were lawyers involved in the Bush v. Gore litigation. That's John Roberts, that's Brett Kavanaugh, and that's Amy Coney Barrett. And you have a situation in which this Supreme Court, in essence, has been corrupted. If Thomas and Alito had not participated in that immunity case this summer, it could have gone the other way. But that's not the only thing that's happened. In Bush v. Gore itself, we know that Clarence Thomas participated in that case, even though his wife, Jenny Thomas, was working for the Heritage Foundation to pick people who would go into the Bush administration if he won, and was rewarded by becoming the top highest paid non-board member of the Heritage Foundation after Clarence Thomas cast the deciding vote in that 5-4 decision in Bush v. Gore. That decision in Bush v. Gore happened in just 4 days from the Florida Supreme Court decision allowing those votes to be counted. So we are facing a significant and substantial threat in this cycle from this Supreme Court of a Bush v. Gore 2 by justices who should not be sitting on these very cases, but who are paving the way for the type of litigation that is being filed in state after state after state. So I'll turn it back to you with that, Mike, and thank you for letting me speak into the next hour.
Well, now that everyone is terrified and our hairs are collectively on fire with a very, very concerning report you just gave us there, Lisa, that is an excellent, frankly, way to close out this panel, because everyone here watching is here to understand the election interference threats that are heading to the Supreme Court's way right now. And it's not just these discrete cases that are being randomly thrown into various pots to hopefully find a way to the Supreme Court. There is an ecosystem involved here, as Lisa so well detailed, that has deep historical pedigree that Madiba so well has chronicled, that is being played out in each state, as Adam can so attest to in Pennsylvania, and has multiple pathways to the Supreme Court, as Aziz himself did detail. So thank each of you panelists for joining us here. Everyone watching, we are 5 minutes over, but I hope that 5 minutes was well worth your time. It was worth mine for sure. And I hope that you will all continue to pay attention to what's going on and keep your voices loud and clear as we follow these cases over the next weeks, and hopefully not several many more weeks beyond that.
Post those
Thank you for
questions.
watching. I'm Mike Sachs with Court Accountability. Thank you, Dahlia Lithwick and Judge Ludig, for joining and starting off this event. And again, thank you all for watching. Have a great day.
We don't get the what? What? What now? Hey now? What now? Hey now? Where? What? How did that? What did happened? What just happened? Oops, that's not the right one. Where's my other one? Oh, there it is. Nope, that's not it. What? Oh yeah, but it was quick. It was super quick butterflies, so you could run back and just isolate that one part. We're gonna join the Georgia hearing, which is Cobb County Board of Electors and Registration versus the State Election Board. So we're going down to Georgia. Wait, what? What in the butt? What in the butt just happened? What in the butt just happened there? Please and thank you very much. Please and thank you very much. Let's see. I want to do that, and then I want to do this because I want to plan ahead. You know, sometimes I like to plan ahead. I don't know. Call me crazy. All right, we're going to join it, and then I'm going to speed him up a little bit. Hold on. All right, let me see if this is the beginning.
Be helpful. I have them electronically, but this machine's not talking to that directory. So
okay.
Thank you.
So what's that mean? I think this is just them getting started, but hold on. Okay, see you later, Carla.
Refer to during my argument. I've also provided that to counsel for the respondent.
Okay, I think this is housekeeping.
That derives its power weeks, and that is already happening with respect given BOER's duty. And that's why FLOAM, the footnote 7 in particular, could not challenge the constitutionality of a state law. Well, that's right. That's a rule of law that's been in existence for many decades.
My goodness, can anybody speak up?
Said is that the power to sue and be sued was given only to enable GIIP to bring and defend legal actions pertaining to its statutory functions and duties. So there, the court recognized that GIIP could sue. It was just limited to getting essentially a court resolution of its own duties and powers. And of course, it's an obvious proposition that an agency that derives its power from the legislature really can't sue to challenge the legislature's acts. We are not suing the legislature. We are suing another creature of the state legislature and asking for a court ruling as to the validity of rules passed.
The guy speaking represents Cobb County. So this case is Cobb County Board of Elections and Registration versus the State Election Board in Georgia. Probably around the rules they're trying to force down their throat before the election, in a few weeks? All right, so we're going to start it, and I'm probably going to speed them up just a hair to 125. So let's see how we can understand, if we can understand. Sorry about the audio. It's maxed out, and they say they have captions, but they lie.
It's not by the legislature, but by another agency. And that's why FLOAM, the footnote 7 in particular, the Supreme Court's most recent statement on this issue, makes this very easy for the court. And frankly, that decision, and this is tab 18 of the binder that I just handed to you, answers both the question regarding a declaratory judgment and the uncertainty that we as a election board face, as well as the question of capacity to sue. The footnote 7, the Georgia Supreme Court earlier this year says, given the Cobb County, I mean, this is talking about our county board of elections and registration, given BOER's duties in administering elections, that is the kind of uncertainty that would support a declaratory judgment. And the declaratory judgment was regarding the validity of a redistricting, how we administer elections. So I don't think the court needs to spend a lot of time addressing either of the two issues that we talked about this morning, because the Supreme Court, thankfully, in footnote 7, provided us the answer. Now, we are not the only board also that is asking for court guidance on this issue. And Your Honor, we filed a motion yesterday asking the court to take judicial notice of the fact that the DeKalb Board of Elections, as well as the Muskogee Board of Elections, and these are differently situated boards, but across the state, suffer the same uncertainty that we do. And Your Honor is familiar with also who have the same concern. And so this is not like one rogue local election board trying to pick a fight with the state election board. This is a case where the chief legal officer of the state, the chief election officer of the state, that comprise different populations, different demographics, all have serious questions regarding how this election to happen in 2 weeks. And that is already happening with respect to absentee ballots, and early voting is to be administered.
But of all the rules, the one that seems to concern people the most is the hand count rule. And we just heard a fairly persuasive presentation as to why on the one day that it might involve, or maybe a day after, if there are too many ballots to be hand counted, again, just number of ballots, not contents of ballots, that's nothing that affects today. We could both go vote early, and the hand count rule doesn't implicate how today would be administered by a county board of elections. What is all the uproar about if it is as simple and non-impactful as Mr. Thomas described it? He got down to 14 minutes for the typical precinct in Cobb County. That doesn't seem like the type of imposition people need to say, stop, we need judges to get involved because we don't have 14 minutes. I'm sure it's more complicated than that, but that was based on numbers, not the speculation. It could be very knowledgeable speculation that this is going to get complicated because my poll workers, they're not going to stay late. It's going to be a long day for them. And they're already saying, if I have to be hand counting ballots, I'm just not going to show up.
That's fair. And if you don't mind, Your Honor, I'll walk through the rule because I think my answer to that question requires considering what the rule says. And so just to point out, as we stand here today, this rule is not in effect. And so to the extent that we request an injunction or a temporary restraining order, and we ask that the court maintain the status quo today is that this rule is not implemented. And I think that that's important because even though counties across the state are probably trying to figure out what preparations need to be made to comply with this rule in the event that the court holds it valid, it is not even yet in effect. And that's important to the legal analysis with respect to our request for a TRO.
And is that true for all 6 rules? They all have an effective date of October 22?
That is correct, Your Honor. The state election board noticed the hearing to receive public comment about these rules on August 21, that exactly 30 days before its hearing on September 20th. Its hearing took place on September 20th, and despite not giving the public notice about this, it voted to approve those rules. The Secretary of State then, as you see on the screen, Exhibit 15, published these rules, and the date of publication is what triggers the rules. I think it's 20 days from the Secretary of State's date of publication, which is October 22nd. So that is next Tuesday, which means literally 2 weeks before the election to follow 2 Tuesdays later.
Okay.
So to answer your question about, well, is this really that big of a deal? Let's walk through the language of the hand count rule. The hand count rule requires that 3 poll officers hand count all paper ballots that are fed through an optical scanning machine.
On election day?
Either on election day or...
Oh, I didn't ask that clearly. It's only the ballots that were cast on election day. It's not ballots that were cast through early voting or mail-in absentee ballots, all the different other categories of ballots. It would be hand counting the ballots that were cast on election day. They may be counted later than election day, but it's only that universe to be very popular, an increasingly small percentage of the total votes cast in any county.
So I think the answer is yes, although the Secretary of State has not given us guidance on this, but we read the rule as pertaining to the ballots that are cast on election day. Okay. So the first answer to your question is we think yes, though we would prefer that the Secretary of State give us that confirmation. And also to in some way address some of the numbers that were used by the respondent. I don't think that we can fairly use the election results of, say, 2020 during COVID as a very good indicator of what the election looked like. Ballot casting in that election was substantially higher as a result of COVID.
And 2022 wasn't a presidential election.
Exactly. So those statistics, while certainly they're true and public, they do not give clear indication of what the rate of in-person ballot or in-person voting would be. I actually think it would be better to look at, say, the 2016 presidential election, which the respondent did not address and which is not in the record. So what is the rule? What else does the rule require? Well, the first part of the rule states that these 3 poll officers must count, quote, separately, unquote, and, quote, into stacks of 50. Now, the rule is not clear as to how this count should be performed. Does the term separately mean that poll officers must count all 2,000 before the next poll officer counts and stack, each into 50? Because if that were the case, it would take a whole lot longer. The word independently is also used. So what is the difference between the requirement that the counting be performed separately and that the counting be performed independently? We also don't know those words and intended to create separation, to create independence among poll officers, but we don't really know what that means. Now, the count that officers was on a day when they had good sleep and hadn't worked for 15 hours was essentially taking a stack of 2,000 pieces of paper, sorting them into 50, handing them to the next poll officer, making sure those were 50, and they kept this count of stacks of 50 going on in probably the most efficient way possible. But we don't actually know if that would satisfy the state election board. We sure hope that if this rule were held valid, which we don't think it should, that we can count that way, because if we have to do it another way, where one poll officer has to do the whole count of whole 2,000 statements about each stack, et cetera, we just don't know. We haven't been trained, and certainly we have a lot of fear about, well, are we doing this right? And are we doing this consistently with other ways?
What would the administrative procedure be if this rule were passed in February of next year? Or it was effective February of next year. I'll be familiar with the mechanism. Does a local election board certify a question to the state election board? Is it the Secretary of State who bears the burden of coming up with the rules to implement the state election board's rule? I mean, who answers? Just take that one question. 3 different poll workers, you and I and Mr. Thomas, and then put them back together again, and then you count them all. It's a fair question, but how does that get answered? If this was February, we've got all the time in the world because the next election isn't forever.
Well, so as I understand it, and I'd welcome Mr. White to add to my answer, but as I understand it, in the normal course where, sufficient notice is provided, officer develops training materials and provides those training materials to superintendents. If there are, questions about how to do things, that's often the way it happens if there's not, significant legal questions.
But the training materials don't come from the state election board. They would issue the rule, and then the Secretary of State's staff would figure out what's the most practical way to implement this. In other words, what guidance would come from the Secretary of State to the local election board saying, here is how you separately and independently count.
Correct.
Okay.
That's one way. And that's typically how it's done. Secretary of State makes videos, poll officers doing things in the way that they're supposed to do, transmits those videos to election superintendents, if it's clear. Now, here, the Secretary of State has refused to do any training and has quoted the Attorney General's opinion that this rule is invalid. So we have no guidance, and we have not been able to obtain any information whatsoever from the Secretary of State.
I totally get it. I'm that way all the time.
That's the answer to my question is in a normal situation. I mean, separately and independently, if there was a question about what that means, there are other proceedings which could take place to get more clarity. Of course, election boards or the Secretary of State or the Attorney General's office could interact with the state election board to ask for clarification if there were more time, if we needed to understand those differences. But typically, the Secretary of State would lead the training process in advance of that office's responsibility to ensure an orderly election and ensure consistency among superintendents. Now, the state election code also grants, to some limited degree, discretion to the superintendent, meaning our local board, to deal with very, very specific issues. But usually we're talking highly, highly specific, because if you grant a superintendent too much discretion, then you have counties doing elections differently. And so, but what's remarkable about this rule is that it actually grants discretion not to the superintendent, but rather to individual precinct poll managers to decide when to do this count if there are more than 750 ballots. And so you have in Cobb County 148 precincts. And so there are 148 poll managers.
So a poll manager is a precinct manager.
Correct.
Okay.
That is exactly right. And under this rule, we have the concern that the superintendent, meaning my client, it doesn't even have the power to say, this is what we think this should be done on election night, or we think under these circumstances, you should do it on election night, or you should do it the next day. That power has purportedly been taken away by the state election board and then given to individual poll managers, not just the 148 in our county, but throughout the state. And they get to make decisions about when the hand count would take place, presumably regardless, decision about when is up to the poll manager or even assistant poll manager. So that is, as I'll explain in more detail later, totally contrary to the structure of the state election board and the structure of the authority to administer elections in its own county. Now, in addition to that, to the extent there are discrepancies between the counts by either individual, poll manager is required under this rule. Again, not the superintendent. An individual poll manager is required to, quote, immediately determine the reason for any inconsistency, quote, correct the inconsistency if possible, unquote, and then document any, quote, corrective measures taken. And so once again, we have a rule where, I mean, what does this mean? Like, what is an immediate determination? Or does the poll manager, I mean, what differences in what folks come up with? And I don't want to speculate on what could happen. It's just because hopefully this would be a very.
Don't know, but if we put it in the context of what this rule actually does, which is said simply count pieces of paper. They're important pieces of paper, and there are questions about whether people should even be handling them. But set that aside. The inconsistency would be, I counted 700, I counted 702. It's not an hey, that mark next to McBurney's name on the ballot, that doesn't look sufficient. And I know these aren't hand-filled out ballots, but inconsistencies don't involve what was the intent of the voter here or anything like that. It would be a numerical inconsistency. He counted 790, she counted 792, and they did it twice and they still don't match. So an example would be, I guess that poor poll manager has to then count them all. It's not clear. It's empowering people who maybe shouldn't have that authority. It is creating maybe in but one county, 148 different ways of doing things to resolve an inconsistency that can only be about the number of pieces of paper. So to help me appreciate the alarm about that, because the outcome would be, it sounds like a notation that would be transmitted to the superintendent. We can't tell if it's 790 or 792. There were more votes for McBurney than there were for Kaplan. And we just feel this looked like McBurney people coming into the precinct. And so we think
there's alarm. I think that the concern is that there has been no trainers or of our poll officers. We have never dealt with a situation before where poll managers suddenly have discretion like this. This is a new process that we have never. If a
poll manager wants to keep two machines broke down and the line is long, poll manager can't decide that. She has to get the superintendent to say it's okay, or that kind of authority. Is that a fair statement?
I think that's right.
Okay.
And so that's really, I mean, when we administer elections, obviously we take great pride in doing what we're required to do under the law, which is administer fair, accurate elections and consistent elections, consistent among our precincts and consistent among different superintendents. That is what the law requires. And we are in a situation where these requirements, while it's theoretically possible to satisfy them, we do not have the training that gives us the confidence that this is how it's supposed to be done, whether it's with respect to how the count is to take place or how, reconciliation should be done. And that is the problem that we face, is not that this is a bad idea, but that it is far too close to an election to be starting this process now. I mean, as their states, we started training last year. I mean, elections are very poll officers or I should say poll workers in Cobb County alone. That's because we have 148 precincts. And their training has been completed for the majority of our poll workers. And so to now have a new requirement that is unprecedented and that would take effect literally 2 weeks before an election, and we don't have the resources to do it, whether financial or the resources that we're used to having from the Secretary of State, who has declined, understandably, to provide any support to local superintendents or certainly to poll managers. And we're putting poll managers in a position, or this rule, I should say, for the first time, without guidance from either the Secretary of State or without guidance from our election board, and they got to figure it out. And they got to be concerned because, they're responsible for the actions of their poll workers and they're responsible for following the law, and they're, and our board is responsible for administering a good election. And so, certainly we would never start 2 weeks before an election to train on how to do that.
Okay.
Communication that was made by the Secretary of State's office, this was just about a couple of weeks ago, just after the rule was passed or adopted, I should say, on September 20th, the Secretary noted the Attorney General's comment that the rule amendment, this is speaking about the hand count, was, quote, not tethered to any statute, legislation that agencies cannot do. And they went on to say, because the SEB rules are tied up in litigation and because poll worker training in many counties has already started and there is limited time remaining for additional training, the SOS Elections Division does not intend to provide additional training on SEB rules until after any court decisions are made. And I point out that that's not just with respect to the hand count rule, but it's with respect to all rules. Of the view that rules should be passed 2 weeks before an election, and it simply declined to train on them due to its concern.
They were passed many more weeks before the election than two. They're going into effect 2 weeks before.
That's a fair correction, Your Honor. Yes. View under the APA, and I'm going to move to the Attorney General opinion because it really answers a lot of these questions. But whenever the court is considering the validity of a state agency rule, it really asks two questions. And two is the rule reasonable? And most of the case law concerns the first element because it's very important that the legislature, duly elected by the citizens of the state of Georgia, be the lawmaker in Georgia. And our divided government, it makes the law. And agencies in the executive branch, but that rulemaking has to be limited by what the legislature has expressly authorized. And there's a further reasonableness component that is required to ensure that agencies do not act unreasonably. And here, both of those requirements are implicated. We think because they're not authorized by state are being implemented. Now, the rulemaking by the state election board is limited by the state election board's enabling statute. That's OCGA 21-2-31, which really has two components regarding rulemaking. The first is to promulgate rules and regulations so as to obtain uniformity in the practices and proceedings of superintendents. So, and this is a duty of the state election board. So it's not just a grant of rulemaking power, it's a grant.
They identified three, two of which you don't need to spend any time talking about because they don't involve hand counting. They don't involve what's going on election day. They don't seem to have any, they'd be part of the untethered. But the third one didn't seem to be fully untethered. And so I want you to explain, if this is the direction you're going,
Yes.
I'm not trying to pull you off course. I introduced to the hearing earlier today. You don't need to convince me that the first two statutory bases are insufficient.
Understood.
But the third one, there did seem to be some hooks. So let's talk about that.
Sure. 13-4 that requires the citation of sources. And just to order the court around this, I mean, we are not here based upon our own legal analysis. We are here based because the Attorney General has publicly issued a memorandum that analyzes the validity of these rules and ultimately concluded that they are likely unlawful, at least the
Made in on 3 of the 6?
That's correct. The state election board, and I'm going to forward to these statutes, which are 436 and 21-2-420. And I think, Your Honor, I just want to make sure we're on the same page about which was section 483, which pertains to votes at a tabulation center. The Attorney General said this has nothing to do with hand counting.
I say it has nothing, also say it has nothing to do with hand counting.
And then the second one is OCGA 21-2-436, Attorney General ballots, which we don't even use anymore.
In most places.
As I understand, in all places.
Okay.
But yes, like we don't use stubs and, and certainly this rule also discusses what is absolutely zero to do with counting after removing ballots from a ballot box. So I think the statute that might have some relevance here, as the Attorney General also acknowledged, which does pertain to the accounting and related documentation. And so this is probably the only rule that has like some theoretical relevance reference in this rule to anything even remotely approach.
Well, isn't the debate going to be what required accounting means? And if the state election board concludes that required accounting is reconciling the count of ballots cast registered by the machine versus the actual receipts, then that would be required accounting. Election board add meaning to required accounting. Clearly, the statute's not referencing that. It would be referring to elsewhere in the election code, whatever accounting is required by the Georgia election code for poll officials in a precinct to complete. And they're picking up this new thing. And so the debate is really, can you add to it? And is that, and did they exceed their authority to say required accounting means that which is elsewhere in the election code, the things you've got to do, one, because this is their +1. And if they can add a +1, it seems like 420 supports it. But some of the reasons why some of the other rules seem to be problematic is that the legislature has said, here are the 4 things that you do. There's a list. And then the state election board said, well, here's a 5th. And there's pretty clear case law that says you don't get to add a 5th because we gave you 4. We didn't say, and anything else the state election board comes up with. It's these are the 4 things, whatever the number is. And the state election board is in effect through one of these other rules, adding a 5th. And that seems to be problematic. Here, the way I processed 420 is that if there's a hook, it's that the state election board is saying, here's what required accounting means. See wherever else there are instructions in the election code to poll officials, and then also add this hand count.
Yes, Your Honor. And first of all, I would just note that the chief legal officer of the state, the constitutional officer who has the authority and responsibility to determine that this statute does not authorize the state election board to create a new form of counting of ballots, that the hand counting of ballots is untethered to section 420.
And the Attorney General's opinion, I'm not remembering the format. Was it a letter or is it an actual Attorney General's opinion? So that if we're looking through official opinions, which also is it's not a court ruling, but there are different degrees of oomph that the Attorney General can put behind his word. It could be a letter, and you ought not to ignore it. It could be an opinion. They didn't do that. I'm just not remembering what got sent.
Sure. It is tab 9 and this was a memorandum dated September 19th of 2024. It is 6 pages. It was sent by the Attorney General's office to the chairman of the state board.
Okay.
And, you know, just to your Honor's point, I mean, going to the sort of unusual nature of this process and the lack of orderliness required by the enabling legislation office, I should say, notice on the very first page, the unusual nature of the request for a legal opinion in this matter. It's simply copied to determine whether or not the board has made a passing comment to see a particular topic, excuse me. And so, and ultimately the Attorney General decided to make a quote, limited exception to its usual practice for the election board meeting. Despite the very unusual nature in which this came to the Attorney General's office that was involved here, which is itself unusual, the Attorney General produced a very thoughtful and comprehensive 6-page analysis of at least 5 of the proposed rules and analysis addressing the likely illegality of the hand counting rule. But back to the question about 420, the Attorney General specifically addressed that and noted that it doesn't address the APA case law, HCA Health Services, as well as other case law within its memorandum that makes clear that an agency does not have the power to impose new conditions or new requirements where here, if you look at section 420, there are some very important features of this statute that, in our view, reflect an inconsistency, not only the absence of any authority, as the Attorney General noted, but actually an inconsistency with the hand counting rule. Subsection A of this statute requires that the chief manager, one assistant manager deliver a copy of tabulated results and then, quote, immediately deliver all required documentation and election materials to the election superintendent. It goes on to then require the election superintendent to ensure that such ballots are, quote, processed, counted, and tabulated as soon as possible and shall not cease such count and tabulation until all such ballots are counted and tabulated. This is a very clear expression by the legislature that ballots are to be delivered to the superintendent and counted as soon as possible, and that the counting cannot cease until it is complete. That is consistent with the way we have run elections for many years. We get the count done on election night by 11:59. We post the results, publicly, so that the post statistics. It is inconsistent to delegate to a individual poll manager.
Not immediate delivery. It's, hey, we'll get it to you when we're done with our work, whether it takes 14 minutes like Mr. Thomas forecasts, or much longer like some of your affiants forecast. Either way, that's not immediate. It's holding on to some things that A says you don't hold on to, and it's the superintendent. The word ballots is right there. That it's the superintendent who is ensuring that they are processed, counted, and tabulated.
That's right. An individual precinct level poll manager who's responsible for more than 750 ballots just wait till the next day and start a hand count then. That is totally inconsistent with the Georgia legislature's requirement that the counting not cease until it is completed. So it contradicts the legislative intent and the clear language of subsection A.
Do you want to talk about reasonableness more than you have?
Well, and the only other thing I'd say is subsection B says the same thing, Judge, that the superintendent is required. Again, our board is required to ensure that the number of ballots cast over the time of the closing of the polls in the last election vote. So there's a clear mandate to get this done as soon as possible. All right. To my co-counsel, Mr. Suss, on the issue of reasonableness and the Purcell rule, I think what I'll do is turn to the exact compliance requirement.
Okay, let's do that. That's fine.
So, as I said earlier, the court need not actually, these rules are expressly authorized by statute, whether the agency had the power, whether they are reasonable, because the agency failed to follow the law in the way that the agency, the state election board, I should say, gave only 30 days notice, just enough time on August 21st to post these 6 rules.
There case law that says exact means sometimes shall doesn't mean shall, and exact means kind of close, and some evidence means any evidence. And so I'm curious if there is a case that says the notice that was given by a board that was going to be adopting a rule said, today is just for comment, but instead they adopted, that was challenged, and an appellate court has said, that's not notice. More importantly, that's not exact compliance. And so the appropriate or an appropriate sanction is that rule is void or set aside or whatever the corrective action would be.
The answer to your question is we've looked and we haven't found a case exactly like that.
What's the closest?
The Walker versus Department of Transportation, which is 279 Georgia App 287, says, quote, "The failure to comply with these procedures will invalidate an amended rule." So it notes the exact compliance requirement. The outdoor advertising case, which is tab 21 of your binder, is 186 Georgia App 550, did hold that agency rule of the Department of Transportation was procedurally invalid because it held a hearing, or excuse me, it held a vote earlier than the 30 days required by the statute. But I don't think Your Honor really needs case law to determine the meaning of exact compliance. I mean, the statute is very clear. This is subsection D, and it says very clearly, no rule adopted after 1978 shall be valid unless adopted in exact compliance with subsection A. But in this statute, substantial compliance is enough for some of the other subsections. So I don't think the legislature could have been any clearer that the requirements of subsection A, which include not just 30 days notice, but the additional requirements that I'm going to discuss, and a statement of the agency's, quote, intended action, is an exact compliance requirement. I mean, action is also something that's easy to interpret in terms of its plain meaning. What act are you going to do 30 days from now?
But if the intention was to receive comments, and then there was just such an upswell of support for adopting the rule, hey, let's pivot. Everyone loves it, so now we're going to adopt it.
Well, that's not how the APA works, Your Honor. If no matter how much consensus there is, the agency is still required to give the public 30 days notice, because you can't be sure that you have everybody's opinion and you have properly notified. And this is because we're talking about agency rulemaking here. These are not elected representatives of individuals by either the executive branch or others who are essentially creating law, potentially. And so we need to ensure that the public is on notice of not only the fact that they're having a meeting, but what they plan to do at the meeting. And here, as the notice reflects, the only thing that the only action that the state election board notified the public that it would take at the September 20th meeting was comment upon and provide input into the proposed rule amendments. That was the purpose of the public hearing. And, you know, we're talking about a time when we're just a couple months before a presidential election. So I think a reasonable person reading this notice would think to themselves, okay, well, you know, the state election board is considering taking comments on these rules. It's interested in hearing what, you know, the public had that sentence, which I'll blow up a little bit more here, and realize that the action that the state election board intended to take at that September 20th meeting was to vote on the adoption of these rules. Many people may have not attended the meeting because they didn't really care to hear about the public comment. They may have said, I'll wait until, you know, they actually vote and I'll go then and hang a sign or do whatever they wish to do.
But the point is, you have a right to be there for the vote. It's not that there would be much interaction. It sounds like if proper procedure had been followed, and then there's a subsequent notice that says in 30 days, we're going to meet again and we'll be voting on it. That wouldn't be a time to be heard, as in you get a chance to walk up to the podium. You could wear your hat or hold your sign, but no one was given notice.
Or you could lobby lobby the agency, say, don't vote for it. There's a lot of, public comment is not the only thing you can do. The public has a lot of other opportunities at their disposal to express opposition to a vote if they knew it was taking place. If the mere purpose of this was to accept comment, people might not realize, hey, we got to get to work and convince the members of the election board, or, you know, write op-eds or whatever actions they might take.
Mr. Corey's sign on the smokestack.
Absolutely. So, you know, again, this doesn't require a lot, Your Honor, to just give effect to the legislative requirement that the state election board exactly comply with the requirement that it give the public notice of its intended action. It did not do that.
Okay. Any other procedural defects you want to
another very significant procedural defect, and also reflective of the very rushed other part of subsection A.
So I'm going to interrupt you because we had a good discussion about this at another hearing on similar topics. I thought this law says at some point you do need to provide a concise summary of the views that were expressed, but there's not a deadline for it. And so there's no case law saying you've got 30 days from the passage of the rule. Really, the trigger time was passage of the rule. It's not an infinite period of time. This seems pretty squishy to say it's been violated. Maybe today, technically, it hasn't been complied with because that summary is not yet done. We had been promised that that summary was about to come in other case. Isn't that true here too?
It is true.
Okay.
They also did not issue a statement of reasons or address the public comments. But I think that the two defects that I'm talking about here are—
Oh, this is different. What you put up on the screen is not— Oh, I'm sorry. I'll be quiet. Tell me about this.
Yeah, this is not in our brief, because in the rushed way that this whole proceeding has happened, in the rushed way that the state election board adopted this rule, we actually very recently discovered this problem, which is very significant.
Okay.
So the subsection A of the APA 50-13-4 also requires exact compliance with the synopsis requirement. This is what the notice looks like that goes to the public of rulemaking. And it contains a 3-part requirement of the synopsis. And of course, the synopsis is for the hand count rule is behind tab 2 of your binder. This is exhibit 2, notice of proposal. The second requirement is a description of the main features of the proposed rule. And then the final third requirement is in the case of a proposed amendatory rule, the synopsis shall also contain the differences between the existing rule and the proposed rule. So let's look at.
And most of these were amendatory. I don't know if I've ever used that word before. Were there a couple that were whole cloth new rules? Or they all were amendatory?
I believe they were all amended rule concern on the hand count rule.
Okay, it clearly was an amendment.
Yes, Your Honor. It was clearly an amendment as reflected in Exhibit 2. So this is the synopsis for the hand count rule. As you can see, it's titled Synopsis of the Proposed Rule of the State Election Board. Per element 1 of the APA, the first paragraph describes the purpose of the rule. We don't challenge that. The second paragraph describes the main features of the rule. We don't challenge that. The third and most important section describes, quote, the differences between the existing rule and the proposed amendments. And this is where we see this red line that purportedly reflects the changes that would be made by the rule that was under consideration. And you see even that there is a note that underlined text is proposed to be added, telling the public if the text is underlined, it's new. Meaning if it's not underlined, it's not new. Now, did the SEB get it right? The answer is no. There are significant differences between the amendment, the new rule, and the old rule that were not reflected in the red line set forth in the notice. I've counted actually 13 missing references. They failed to include any strike-through language, language that was removed from the original rule, not reflected in the notice. All of the red on the right side of this screen are differences between the old rule and the new rule that were not reflected in the statement of differences in the synopsis.
Is there a case law that says, oops, you know what, they need to get it close, but this was a typo, or
No.
This looks like a little bit more than a typo, but maybe they meant to put the word scanner in front of ballot box, and that was a technical omission?
There is not, and any such case law would probably be overruled by the Supreme Court because this is an exact compliance requirement. Again, subsection D distinguishes between what the state agency must exactly comply with and what it can substantially comply with. And you can't, sort of get the red line half right.
So that I understand this slide 28 on the screen, the box to the left that says P2, that is what's in the synopsis. If I were to look at the synopsis, which is plaintiff's exhibit 2, the underlining would be what the board told the public. This is what we're adding. This is part of the amendment. Everything that's underlined will be in the new version of the rule. So the box on the right, stuff that's red, if it's struck out, was supposed to be in there. In other words, they said the new rule will contain the phrase. No. Okay.
The stuff that's stricken was in the old rule, but deleted from the new rule. So in other words, if you look at.
That's not in the new, if I read the new rule now, it's not there.
That is language removed by the amendment that is not reflected in the differences.
Okay, got it. So if I were to look at the synopsis, it doesn't tell me that the new rule will get rid of that phrase and replace the paper, but the new rule actually did do that.
Correct. It just failed to include any strike-throughs at all.
Okay.
For whatever reason, performed as a part of this notice just didn't capture any deletions at all.
Okay. All right.
Including deletion and replacement of, in the bottom part of this, of the date and time that the ballot box was emptied, which exists in the original rule, and the replacement of that with hand count ballot total as certified by the 3 poll officials. If you look at the actual notice, you can see the language, hand count ballot total as certified by the 3 poll officials is not underlined as new language, even though that is new language.
Okay.
So they failed to even correctly reference what was being added. Any member of the public reading this notice would have a completely inaccurate understanding, an incomplete understanding, potentially have been misled by this rule. And that's actually important because if you read this notice, and this is what I did. I read this notice and I said, oh, really? The original rule had a reference to hand count ballot total as certified by the 3 poll officials. Because if that's true, we might not have a good case if that happened many years ago or many months ago or whatever. It turns out that's just new language that they failed to underline. And so it does not accurately reflect the differences. And if Your Honor would like, I mean, don't take our word for it. This is from the Secretary of State's website.
That seems so sloppy.
Current version of the rule before any amendment would take effect on October 22nd, and the court can perform its own analysis to ensure that we did it correctly. We had quite a number of people look at this, though, to make sure we were right because of how important it is.
From one perspective, you could be half right. If only half of what's read is properly read, meaning the color red, then it wasn't an exact synopsis of indicating what the differences would be.
I don't think I understand that.
It's okay.
Are you kind of pregnant?
Okay.
I appreciate the work that was done to highlight the number of omissions in the synopsis of differences in the amendatory language.
That's right. I mean, you can see just, the word scanner ballot box in the second sentence. That scanner word is not underlined, but that's new from the old rule to the new rule.
I got it.
And I count 13 edits that were not included in the red line.
Okay.
So, Your Honor, given the board's failure to not only tell the public that it would be voting on this rule, but its failure to even accurately reflect the differences as required by the APA, to which exact compliance is legislatively required, this rule need not even reach the question of the state election board's authority because it simply utterly failed to comply with the APA and its haste to adopt this rule. Now, as I said earlier, and this will be my final point, Your Honor, we've moved for an injunction, we've moved for a temporary restraining order because of where we stand. When the rule takes effect, we will be 2 weeks before an election. We stand here today 3 weeks before an election. As the Secretary of State has said, it is simply too late, far too late, in his words, for counties to implement new rules and procedures.
And even September 2nd
when many poll workers have already completed the required training. The Secretary of State noted that the hand count rule was the most concerning because of the tremendous personnel resources and time that would be required to comply with it, the significant delays in reporting that could result, and that it would disrupt existing chain of custody protocols, needlessly introduce the risk of error, lost ballots, or even fraud. These were all comments by the chief ultimately deciding not to even train any of our 2,000 poll workers on this rule due to their view that the rules was invalid. This concern has been substantiated by the workers in our the election administration within Cobb County. We've introduced the testimony of Chairwoman Silas, and I'll go through this somewhat quickly because I've already referenced it on a few occasions. But in Cobb County, application of this rule would involve at least 444 poll workers because we have 148 precincts. And so we would have to train at least 444 poll workers on the hand count rule when we have no training materials, we have no support from the Secretary of State. And keep in mind that that training isn't just about how to count, but also how a poll manager might decide how to address any inconsistencies or how they might decide whether to count the night of the election when poll workers have been working from 7 in the morning, or often 6 in the morning, through the close of the polls, a 15-hour day. Ms. Silas notes that this kind of hand counting could also delay the reporting of the results since we would be taking resources from one area, putting it to another. We will have to incur additional costs that we did not budget for in our annual budgeting that took place, last year. And certainly we have the concern that our poll workers may not be, may just be exhausted after a very long workday. And
even the worst
counting in those circumstances on election night after you work for 15 hours is just not the best way to do it. It introduces the risk of error. It's more likely that a count would go much longer than we estimated because of the exhaustion of our poll workers and the fact that some of them aren't going to have at all been trained. Some of them will have only, could not be as experienced as the ones who did our sample. We've also received mail from members of the public that have gotten misinformation, as the court addressed earlier. People have warned, representatives of our office, poll workers, that they better comply with this hand count rule. We'll be watching. The intimidation has already begun and is only going to continue. This is going to require security. There's also,
But that pressure would exist if this rule had been passed 6 months ago and there were operating instructions in place. People get energized about elections and say things that are intimidating. I don't mean to minimize this concern at all, but I don't put that at the feet of the state election board or even the timing of the rule. Had this been passed at a more reasonable juncture, maybe with more care put into it so that we didn't have all these discrepancies in the synopsis of differences. And so the Secretary of State could have pushed out training, et cetera. There's still going to be people who say, I'm going to pull up with my pickup truck with the flags on it, and I'm going to make sure you hand count correctly. And if you don't, there's going to be trouble. I don't think it's fair to put that at the feet of the rule or the state election board. That goes at the feet of polarization in our community.
I understand, Your Honor, and totally agree. We're not blaming the state election board for any acts of intimidation. What we're saying is that because we have so little time to prepare, that we are suffering irreparable harm because we have uncertainty about what we have to do. And if this rule is going to come into account, we're going to have to pay more security officers. We're going to have to make decisions about where the countings will take place, how to provide public access, which is required by the rule, what security measures need to be taken in light of the polarization. And so because of the polarization,
it amplifies and magnifies the cost.
Right. And it suggests that a reasonable rule would have, like this, would have been implemented far more in advance of the election than
that's what we're calling
2 weeks,
them now,
so that we can deal with the added risks and concerns that our current political environment creates.
Okay.
Obviously, the rushed nature of this also could create questions, and voter confidence and lead to disinformation and distrust, as the court has already noted. And so all of these issues constitute the irreparable harm that we as a superintendent, we as an election board are suffering and will suffer, implemented or takes effect in 1 week. And for that reason, Your Honor, we request that the court enter a TRO or an interlocutory injunction. The court would be, of course, well within its power to do so today, while considering the broader issue of a declaratory judgment with respect to the validity of the hand count rule and frankly all 6 rules. And we ask that it do so that our poll workers, our elections director can focus their resources on training for this election without having the concern that they might have to really change all their plans and suddenly try to train and add resources and staff and try to address this hand count requirement.
All right. Thank you.
Thank you.
So I need to give our court reporter a break in a moment, and probably everyone else. We're approaching noon. I've got a little more time than I thought, so we're certainly going to hear from both sides. But I'd like to get a sense if there's much more from plaintiff's side. I know you had said Mr. Suss was going to cover some things, and yet you talked about them as well in some ways. And certainly we have interveners. A lot of what they've had to say that I've processed is consistent with, but I don't want to keep anyone silent. Mr. Suss, give me a summary of what you were going to cover, not substantively, but just going to talk about A, B, and B.
Sure, Your Honor. So I'm just going to be talking about the sort of cross-cutting arguments that apply to all 6 rules, not just the hand count rule. So the notice deficiency would be one of those issues. In addition, the question of whether all 6 of the rules are consistent with the SEB's rulemaking authority, which is limited to rules that are fair, orderly, and promote uniformity in elections. Also, whether each rule is reasonable under the APA. And that sounds like a lot of issues, but there's a lot of overlap between those issues.
Sure, and I think we've covered notice pretty thoroughly, so I wouldn't think there'd be a lot to add.
No.
Okay.
Rules, including the poll watcher rule and the daily reporting rule, which are 2 rules that were addressed in the Attorney General's memo.
Okay, thank you. And for our interveners on plaintiff's side, Mr. Varghese?
We intend to be very brief, Your Honor. Supplement. We intend to be very.
I know I heard that part, and you're being brief in talking about what?
We want to supplement evidence of additional irreparable harm that's been offered by the BRE petitioners and other exact compliance citations that if Mr. Suss doesn't cover, we can provide to the court.
Okay.
We want to move Suss T on the record.
He wants to cover additional
Are your
evidence
exhibits
of
something Mr.
irreparable
Thomas has
harm
seen
done.
He has, Your Honor.
Before this morning?
Correct. He
Okay.
received them Sunday.
Judge is getting an. I think they're just like amici, right? Interveners.
Got it. Okay. Why don't we do this? Let's take a quick break. And during the break, think about compression. And I'll hear from the rest. Pivot and Mr. Thomas, you and everyone else, and Mr. Kaufman, if wrote it.
So they're not back yet. So we've caught up. Thank you. I think it is. I'm guessing. I'm sure there's legaler minds.
Because I'd love for Michelle to
Legaler minds are in the room.
He's gone.
I know.
Okay. I mean, you think it's today? It's this week?
So this is interesting. I did not know this was happening.
So it might not be told, and they don't need to do
knows,
something
nobody
crazy. Like just get them out now.
Like a reminder.
Yeah.
I would ring
So
their
it'll be
bell and turn them down a little bit. I'm sorry it's so warbly, and there is no captions. I just really apologize, but here we are. And I'm basically checking some of the news. The other piece is that Gal had dropped a link earlier. I don't know if it's still up there, but it's a justsecurity.org, justsecurity.org. Great website. Highly recommend it. Lots of good media literacy, good source information, nice summaries of everything and all that kind of stuff. So I highly recommend that. But let me give you this because it's one of the latest. Oh, shoot. I didn't want to do that. Undo.
You're a realist. All right.
Okay. So I will copy that. And then I will do that. And then I will do this. Okay, here we go. justsecurity.org. So I haven't read this yet, but it looks like it's kind of interesting. And that website, boy, I sure recommend it. I'm sure everyone here probably already knew about it, of course. But if you didn't, that's a great website for all this stuff. So yeah. Let's see. It's Tuesday. I don't know what else is happening this week. Is there gonna be a debate? I'm so confused because there's some kind of placeholder, and I created one, but there's a real placeholder like on ABC News or something like that for a debate, or CNN. I can't remember. No, Fox. I don't remember. Anyway, no, CNN. Another debate, or didn't he say no? I thought it was like on the 23rd or something like that. They should not be able to adopt. This is the thing. I know butterflies, and the thing I guess that we should like about this judge is that he does seem to ask questions and challenge people's stance, and in a pretty equitable fashion. Sometimes to a fault. That's how we got where we were with Fonnie Willis and whatever that thing. But I appreciate actually that he puts the state or the county in this case on the spot. This is the Cobb County recorder, kind of county clerk, if you will, equivalent, however they call it, registration and election for Cobb County. And so they're basically saying, fuck you and your rules, state election board. We can't do that 2 weeks before the election, because I guess not only did they decide this on September 2nd, the state election board, these are new rules. We watched some of that. I'm, live. And not only did they pass them September 2nd, they seem to have, I believe, now this seems like a poison pill to me. They seem to have said that these rules are in effect 2 weeks prior to the election, which must hamstring the county recorders or whatever, those responsible for running the elections. That it must hamstring them in some way to have something take effect 2 weeks before the election. I don't know. Clearly, in this case, it's already been done. That the Secretary of State or whoever was the support, forgive me for not now remembering like what was said a minute ago, that they said we will not provide new training until the court rules, you know, and or they whatever. So I feel like that's really see, that feels like a poison pill, like you're setting someone up for failure. Kind of like agreeing to let 5,000 Taliban prisoners go and not empower the Afghan government that we selected to actually succeed in holding that holding a democracy, or holding it together, or however you view the situation in Afghanistan prior to what, you know, whatever. So you know, I'm sorry. Hold on. I just want, okay, no, I'm not going to sneeze anymore. Sorry about that. So it's fascinating to me, actually, that we find ourselves where we are. And we've got the pasta sauce commercial playing on stage with Crispy Gnome. I love that name. Who gave her that name? Thank you very much, Butterflies. I feel better now. Yeah, I don't know. You know, in terms of like setting up these rules, I think it was really hard to watch the state election board be so smug about, you know, setting them up. It's almost like when Roe was overturned and it was kind of like, well, the states have it now. You know, that's what everybody wants. It was kind of that kind of attitude. Like, we didn't do it. We didn't break glass. You know, we didn't do that. What do you mean? We're just over here trying to, you know, be Republicans. I don't know if I will ever get over the fact that seemingly thinking people in the Republican Party decided that the best option for them was to go along with a big verifiable lie. Hi, Paul J. How are you, darling? So it's kind of odd to me that we find ourselves here. Like, how are relatively probably normal people so deeply invested in a lie that can be proven, that has no evidence? How do you just kind of sign on to that and then just like completely let go? Because you have to let go, because this is almost 5 years now after the fact. That's so crazy. That's so crazy to me. Oh, let me make sure these guys are turned up. I'm so sorry. I think they're just practicing, but yeah, they're not totally back yet. I don't know what's going on with that screen. I mean, it's on whatever. I guess so, Butterflies, but man, it just seems like an awful lot of people are completely, deeply invested, and they don't actually have that much power, I guess, or they do, but it's not a forever power or something. And they're probably not billionaires. They might be a millionaire or something like that. So it's not that they, I mean, I guess I think about the Murdoch trial, the guy in Georgia, or no, South Carolina. Oh God, I think it's South Carolina. Forgive me for not remembering. Where his family basically ran the legal system, the judicial system in the state. Oh no. Oh, I'm glad you've been around, Paul J. I'm so sorry you've not been well. Oh, good for you. Every day. Every day. I'm glad you're back. And I'm glad you've been lurking. Please lurk whenever you need to. You're always welcome. There's always a seat saved. I wonder how many election lawsuits are ongoing now and backed by Trump's people. You know, I think we can find that actually. I think there's a tracker. Hold on, let me see. I think Democracy Docket. I think Democracy Docket has one. Oh, Just Security actually might have one. Yes. Oh, no, wait. No, I think it's Democracy Docket. But I've seen one. Oh, meow. Okay. Oh, actually, I'm going to put this link in there. Butterflies are free. That's right. You're only human. And that's exactly the place you need to be, is being human. Let's see. This is the current challenges on Democracy Docket. Oh.
Right.
Okay. There is the link to the Democracy Docket current cases.
You ready?
Yes, Your Honor.
I wasn't asking you, sorry.
Oh, sorry.
Court reporter. Just asking the important person.
Boop, boop, boop.
You were standing up there, so it was kind of obvious you were ready. Okay, let's get back on the record in Cobb County Board of Elections and Registration versus the State Election Board. We're going to hear a little bit more from some of the spokespersons for people whose interests are aligned with plaintiffs, and then we will pivot to Mr. Thomas and the defendant. Mr. Suss.
This, but I did want to emphasize that the argument with respect to the deficient notice and the notice of proposed rulemaking applies to all 6 rules.
Let me ask about that. So all 6 were adopted at the same time?
Correct, Your Honor.
So the notice that says all we're going to do is receive comment and discuss would be for all 6. And
Oops.
yet all 6 on that date,
Judicial
September, whatever it was, were adopted.
ASMR.
It wasn't just comment on, it was comment on, thanks, nice to hear from you. Now we pass all 6.
That's correct, Your Honor.
There were other arguments about the deficiency of the notice. I guess it was the synopsis that accompanied. As for the hand count rule, are there similar issues with any of the other 5 rules?
There are not.
Okay, so the notice deficiency for the other 5 is solely, you said on date X, we're doing Y,
Screen
but you did
res
Y
is
and
as good as
Z.
it gets.
And Z was pretty darn substantive,
It's
and
crazy.
that's a notice deficiency.
That's correct, Your Honor.
Okay.
And just to sort of give some additional context here, there was, since this summer, the SEB has proposed a flurry of new rules, and that even those who closely track Georgia election law had trouble keeping up with. At the September meeting alone, the board was considering 11 proposed rules. So members of the public
When you
rightly-
say considering, they were discussing, or was there also a notice that said, these 6, all we're going to do is talk about them, but these 5, it's vote day?
So for all 6, all notices of proposed rulemaking for all 6 rules had the same boilerplate language, and it said that they would vote to, or sorry, my mistake, that they would hear public comment on the
Right.
rules.
But it's telling if there were also notices issued that said on September 20, what was the date? September 20th?
September 20th.
September 20th, we're going to actually vote on these other rules. That would show that they knew the difference between voting and discussing. Were there proposals for which the notice said, today we vote?
No, Your Honor.
Everything was discuss.
That's correct, Your Honor. For all 11 proposed
Right.
rules that were, that public comment was heard on September 20th, it had the same boilerplate language with respect to the board hearing public comment on the rules, and none of the notices said that they would vote to adopt rules.
Have you ever seen a notice from this state election board, this composition of 5, that said, here's notice, today we will consider whether to adopt?
So, Your Honor, I have not seen that from the state election board, but I have seen it from other agencies in the state who clearly do know how to say that they are going to vote to adopt a rule at a particular meeting. And we cite at least one of those examples in our TRO motion. So it is clearly possible to do this, and other agencies know how to do this. But to answer your question, no, we do not have an example of the SEB specifically doing that.
Okay.
So, Your Honor, other than to note that procedural deficiency applies to all the rules. Just next move on to the second point, which is that all 6 rules are also invalid because their last-minute timing is not conducive to fair, orderly, and uniform election administration. And this is sort of one possible hook for importing a sort of Purcell principle in this context. The SCB only has statutory authority to adopt rules that will promote uniformity in election administration and that are conducive to fair, legal, and orderly elections. Adopting election rules that would go into effect on October 22nd after early voting has started and just 2 weeks from election day is not orderly, it's not fair, and it won't lead to uniform.
Okay, just stopping to read this. Oh boy, thank you, Teresa. Breaking news, Will Staken on Twitter. New House Ethics Committee has subpoenaed documents from the lawsuit brought by Matt Gaetz's friend. Docs include a deposition of the woman Gaetz allegedly had sex with when she was a minor, deposition from a woman who was a witness in a Department of Justice probe, and Gaetz's ex-girlfriend's affidavit. Poor McForehead. Poor baby McForehead. ABC News is reporting. Hold on. As part of its ongoing investigation into Rep. Matt Gaetz, the House Ethics Committee recently issued a subpoena for documents from a civil lawsuit brought by one of the Florida congressman's longtime friends against several third parties, ABC News has learned. The subpoena, which has not been previously reported, requests all documents related to Gaetz that are part of a lawsuit brought last year by Gaetz's longtime friend, permanent Florida lobbyist Chris Dorworth, who was alleged he was defamed by several third parties over the course of the years-long sex trafficking probe into Gaetz, sources told ABC News. Oh, gal. The documents from the lawsuit, which include witness depositions and affidavits, could provide Congress with new details regarding allegations that have dragged Gaetz for years, including the allegation that he had sex with a minor who was introduced to him by by his one-time friend, Joel Greenberg, who pled guilty to sex trafficking and is serving an 11-year prison sentence. Gaetz has long denied any wrongdoing. Last year, following a year-long investigation, the Justice Department declined to bring any charges against the congressman. Last week, Gaetz stated that he would no longer voluntarily participate in the House ethics probe, which he blasted as a political payback exercise, and said that he had recently learned that the committee had issued, but not yet served him, a subpoena for his testimony. The Florida congressman also reiterated his denial that he had ever had sex with a minor. Quote, your correspondence of September 4th asks whether I have engaged in sexual activity with any individual under 18. The answer to this question is unequivocally no. You can apply this response to every version of this question in every forum, Gaetz said in a statement to the committee posted on social media. Members of the House Ethics Committee declined to comment to ABC News. Representatives for Gaetz did not respond to a request for comment. When reached for comment, Greenberg's attorney, Fritz Scheller, told ABC News, quote, while I'm reluctant to comment on a pending congressional investigation, Joel Greenberg's position remains the same. He will fully cooperate with all congressional inquiries, whether by subpoena or not. And regardless of whether the cooperation occurs in the rain or on a train, with a fox or in a box. Yes, Mr. Greenberg will fully cooperate here or there. He will cooperate anywhere. I don't even know what's going on. I don't even know what's happening right now. Among the documents related to the civil lawsuit, according to court filings, is the deposition of the woman. Okay, we read that. The documents Congress is seeking stem from a lawsuit brought by Dorworth, who alleged that the one-time minor identified in the lawsuit only as A.B. and others, including Greenberg and his family, worked to defame him amid the Justice Department's probe. Gaetz, who was not a party in the suit, was scheduled to sit for his own deposition as a witness in the lawsuit prior to Dorworth dropping the suit in early September. Dorworth has a separate ongoing defamation lawsuit against the Greenbergs in state court. It is unclear if and what documents have been handed over to Congress, and while many of the lawsuit's documents, including depositions and sworn statements, remain sealed, recent public court filings shed some light on what alleged details could be included in the underlying documents requested by Congress. One filing, Exhibit 23, in a motion for attorneys' fees filed by attorneys representing the Greenbergs, details some of the allegations made during discovery in the lawsuit, including that GAETZ was allegedly among the guests at a July 2017 party that AB, who was 17 years old at the time, also attended. The filing states that according to a woman who attended the party, there was, quote, alcohol, cocaine, ecstasy, also known as Molly, and marijuana present, and that there was access to the bedrooms for sexual activities, and that AB was seen naked at the gathering. In July, the House Ethics Committee released a rare statement updating the status of its probe into GAETZ. The committee stated that it had stopped looking into certain claims, including whether the Florida congressman misused state identification records or accepted a bribe or improper gratuity, but that its investigation had found that other allegations, quote, merit continued review. The committee said that it would continue to review claims that GAETZ, quote, engaged in sexual misconduct and illicit drug use, and that he sought to obstruct government investigations of his conduct. Ooh, hoo, hoo. Hoo-hoo. In GAETZ's statement last week regarding the committee probe, he reiterated his denial of any wrongdoing while seemingly responding to a string of questions the committee issued to him earlier in the month. In response to whether or not he had ever used illicit drugs, GAETZ stated, quote, I have not used drugs which are illegal, absent some law allowing use in a jurisdiction of the United States. I have not used illicit drugs, which I consider to be drugs unlawful for medical or over-the-counter use everywhere in the United States. Wow. I'm going to go ahead and copy that and drop it like it's hot. I want to see this. The frat pack. Oh, I remember this. Oh my God. 2021, December 1st, 2021. Chris Dorworth is special. Can't wait. Let me know when you're ready for Ballard Partners. Oh, shit. Oh, shit. Conspiracy, money laundering, stalking, bribery, public corruption. Oh, wow. What? Oh boy. Oh boy. Wait, hold on. Let me go to this one. Then we're going to go back to the trial. We're going to go back. Don't tase me. Okay. Greenberg's victim's attorney. Dorworth has a history of hiring local provocateur, referring to blogger Jacob Angles. Emails cited an unrelated defamation suit against Angles, which the attorney claimed Chris Dorworth was the financier of the alleged defamation by WFTV. Wait.
Questioned Joel Greenberg about his charges for stalking last summer. We knew the case involved social media posts about a political opponent seeking to unseat him as tax collector.
People have been talking to you about your social media etiquette for a long time.
We later learned Greenberg's fingerprints were found on a letter sent to Trinity Prep, falsely accusing one of its teachers, candidate Brian Butte, of an inappropriate relationship with a student. Now, emails from that victim's attorney at the very beginning of the investigation, dating back to the fall of 2019, are describing a possible coordinated effort to smear his client's name. Attorney David Baer noted he believed it involved Chris Dorworth, Joel Greenberg, or Jacob Angles. Laying out this background. Before Butte ever sought Greenberg's position, he was a leader of Save Rural Seminole, a group that was successful in blocking a proposed development in the county's rural boundary known as Rivercross. The developer behind that effort is former state lawmaker Chris Dorworth, a friend of Greenberg's. Butte's attorney claimed Dorworth has a history of hiring a local provocateur, blogger Jacob Angles, even citing an unrelated defamation lawsuit against Angles, in which the attorney claimed Dorworth was the financer of the alleged defamation, something Dorworth denied in an email to 9 Investigates today.
Creepy candidate Brian Butte.
Ingalls runs the Central Florida Post and made Facebook Live videos about Butte days before Greenberg's arrest, when no one would have known that there was an investigation except for the people involved. Butte's attorney told deputies that months before Trinity Prep leaders received accusations against Butte, Jacob Ingalls sent an email about Butte's opposition to Dorworth's development, accusing the teacher of leading a pro-segregation group and describing the county's rural boundary as racist. Ingalls' ties to Greenberg go back to the very beginning. Days before the 2016 primary that would secure Greenberg's position as tax collector, longtime incumbent Ray Valdez knocked Ingalls' phone to the ground at an event in Altamont Springs, a scuffle some speculated was a coordinated effort to help Greenberg win.
Oh. Wow. Is Jacob hiding? Is he hiding? Oh, you got your ballot. Fan-fucking-tastic. All right, let me go back. I'm so sorry. Let me go ahead and put that away. Oh, my goodness. Okay, I'm going to have to speed these guys up a little bit, but, you know, just a little tiny bit. Okay, here we go.
It will do the opposite. Both the Attorney General and the Secretary of State made that exact point to the SED before it adopted these rules. And they correctly cited the U.S. Supreme Court's decision in Purcell, not because Purcell binds state courts, but because it's just common sense. Changing the rules this close to an election is unfair to election officials and the workers who will be blamed for any disruptions. It's disorderly, and it will promote non-uniformity across the state's 159 counties, especially since the Secretary of State has said that he is not providing any statewide guidance on any of these rules pending litigation. As the 11th Circuit recently held in a case applying Purcell, changing election rules at the last minute generates election administrator confusion, and it undermines the state's interest in running an orderly, efficient election. And notably, that case applied Purcell to an action taken more than 3 months away from a municipal election. Purcell itself involved a Court of Appeals order that was issued a month away from an election. And yet here, these rules are 14 days away, will take effect 14 days away from the election. So if there is a Purcell window, we are in the red zone right now. And in the words of the Secretary of State, changing the rules this late in the game is, quote, absurd. Because the SEB's last-minute rule changes will cause disorder, unfairness, and non-uniformity, they exceed the SEB's rulemaking authority. And under the APA, any rule that exceeds the scope of or is inconsistent with statutory rulemaking authority is invalid.
When you say exceed seems like the wrong verb. I understand the requirement is that there be a statutory basis, that the rules have to be authorized. We're going to talk about it a little bit, but you were focused on reasonableness, and there's no authority to issue a rule that's unreasonable. That would hit that tripwire. But it sounds like the main concern you're articulating is not so much the substance of the rules being unreasonable. Every poll worker has to do 100 push-ups before starting the day. It's the timing makes it unreasonable, sort of situational unreasonableness. So again, my example, if these had been adopted with notice in February of 2024, so that the Secretary of State would have had time, so Cobb County would have had time, because they don't train their poll workers a week before, but they train them months before, and this could have been baked into the training.
That's exactly right, Your Honor. I mean, rules that would otherwise be unobjectionable become objectionable when you adopt them so close to the election. So that sort of principle applies to all of the rules. And Your Honor focused on exceeding the scope. I would also highlight the inconsistent with. That language is also important here because the statute requires that the rules be, that the board's rules promote a fair and orderly election administration. So relatedly, this is sort of another potential hook for the Purcell-like argument, is that the rules are unreasonable due to their belated timing. The Court of Appeals has held that the test of a rule's reasonableness in the industry it regulates, and the court has further explained that a reasonableness analysis must consider the degree to which the rule advances the purposes of its enabling legislation. Here, the rulemaking record, the notice and comment record, was
Is there a specific case you had in mind when you were saying that?
Yes, Your Honor. It's Georgia Oilman Association versus Department of Revenue, and the site is 261 Georgia Appellate Court 393.
Okay.
And so here, Your Honor, the rulemaking record was replete with evidence of the immense burdens, disorder, and confusion to election officials and workers that would result from these new rules and adopting them so close to the election.
What's your response to Mr. Thomas? He would take issue, I don't mean to speak for him, with that adjective immense. Certainly a rule imposes burdens. Now you have to count these of, we're going to be here until 1 minute before that week plus a few days deadline to even certify. Counting these things is going to be an endless Herculean task. 14 minutes, 22 minutes. What's the immensity, or do you want to use a different adjective than immense? It's a burden, but
the immensity is not just the hand counting, it is preparing for the hand counting. It is training for the hand counting. It is staffing. This report, the Silas affidavit, I'm sort of straying outside of what I said I would talk about, but the Silas, right. The Silas affidavit lays out how the rule and preparing for the rule concretely impacts the Cobb County Board and the preparations for the election. So even if theoretically under perfectly controlled conditions, hand counting might take a certain amount of time, you have to factor into place both what rush into place with inadequate opportunity for training and inadequate guidance, or a total lack of guidance rather, from the state's chief election official. Okay. And so this reasonableness prong, Your Honor, is simply another sort of hook for that argument. Those are all of our global challenges, and I'd just like to briefly address two specific rules, the poll watcher rule and the daily reporting rule. So the poll watcher rule is based on Georgia Code section 21.2.408C. That statute identifies 3 areas in tabulating centers where poll watchers shall be permitted. It says the check-in area, the computer room, and the duplication area. The statute otherwise gives county superintendents discretion to grant poll watcher access to such other areas as the superintendent may deem necessary. Now, the prior poll watcher rule just tracked that statutory language pretty much verbatim. But what the new rule does is it inserts new text in the middle of the clause that gives the superintendent discretion, and you can see it up here on the screen, Your Honor. The highlighted language covers the area where it gives the superintendent discretion in the last clause and such other areas. And then we have all this new text that's inserted before the phrase "as the superintendent may deem necessary." And so the Attorney General, the Attorney General's office, opined that the rule goes beyond the statutorily designated list of places that supplants the superintendent's discretion with the SCB's own, and the Attorney General concluded that the rule, if adopted, would very likely be subject to legal challenge as invalid. Now, our position is that there's actually 2 ways to read this rule. One is sort of in line with the Attorney General's interpretation, that it expands the designated areas where poll watchers must be allowed in tabulating centers. If the court accepts that reading, then the rule does conflict with the election code and it should be declared invalid. But another way to read it is that it simply specifies additional areas that the superintendent may allow poll watchers. And if that is the reading that is accepted, then the rule doesn't really do anything. It's more advisory than actually binding.
All these things you could do, you can still do. We just gave you some other ideas to think about as you're pondering where would you let people be.
That's exactly right. And we would submit that that's probably the better reading of the rule. But importantly, Your Honor, if the court reads the rules effectively doing nothing, it should provide declaratory relief to that effect, because otherwise there's going to be uncertainty and insecurity with respect to the meaning of this rule. And there could be confusion on election day about where poll watchers are permitted, and that could lead to disorder and security concerns. In addition, the mere existence of the Attorney General's memorandum also creates uncertainty and insecurity with respect to petitioners' legal duties potentially under the election code versus the SCB's rules. And finally, Your Honor, just briefly on the daily reporting rule. So this rule does impose new obligations, but they are not a major departure from the statutory obligations. So the Cobb County Board is not opposed in principle to this rule. But again, the issue is that the Attorney General has specifically opined that this rule is likely invalid because it, quote, seeks to go beyond the statute to require, among other expansions, additional information regarding the substance of the ballots, i.e. the number of political party or nonpartisan ballots cast. So given the Attorney General's opinion, we need to know whether the rule is valid or not in order to carry out the election.
My read was that this was a whole new rule. I had asked Mr. Kaplan, was everything a mandatory, or was there one? I couldn't remember which one from my prep for today. Is not the daily report, that's brand new, whole cloth. There was no 0.21.
That's correct. This is the only new rule of the 6.
That doesn't change anything other than that you couldn't run afoul of having a bad synopsis of what the differences are, because the whole thing is new.
That's right.
Okay. So to distill your argument, one, it would be invalid because the General Assembly already said, here's what you have to report. Sort of like me saying you have to do these 4 things. And this rule says, well, now you have to do number 5. And the General Assembly knows how to add things if it wants to, knows how to add the power to sue if you're going to sue. And it didn't include this. And the State Board doesn't have the authority to expand the legislation by adding this additional reporting requirement.
So, Your Honor, just
am I missing?
Well, just to be clear, the Cobb County Board's position with respect to this rule is that it's procedurally invalid, and it is invalid because it's outside of the scope or inconsistent with the board's rulemaking authority due to the late timing. We do not take a position on the statutory authorization issue offered by the Attorney General. And so that does create legal uncertainty for the board. And so we leave it to Your Honor to resolve that. However, other than the procedural and timing challenges that we raise, we do not raise a specific substantive challenge to the authorization for this rule.
Okay.
Sometimes that was.
And so for all those reasons, Your Honor, we respectfully request that the court declare all 6 SCB rules invalid and permanently enjoin their enforcement.
Thank you, sir.
Sorry.
You were succinct.
Yeah,
The bar's been set. Who's next?
I see you. That's right. We
I
got
think
this.
from the Cobb Election
got
Board, Your
this.
Honor, that's all we.
Oh, I get that. I mean, I will circle back when, as the plaintiff, if you've got concluding remarks, we'll pivot back to you after we hear from the defendants. But I'm ready for whoever wants to say something on behalf of the plaintiff interveners.
Yeah.
You want to stand up yet again?
Good morning, Your Honor, or afternoon. I will try to match Mr. Suss's succinctness, and I'm sure the court will tell me to move along if I'm failing to do so. So just a few points that I want to make. First, as an initial matter, we want to move to admit certain exhibits. And these are exhibits. Some of our exhibits are also on Cobb's list. These are the exhibits that are not overlapping, and that's intervener petitioners 5, 6, 9, 10, 11, 12, 15, 17, 20, 21, 22, and 23.
Mr. Thomas, any objection to, I know you've objected to intervention just on a timing basis, but here's the result. He's talking now. Any objection to these exhibits coming in as part of the record?
No.
Thank you. They're in.
Thank you, Your Honor.
And Ms. Niles has them already. I guess you said that because that's how you also got them to Mr. Thomas and his team.
We got them to Mr. Thomas before we sent them to Ms. Niles, but she has them as well.
Okay.
And part of an effort to be succinct, we filed a petition. We've also filed emergency motion for preliminary injunctions. Our arguments more fully fleshed out there. We're also adopting Cobb's motion for TRO as well.
Okay,
A couple of initial points. The capacity to sue argument does not apply to the intervener petitioners. And so this case can move forward regardless of how the court decides that decision. I really want to just focus primarily on the conflict and the irreparable harm.
Oh, hat tip to Risa. Thank you, Gal.
If this rule goes into effect.
Also,
and so
Fifth Circuit panel lets Texas
spoken very well for their
ban
interests,
on so-called
but this
vote
interest is
harvesting
statewide,
in
as evidenced
November
by the
elections.
statements of the Secretary of State, as evidenced by the statements of Gabriel, the Georgia Association of Voter Registration Election Officials, and as evidenced by the BRE petitioners that I represent. And all of them are concerned about the impact of this rule. It would be one thing in an ideal sterile environment to have 3 people who are fresh and energized sit down and count ballots. And I think that's what Cobb attempted to do, and they got a certain number. But as Mr. Kaplan recognized, that's not how this is going to play out in reality. As our petitioner affidavits reference, poll workers get to their polls as early as 5 a.m., 5:30, 6 a.m. They stay as late as 8 p.m., 10 p.m. And so we're talking about adding something on top of an already 14 to 16-hour day when people are exhausted.
Unless you decide to do it the next day.
Unless you decide to do it the next day, but then there are challenges that come with that as well, Your Honor. So you've got the poll workers who typically sign on to work one day at a poll location, maybe near their house, maybe not, now being asked to come to a county office, which in Fulton could be, an hour from Johns Creek without traffic. And so they've got to be there the next day. The county has to figure out how they're going to implement the count the next day because the count has to be observable by the public. And so in Fulton, for example, 481 precincts, there's no way that Fulton County, in its main office and its tabulation center, is going to be able to facilitate a simultaneous count. So it most likely happens in phases, right? And so, and at the same time, I think it's important to recognize the BRE isn't sitting around waiting to get to Tuesday this year and vote to certify. They have a number of other tasks that they're performing at this exact same time.
Do you agree that the tasks that the board needs to perform is not delayed by the hand counting rule?
I hope they go smoothly and quickly.
Because that which is being withheld from the board isn't something that the board has an immediate responsibility. They're not counting ballots anyway. In other words, use the wrong term, but the memory cards, whatever the superintendent would be doing to accomplish certification can start that very next morning or even that evening because the necessary material is being provided to the superintendent.
So I want to make a couple of points on that. First, on the memory cards. It is.
Well, do you agree or disagree that this hand count, should it occur, should it take time, should it be cumbersome, will be a resource drain, no question, but it doesn't directly interfere with the certification work that's supposed to be going on. because that which is being withheld isn't part of what I'll call the certification flow.
And what I want to describe is instances in which it may.
Okay.
Yes.
So first off, with the memory cards, most precincts in the state transmit everything together, and that's what quite frankly, the statutory scheme contemplates.
That's what people have been trained to do.
Exactly. And you have to account. I mean, when it's not just somebody gets up and says, okay, I'm going to drive this memory card down, right? There usually happens in pairs. There's often law enforcement along with them. And so, maybe if there was all the time in the world, we could plan to do that and make sure that the memory cards all get to the tabulation centers in all these counties in enough time to get that 11:59 p.m. deadline, right? So that's just one point.
But why is it any different I didn't fully understand the flow of information from precinct to superintendent, and was under based on what I understood from Mr. Thomas, the misimpression or mistaken impression that until they're done hand counting those ballots, nothing goes anywhere. And so if I'm the superintendent, like, come on, I got work I need to do. I've got the midnight deadline for the unofficial count, and I've got certification. I can't do anything because you guys are 50, there's another 50, and the next person is counting the 50. But what I understood Mr. Thomas to say is divorce those two, because the ballots are staying behind the paper and we'll count them, and whatever this mystery control document that doesn't exist, and I think only the Secretary of State can issue, and he's not, that's what would be sent on to say, hey, there was a little hiccup in precinct number 17. We counted 190 paper and the machine said 191. That can all happen without interfering with the transmission of everything that ought to be going to the superintendent so that corporate body can begin certifying. Correct or incorrect?
It ought, if there was appropriate planning where counties could prepare and make plans so that they could submit the memory cards separately from finishing up the hand count, right? Then
If they had enough people, because they've already planned to deliver everything to the superintendent or the tabulating center. That's a plan. It has to happen. And all that will change is don't send the ballots. Send everything else but the ballots under this new system.
Correct.
But that would mean then 2 trips down to the tabulating center, because ultimately the ballots have to get there. Setting aside all the strange, well, what's the security? These ballots are just sort of floating around, and who's been deputized, and they haven't been deputized to even be touching those things. Set that aside. Is it not true that the certification process could move forward unabated while the poor poll workers stayed late or counted them the next day?
No.
It's unclear to me under the rule, because the rule gives authority, taking it away from the superintendent and giving it to a precinct poll manager to investigate and correct discrepancies, right? And so how that fits into what is the appropriate vote count to certify, I don't know the answer to that question. We don't have guidance on
that. Which is part of the problem.
Which is part of the problem, Your Honor. Just want to highlight one other conflict, and I just touched on it. Is 493B, the legislature gave superintendents the ability to investigate and correct discrepancies. And also, and now this rule attempts to give it to poll managers.
Same discrepancy, or, 493B describes a specific scenario where a discrepancy could arise, which is not the kind of discrepancy that the hand count rule contemplates.
Correct. So I think the legislature has determined the scenario in which, in the specific type of discrepancy, it wants investigated and who it wants to investigate that. And so that's not authority they intended to give to a poll manager. The other statutory provision is not so much a conflict, but it is the legislature speaking as to when it wants these paper ballots actually reviewed and analyzed. And that is in the context of a risk limiting audit post-certification. So the legislature has specifically laid out, this is when we pull samples of these paper ballots. This is when we count them. This is the process to make sure that the electronic count we got matches the paper count we got. And so it's not, and the SEB is trying to expand that. It's not contemplated by the code. I'm going to be brief on a few of these things.
Where is that place?
The risk limiting audit. I'll have to get it for you. I don't have it off the top of my head, but I'll have it to you before I leave today.
Okay.
Each of our BRE petitioners echo the testimony of Cobb, the Secretary of State, and Gavrio. They're concerned about how this process is going to play out at the end of a long election day. They are already being told by poll managers, we are not doing this job if we have to hand count at the end of what is already an exhausting day.
So, meaning I'm the poll worker and I'm saying, I'm not showing up at all. If you tell me there's a chance that I'm counting by 50s, these ballots, I'm taking this year out.
Yeah, and that's in the affidavit specifically.
No, I read it. I just wasn't sure what you meant by what you said, but that is in the affidavit.
Thank you, Your Honor. Also concerned about the training piece, which is again covered, but all of our BRE petitioners concur. And in the Secretary of State's letter, September 16th, I believe, that's already in the record, the Secretary acknowledges that most training has been completed, right? I mean, before the rules even passed. And so I know the court earlier had a question about, well, it was passed weeks ago, not 2 weeks. But the point is, and all of our petitioners affirm this, the training or the preparation for the elections begins at least a year in advance. Training begins weeks to months in advance. And trying to implement this rule at this last minute is simply not sustainable and would cause irreparable harm to our clients. We've also discussed, and I won't dwell on this, in our papers, the diversion of financial resources, concern about error, fraud, and spoliation of ballots for this manual handling. That's concerns shared by the Secretary of State.
When you say ballot, I want to make sure I'm as informed as I can be. The actual piece of paper that people are handling, Mr. Thomas has said it's a receipt. What a concern that's been raised by plaintiffs is, well, what if in counting, whoop, I tore that one accidentally, and it tears it in just the wrong spot, so that if it's a QR code, that's torn in half, or if it was a number that you can't figure out what that receipt ever stood for because of what happened, or someone just brushed against it and all 50 fall on the ground into spilled coffee. What is being lost? It's not a piece of paper that says McBurney voted for Varghese. It doesn't have that, but what is it, and what could we not recreate other than to say, well, I guess they're soggy and they're brown, but I can count them and they're 50 right there.
Maybe you could count them if they're soggy and brown. You can't count them if they're lost or misplaced, which in this type of exercise is certainly a possibility. And I'll point the court to the July 9th transcript of the 11 at pages 224 to 225 and pages 137. It discusses a pilot project where there was a pilot project to see whether this hand counting can occur. And they eventually gave up on the pilot project because everyone couldn't come to the same numbers. Because in reality, when you take 3 people, particularly at the end of the long day, and you're trying to do this, 14 minutes maybe if everybody gets to the same number once, right? That assumes 2020 or 2022 are good years to use, and they're not, for the reasons I already stated.
Sure. But what is on the piece of paper? Not what was just handed to you. That could be a private. No, sorry.
I can't read that.
That's not what I meant. But the receipt, the thing that people are counting, what is on it?
What is on it is a QR code and the vote selections that you made. So
embedded in the QR code, or it would say, it might not have my name, but it would say voted for this candidate in this race, voted for that candidate in that race.
So both embedded in the QR code and also listed out.
Okay.
And the reason it is listed out, two reasons. One, so the voter can get a piece of paper and says, okay, these are my votes, right? We're talking about 8.5 by 11 piece of paper. And also in the mechanism that the legislature has provided to audit the electronic voting, that piece of paper exists. So you can go back and check the machine count against what's on the piece of paper. Because we as humans, not yet, can't read QR codes, right? So the voter can't look at the QR code and say, I know when I feed this QR code, that's what's going to come up, right? But the piece of paper tells it, that's the way the system works, it reflects it, right? But if we ever have to go back and check, and the legislature has created a mechanism to do that, we go back in a risk limiting audit, and that provision, Your Honor, is OCGA 21-2498.
Got it. So if one of these ballots was lost inadvertently or intentionally, I'm seeing too many with that McBurney name, I'm gonna put one in my pocket and it won't get counted. Lost would be the paper proof of that vote. Sure, there's a microchip that has on it that we had 200 people who voted for McBurney, but now if we counted the pieces of paper that were pro McBurney, there'd only be 199 because one of them was folded, spindled, and mutilated and can't be used anymore. Is that a fair statement?
That's a fair statement.
That's how sensitive these pieces, they're not just a receipt, but if one goes missing, then the physical proof, not the digital proof that some people don't trust, is now gone.
Correct. And it seriously compromises the ability to conduct the paper copies against the electronic records and make sure everything matches up. I believe petitioners have some arguments they may raise with regards to standing and justiciability. I can get into that, but I think it's all covered by the court's order this morning. Questions for me? I have nothing further, but my colleague, Mr. Kastorf, is going to briefly provide some additional citations to the court on the APA question.
You guys didn't tell me there was going to be another speaker. All right, Mr. Kastorf. Good afternoon, sir.
Good afternoon, Your Honor, and I think I can win the award for brief this presentation. I wanted to address specifically APA procedural compliance. I'm not going to repeat anything that Mr. Kaplan already said, but I thought there's some other resources that may be useful to the court. First is that our exhibits, exhibit number 22 and 23, are examples of proposed rules issued by other state agencies. As Mr. Suss points out, we unfortunately couldn't find any examples of the state election board getting it right, but we put 2 examples in the record of other agencies, and it shows how simple it is to engage in exact compliance. They each state the department will consider the proposed new rule for adoption at X time at X date. It's simple. The other reason why I think Exhibit 22 may be helpful to the court is it is a great example of how you deal with proposed amendments. The way the Department of Banking and Finance handled it was by describing each of the changes, whether they were additions of subtractions in plain language so that the public could understand, which is a much better system than an inaccurate red. Second, the court had asked about whether there is, actually pointed out, there's only one case talking about it specifically in the context of the Administrative Procedure Act. However, exact compliance and similar concepts do exist in other areas of law. One is that exact compliance is required for accord and satisfaction. An example is Parker v. Pender, 174 Georgia 579. And in that context, exact compliance means exact compliance. Second, Georgia law also uses a similar but actually laxer standard of strict compliance, such as in anti-litem notices. And there are numerous Court of Appeals cases that say, quote, strict compliance is exactly what it sounds like, strict. An example is DeFloria v. Walker, 317 Georgia App 578. Now, strict compliance is already strict, but exact compliance is even stricter than strict. The plain language of exact is more stringent, but this court doesn't need to just rely on common sense and plain language definition because Georgia courts have said as much. For example, in State v. Fielding, 229 Georgia App 675, the Court of Appeals held that when a police officer reads an implied consent notice, he must read it exactly as written with no deviation. And there the court specifically explained that even strict compliance is insufficient. Compliance must be exact, indicating that exact is stricter than strict. In that case, the Court of Appeals also explained that when the legislature requires exact compliance, it is, quote, obviously intending to provide a bright line test and to alleviate the need for a case-by-case determination as to what notice is legally sufficient. It is designed to make this court's job easy. If it doesn't match, you strike it. And finally, the Supreme Court in Blackburn v. Lee, 137 Georgia 265, 1911, has contrasted substantial compliance with, quote, literally exact compliance, again indicating that exact compliance is something stricter than strict. The final point I wanted to make about the notices is that Mr. Kaplan did an excellent job of laying out how many differences there are in the red line. I want to point out that at least one of those missing subtractions is quite material. The first missing language that's removed is the paper ballots shall be placed into durable, portable, secure, and sealable containers to be provided for transport. In the current version of the rule, pretty much as soon as you close down the polling place, you immediately get those ballots into a careful sealed box for transport. One of the largest concerns we have about this rule is that as soon as you move the ballots to a table and you start counting them, you instantly introduce chain of custody problems. There's a possibility a ballot gets lost, it gets tampered with, it gets ripped, or a worker who's already been working for 14 hours spills their late night coffee on it. If that happens, that ballot is no longer available in a recount or a risk limiting audit. There are already multiple procedures to reconcile how many voters voted at a precinct. The poll pads, when you check in, check the number of voters. The machines where you produce your ballot, check the number of voters, and the scanner checks the number of voters. And those are already being reconciled on recap forms by the Secretary of State. So the marginal benefit provided by an additional hand count is trivial compared to the potential downside that a ballot would not be available in a recount or a risk limiting audit. And because the notice does not mention that it is removing this language, a member of the public reading that notice might not be aware of one of the potential largest downsides of this rule when they're considering whether to attend the state election board hearing, to provide notice and comment, or to otherwise engage in the process. And that's why, under any definition of exact compliance, that failure to include information is material.
Thank you for that. I'll make sure I follow. Mr. Kaplan had on the screen the version that was in the notice that showed what was being added and subtracted. And then he had that box with red in it. And I'm still working through. I think if it was struck through, that meant that was something that was excluded, that they didn't say was going to be excluded. And if it was just in red, it was added, but the notice didn't say it was going to be added. Regardless of what all the red text meant, what you just described, that durable protective bag was removed as a result of the amendment?
Yes. So I believe it would be that longer red sentence black. I can't quite read it. Yeah, it's
I see it, durable, portable, but here's what I want to understand. So that being struck through in red there means that the rule as passed and that will go into effect on October 22 does not include any more requirement that things go into the durable, portable, secure bag.
That is correct. Instead of immediately moving it into that batch, they pull it out and hand count it, and then it's not added back in later in the rule. It does reference a separate put in, and the specifications on that box are no longer in the rule.
Okay, but critical to the argument about notice, and say that's being removed. If I were to read the notice, like, oh, they're gonna do some hand counting, but we still got that durable bag. it didn't indicate that that would be struck.
That's correct. The only way you could figure it out is by doing the type of red line that Mr. Copeland has performed.
After the fact.
Correct.
Okay.
Not by the face, anything on the face of the notice.
Okay. Thank you.
Thank you.
Oh, that was important. That was really important. If you missed it, I'll just recap what he just talked about. Basically, what they said was when they restated the rule with the red line, which shows you the changes made from the original rule to the new rule, instead of including language that they struck from the original rule altogether, they just didn't include it. So they didn't show struck through language. They didn't show any of that. And that's important because part of that struck through language that basically now changes the procedure for counting used to say that you had to secure the ballots in a certain type of secure box, et cetera, et cetera. It went into a little bit of detail. By omitting that language, it omitted the requirement to do so. So this is a very important distinction. And furthermore, part of the premise that the Cobb County election people are arguing against is that the state election board never announced a public notice for a vote. They only announced discussions. So the public wasn't made aware, as per pretty standard public notice requirements across states that I've worked in for different organizations, nonprofits mostly. By omitting that, they basically, they didn't give the public a full disclosure of what their process was going to be and when public comment would be meaningful and when it wouldn't. This is not good governance. That's bad governance. So I don't know how the judge is feeling, but he did linger on that. He lingered on that point, I think for good reason, that that's a material harm done to the people, I think. I mean, okay, I'm just speaking out of my butt, so I'm sorry, okay? Forgive me. Forgive me. But this is what I'm hearing and what I'm picking up this is what I'm picking up that he's putting down, but I could be proven wrong. But anyway, so we'll continue at 1 1/4 speed. And I'll come back. Yeah, my county removed the drop box after 2020 because Republicans, even though it was just outside the county election board office, so it's a matter of a few steps more to drop it off in person. I actually really appreciated I had a drop box right outside the precinct. And frankly, I use it all the time because I don't want to stand in line in the precinct. I don't need that experience. And that's where the county, and that's where the drop box is. So it makes perfect sense for me to drive there, droppy, bye. So yeah, it's ridiculous to me that we are making it harder for people to vote. It should be easier. Period. There's no fraud issues. They've got it wrong. They fooled you. Okay, I'm going to shut up.
At long last, Mr. Thomas, or any of your colleagues, let's hear from the state election board.
Well, just to address a few points that were made by Mr. Kaplan early on about some of the alleged vagaries here, it is clear that it is only election day ballots. And we know that because the advanced voting section of the election code, of the regulations, provides that on the Friday before election day, the poll managers will go in, remove all of the ballots that are in the machines. They will go through that same process. They will seal the box that's coming from the scanner machine, put them in another container, and then take those to the election office. So we're starting.
What in the rule, the hand count rule, says, well, don't also do that on that Friday? Or it says do it only on election day?
These are two, 183, 114.02 is the regulation that talks about taking the advanced votes.
Okay, completely different space in the set of rules.
Yes.
Okay,
And so on Friday, the scanner machines are emptied. So you start election day with empty scanner machines. That's not vague. That's not unclear. That's how it works. There's been a lot of reference to this notion of the poll manager having this authority and therefore, intruding upon the superintendent's authority. And how can we understand, what the language of this means? But you sort of pointed to that in that first, you've got to address the context in which that language is being used and also address the task that they are actually engaged in. And in that task, the only thing that they're supposed to do is count the votes, count the ballots, and make sure the number of paper receipts, in effect, matches what's on the tabulation tape. That's it. So to the extent that they're supposed to, if there's an inconsistency, fix it, it's limited to seeing if they can, is there a spoiled ballot? Is there a ballot that's stuck in the machine? Once that ballot box, once those paper ballots are removed from the machine, you can't do that anymore. That's it. That's the best time to make sure that you can collect all ballots, including emergency ballots, spoiled ballots, and any ballots stuck in a scanner or otherwise. And that has happened, and that's in the record. Second, that same language already exists in
What same language?
the discretion, in effect, that people have complained about in 183.112.12a2. And this is with respect to filling out the recap form against the tabulation tape numbers. And it says, if the numbers recorded on the recap form do not reconcile with each other, the poll manager shall immediately determine the reason for the inconsistency, correct the inconsistency if possible, and fully document the inconsistency.
It's the same language.
And it's in the context of the same thing. Do the numbers on this form match the number of voters that we've had check in? There's been no problem with that language, and it's been in operation for 2 different elections. So the idea that this is some massive intrusion upon the superintendent's authority is overblown. Your Honor asked the question, setting aside the idea that should people be handling these ballots at all, right? When you were listening to Mr. Kaplan's presentation, well, the answer is they're already required to handle the paper ballots because the process requires that when the poll closes in the old rule, regardless of the hand count rule, they have to take the ballot box out of the scanner, they break the seal, they pick up those ballots, and then they put them into that container. Okay, so
that's pretty different from let's spread them out, piles of 50, 3 different people. Maybe we'll do it tomorrow. Yes, they're touching them, but that is a pretty minor from point A to point B, 2 seconds, done.
What I'm saying is at the same risk that you identified earlier, for instance, somebody might see that there's a lot of votes for so-and-so or such and such, and I'm going to take it already exists. A lot of those issues already exist.
No, they don't.
Just as an aside too, there keeps being these references to these very old, infirm people who have been there for all day. And how can we possibly ask them to count for 15 or 25 minutes? And I take issue with the idea that you can't find 3 people who are willing to engage in an election day process and make sure that this reconciliation process can happen.
Isn't it though, let's just focus on Cobb, isn't it actually at 444 people and not 3?
Correct, but correct. Yes, it is true that they have to have 3 people at each one of the precincts. But the idea that, there are already volunteers there. There are people who have already taken the oaths and undergone the training. And all we have to do at this point is say, the 3 of you that we're going to take the ballot box out, if you're up for it, count them. If you're not, let us know. We'll find somebody else. That's it.
How do you find someone else?
The same way you found them in the first place. You solicit volunteers.
What?
Okay. And so if they that night say, you know what, this took longer than I thought. I'm punching out. Polls have closed. See ya. I'm the poll manager. Who do I call to solve that? Do I call you? Well, do I call the state election board, Secretary of State? Dang, there's just 2 of us now, and I need 3 because that guy just left.
The same hypothetical applies regardless of whether these regulations go into effect or not. You still have to have 2 sworn witnesses that are part of the process of removing the ballot box. So if someone says, it's taken a long day, the polls stayed open an hour longer than I anticipated, I've got to go home, that same hypothetical still exists. And just on that point, since you brought it up, that is part of what is problematic with all of the affidavits that have been provided. It is littered with concern. It is concern. It is worry. If this were anything other than an election case with the public outrage that has existed, the type of affidavit that was submitted here would not be enough. Because all that it says over and over again is, quote, I am concerned about the rule's last-minute adoption. I am concerned that the BOER will have difficulty identifying and deploying. I am concerned that the Cobb County Elections Office lacks space. I am concerned that the hand count rule may lead to delays. It's hypothetical on top of conjectures, on top of speculation.
Well, darling,
there is no imminent threat
we know
here.
We're going based on
it's a threat of potential things that might happen if the worst case scenario comes up. And that's simply not sufficient for declaratory judgment. There was a statement by Mr. Kaplan that while it is theoretically possible to comply, we are concerned it's not practically impossible. We are concerned it is not practically impossible. Again, hypothetical, and it is again substituting the judgment of these individuals with the judgment in effect of the legislature through this secondary legislation. If I may also, and I know that everybody understands the language of the hand count rule, but I would submit to you that this is not Greek, such that it would take hours to train someone to do this. All that is added is that you remove the paper ballots,
That's such a
record the
clue to me
date and
that
time
this
that the
guy
ballot
is not
box
a
was
good
emptied
critical
and present to
thinker,
three
because
sworn
anybody who
precinct
resorts
officers to
the,
independently
well,
count
you
the
know,
total
we
number
should
of
be
ballots
able to
removed from the
find
scanner.
3 people.
That's
a
enough
stupid
instruction.
argument.
That's not vague. That's not ambiguous. Sorting in stacks of 50 ballots, continuing until all ballots have been counted separately by each of the 3 poll officers. That's that. So that's the first part. You got to count them, separate them into stacks of 50. That's not Greek. That's not difficult to follow.
What about the separately and independently? Is it that each of the 3 starts with a whole pile and breaks them into 50, or I'm the poll manager, I break them into 50, and then they verify? Or I mean, none of it's Greek. You're right. Some of it strikes me as opaque, with no guidance from the de-opaker, whether that would be the Secretary of State or someone else. So how would you train? Now you're apparently an expert trainer, because you've concluded this would be easy to do for folks with unknown educational background who aren't getting paid a whole lot to do this, that they'll just pick it up like that. So instruct me on what it means to separately and independently count.
It means that each of the 3 poll workers have to count all of the ballots independently, sorting them into stacks of 50 and coming up with the same number. That's what it means.
What?
Whether you do it, as you said, with a poll manager, dividing them in half or in 3 parts and letting you start that way. That's up to the discretion there. That's fine. There cannot be regulations or legislation sufficient to cover every conceivable possibility or to govern every conceivable action that you might have to take. In fact, anytime that this board attempts to provide that clarity, there's a constitutional challenge, and we're told there's an exceeding of authority. So the point remains, there can be some discretion into how that takes place.
You are a whiny man.
When all 3 poll officers arrive at the same ballot count, you sign the control document containing the polling place, ballot and serial number, election name, printed name with a signature and date. If the numbers don't, and this is the reconciliation part, that's it. That's what we are concerned about, that we can't do between now and Election Day. We cannot explain how to do that to 3 individual precinct workers.
So 444, what's the plan? What's the game plan to get that word out to 444 folks?
That is up to the individual county boards. They've got to do that. That's how they are they're required to follow the regulations.
What's the wisdom? I agree, but you dumped a problem in their lap, not you personally, a few weeks before it needs to be put into operation.
Yeah.
What's the wisdom of that?
Right.
And what's the necessity for that, as opposed to, all right, let's make sure that we get to try this out, and this will be effective the next election.
To ask that question is to invade the province of the legislature through their rulemaking authority, the agency through their rulemaking authority. I mean, that is at the discretion of the legislature and the rulemaking authority. They're the ones that review all of the factual information and make the determination that this is practically impossible. It may be controversial. Some people say, I don't think I can do this.
But what you can't give no weight to the Secretary of State's perspective on that. There's a subject matter expert, and his considered opinion is this is too much too late. This isn't the time to pass rules like this. You're changing too much too late in the game. I'm not going to be the Secretary of State, am not going to be in a position to generate what I normally would, which is training materials, et cetera. So this isn't some reactive election board that never got along well with the state election board. This is Secretary of State, and it's his job to try to make this stuff work. And hopefully you're not suggesting that he has some agenda other than fair, legal, and orderly elections. And his considered opinion is too much too late. What's the response to that other than to say, well, that's his problem because the state election board passed these things, which is what you're saying when you say you got to get out of the way of this board that has been given the authority to do it, assuming it's authorized and is reasonable.
Right, but the Secretary of State, I'm going to say what you told me I was going to say. The Secretary of State does not have rulemaking authority. They do not have legislative authority. They're not the ones that review the record. They're not the ones that are empowered to make a determination based on their review of the record. If it were the case that every time an agency official questioned the validity or the practicality or the reasonableness of something that they have some relationship to, such that it would give standing to the entities that are governed by those rules to challenge them, we'd be in litigation nonstop over things that are reserved to the legislature. And if this court is to accept these arguments, it is to substitute the Secretary of State's judgment or the county board's judgment with that of the legislature, and it cannot do that.
Clear. I'm not accepting arguments. I'm asking, how does one weigh it? It doesn't seem like it's an immaterial, irrelevant observation coming from the top legal officer in the state, the Attorney General's opinions. It also doesn't seem to be an immaterial, irrelevant observation coming from the Secretary of State that there are these concerns. And your answer, and it may be the answer you have to give, is to swat it away and say, you know what, everyone has an opinion. They don't merit consideration in this debate because the State Election Board has spoken. And I hear you, and that may be your response, which to me is non-responsive to how does a judge called upon to assess this weigh the concerns that were raised by the Attorney General and the Secretary of State. You and the board can choose to not pay attention to them. I don't know that I should ignore them, but it's not lost on me, your point. It's a very important point that the Secretary of State is not the one empowered to issue these rules. That's not his role at all. In fact, he takes them and he figures out how to help local boards implement them. So I get that. I'm not trying to turn the process on its head. There's no veto. And the Attorney General's memo was just that. It was his office's considered opinion about the validity of some of the steps that the board took. But like you said, it's not a veto.
I would refer you to OCGA 501319, which is the Administrative Practice Act. The reason I keep coming back to this is because it determines what this court is constrained by. This court shall not substitute its judgment for that of the agency as to the weight of the evidence on questions of fact. And that is exactly what you are talking about. The weight of the evidence as to questions of fact. Is this practically possible?
No,
do these county election boards have the time and resources necessary to do it? That's exactly what they were looking at in the administrative record. And that is precisely what the APA provides. This court cannot substitute its discretion for. You have to give deference to that.
Is there, you are much more familiar with the record that was before the State Election Board, but there's a robust record that they carefully considered the local election board's abilities to implement and comply with these rules, or someone just said, like you've said, 14 minutes, what's the big deal?
I think there are something in the neighborhood of 1,500 pages of hearing transcripts. Part of Cobb County's exhibits includes an Open Records Act response that contains all of the emailed public commentary on it. I think it's 535 pages of emails, so it's thousands of emails.
Right, but that wasn't my question. I know there's a big record, but in directing me to 501319, you correctly said courts are not supposed to substitute their judgment for findings of fact that the rulemaker made. And then the natural flow from that is that they carefully considered a record that there's a basis from that record to conclude that these rules don't impose an unmanageable burden or an unclear burden on the local election boards. And I'm asking you to direct me to where in the record that is, as opposed to it's a big record. I know it's big, but it might be big because all the local election boards were saying, don't do this. That doesn't mean then that they carefully considered evidence that it wouldn't be an unreasonable burden with such short notice.
Sure. And I'm obviously I can't do that now. I don't have all of the transcripts, but I can certainly get you evidence of consideration of whether this is practical or not practical.
Okay, I get that, but you believe that that's in there. It wasn't, we heard all the naysayers, but we are yay-sayers.
Yes, there were people who spoke out on behalf or in favor of it. There were people who spoke out against it. You've got people who are members of boards doing the same. So you've got both sides who are arguing about whether this makes sense or not. And based upon hearing all of that and considering all of that, they said this is practical.
Okay, I appreciate that there were pro and con. I get that. But what you said was that there was careful consideration of evidence that supports the notion that implementing these rules so close in time to an election was not an unreasonable or impractical burden on the local election boards. That's different from me appearing saying we need to have a hand count rule. It's one of the best ways to assure accuracy, that the total number of votes is what shows on the machine as well as the pieces of paper. And that may be true in a vacuum. But that's not what we're working through today. In fact, there may be plenty of people who would take no position adverse to a hand count rule had it been promulgated in February. But here we are. You're telling me that you're going to be able to find in the record a consideration of the practicality of this last minute implementation, not the practicality of the rule writ large. You help very eloquently at the beginning say, it's not counting who voted for whom, it's counting pieces of paper, and it's not all that burdensome. And the pushback from plaintiff was, I think they kept using that word, immense burden. But in the end, it's more the practicalities of how do we get this thing off the ground in such a short amount of time? And that's where people are butting heads.
Where are my stoners
You
for
think the record will
Kamala?
show there was
Come
robust
on,
discussion
baby.
about pulling this
Legalize
off at the last minute, as
Kamala
opposed to
Harris
what are the
will
merits of this rule
legalize
in a vacuum.
recreational marijuana.
I don't know about the word robust, Your Honor,
That's
but I know that
right,
there's evidence that these types of considerations were
right.
discussed.
And it just needs to be some. It doesn't need to be robust.
Bring your
Okay, thank you.
stash.
Okay.
Fuck yeah. Well, she's got my vote. That's for sure. That was it.
There
I
was
on the
reference
fence,
to
but
the
now
potential conflict
I'm
of the
all
hand
in.
counting rule
No.
with OCGA 420, which provides that the election superintendent shall then ensure all ballots are counted. That provision is talking about, in that context, the votes. They're on the memory card. That's how they count the votes. They're not hand counting in that section. They're taking that memory card and they're getting the tabulation from the memory card. So there's no conflict there.
Retroactive that bitch.
Finally, and this goes back to our capacity to sue argument, and I'll be very brief because I know you've heard a lot on this.
We will, Carrie.
But the footnote in Floam that our friends on the other side say demonstrates that, of course, they can have standing. That's not at all what the footnote says. The footnote is in the context of a discussion about whether one of the plaintiffs had demonstrated evidence that they had a justiciable controversy or were facing some type of uncertainty. And the footnote in Floam simply says that as dicta, the Cobb County Board submitted an amicus brief that talked about how they're uncertain about what this other Board of Commissioners thing was done. And all the court said was, that's the type of uncertainty that we are concerned about. It has nothing to do with standing. It certainly has nothing to do with the capacity to sue argument that I've made already.
It's dicta either way.
Right.
Okay.
And that's it, Your Honor. I'm happy to answer any other questions, but that's what I have to affirmatively present.
Tell me, because you've heard me mention it several times, and you've had very good responses to, this is why that's not a big deal. But there has been concern raised about the control document. And I may be using the wrong word, but whatever form is supposed to be completed by the poll manager when the hand count is complete. And that is
got that cool thing.
my very limited understanding is that any form anyone is filling out in an election, the generic form comes from the Secretary of State. This came up in a parallel hearing about what does the certification look like?
Right.
Because I had this idea, like, why don't you just put on the certification? I have concerns about these things. And that's not what a certification form looks like. There's no blank for you to freeform your answer. Yes, I certify, but go check out precinct 9. I mean, I don't know what they were doing there, but that didn't look legit. And that's too bad, but that's not what a certification form looks like. And that's when I learned, because the board, a local board doesn't get to create its own certification form. It is given one. And so that same concern arose, like, well, what is this control document that a poll manager is to fill out if in completing its work, if that has to flow from the Secretary of State? And he has said, I'm not doing anything in connection with this rule. And that may be a chess game, like, haha, you can't fulfill this rule because you don't have a control document. Maybe that's a different declaratory judgment to tell the secretary, well, you got to create it because it's in a rule.
I'll be frank with you. I'm not familiar with that Secretary of State regulation. I need to take a look at it. I don't know.
I'm not citing you to one, but what the plaintiffs have said is we don't generate forms that document what happens in the election. Those come from the Secretary of State. And so there's a reference in the hand count rule to completing a control document that certifies, if you will, completion of the hand count. And so uncertainty abounds in some places. What control document? Who creates that? Will there be 148 different forms of a control document in Cobb County? And I thought that was one of the things you were going to pounce on, to say, come on, control document. It's defined here in a different provision of that rule.
I don't know that it is defined in a different provision. To be frank, I see that when all 3 poll officers arrive at the same total ballot count independently, they shall each sign a control document containing the polling place, ballot scanner, serial number, election name, printed name, signature, and date and time.
Right.
I mean,
it tells you the contents, so it could be a piece of binder paper that has that info on it.
It's also not something that is actually, as I understand it, in any sort of certified recount or anything along those lines actually considered. What is considered are the ballots, the memory cards, et cetera. This is simply to document the process by which they've gone through this, to make sure that the information from all of the ballot boxes and machines, et cetera, are on that piece of paper, but it's not actually reviewed, and it's not part of any required review as dictated in the election code or the regulations themselves.
Then what's the point of the rule?
It simply to ensure that, just to provide that information that you can only get from that place at that time, such that in reviewing all documents later, it's something that can be considered, but it's not part of a formal review.
So the control document, whatever that might look like, I agree, it's not part of the certification process. But if I'm bringing an election contest because of what I think didn't work well in that county, a control document might be a central piece of evidence, because it says there were 47 precincts where they couldn't get the 2 numbers to match. It's not something that the superintendent relies upon in certifying, but I guess your argument in saying, well, why do we have this rule at all? Since you just told me, hey, really, the control document doesn't matter. No one's going to pay attention to it. Is that hypothetically, it could be of value if there's an election contest and it could be evidence of systemic irregularities in a jurisdiction because there are multiple control documents that said, try as we could, we were -10. The machines were at 1,000 and we got 990 and we all got to 990. It wasn't even that I got to 989. All three of us got to 990 and the machine said 1,000. And that's a reason to think that there's some overcount going on. And strangely, all 10 of those went to the same candidate.
Your Honor, I don't actually see that the control document contains the number of ballots counted or anything about that. What I see that it talks about is the polling place, the ballot scanner serial number, the election name, and a printed name and signature, date and time of the ballot count, not information related to the ballot count.
So then how would, if I'm a poll manager and I can't resolve it, there's a discrepancy and we can't figure it out, how does word of that discrepancy go anywhere if it's not on the control document?
That's not what it talks about with respect to correcting an inconsistency. What it's talking about with respect to that is if the number is recorded on the precinct poll pads, ballot marking devices, and scanner recap forms, which are promulgated by the Secretary of State, do not reconcile with the hand count ballot totals, the poll manager shall immediately determine the reason for the inconsistency. So it has nothing to do with that control form that we referenced above. That has to do with reconciliation with the Secretary of State's form.
Okay, but I don't have the text in front of me. Assume you're right on that. I'm the poll manager and I can't reconcile it. And there are 10 more votes on the memory chip than I've got pieces of paper.
Regulated, so it would override.
Does the hand count rule empower me to tell anyone about that? Require me to tell anyone about that? Or I leave frustrated. I did my job and
it is left
it didn't work. Because if it's not going on that control document, where does it go?
Well, the poll manager shall immediately determine the reason for the inconsistency, i.e. are there still ballots in the machine? Correct it if possible. Find them if they're there. And fully document the inconsistency or problem along with any corrective measures taken.
Okay, but that's the circle I thought I was completing. That documenting the inconsistency, whether it could be resolved or not, doesn't go on the control document. That's a different document that would just stay with the poll manager or maybe go to the superintendent or?
Everything goes to the superintendent. That's a separate provision in the tabulating results provides that everything goes to the superintendent, except for obviously the machines themselves.
Sure. Okay. So this documentation of identified discrepancy and either successful investigation, there were things stuck in the machine, or unsuccessful, I can't explain why they don't match. That document would just be sort of swept up in the please send everything to the superintendent that's elsewhere in the rule.
Correct. And that's the same language, remember, that we've already dealt with for 2 elections in a row with respect to a similar reconciliation of the ballots tabulated on the tabulation sheet and the check-ins.
Okay.
So this has already been tested.
New.
This has already been tested. People understand their discretion within the context of counting to, compare that count to the tabulation tape. And that's it. That's the limit of your discretion. That's the limit of your obligation. And fully document the inconsistency or problem along the way is that same language has already been attended to.
Then what is the difference?
Okay. So that wouldn't be something new for a poll manager. I've had to do this before in a slightly different context concerning the recap form.
Correct.
And now whatever toolkit I developed to do it, I apply it to the hand count that we're doing of the ballots.
Correct.
Okay. And so what would be new along with the hand count would be this control document, which, as you pointed out, doesn't actually include there was an inconsistency. It says these are the machines basically that for which we were counting ballots and the date we did it.
Correct.
Okay. All right. Thank you.
Thank you.
Wow. That sounds like a terrible idea. That sounds like nobody thought it through.
Mr. Kaplan, anything you want to say as we wrap up?
Just very briefly, Your Honor, a couple of points.
Right. Good point, Max.
I think the State Election Board's presentation and certainly some of the responses to Your Honor's very fair questions really raised more questions about the meaning, interpretation, ambiguity of the hand count rule than we started with. I think the answer to, well, how do you count in stacks of 50? What does separate and independent mean? I think the answer was essentially it's up to the poll manager. That could lead to thousands of different people making decisions about how to do this count. That does not promote uniformity, does not promote consistency in the administration of election. It's contrary to the SCB.
What about Mr. Thomas's observation is I think he got frustrated with me pressing that, like, hey, you can't, but I agreed with his answer. You can't write a rule that thinks of every permutation. And so, hey, we're saying generically, you can't, the three of you can't just sit there together and watch one person count and say, yeah, we all got the same number. Because when two are stuck together, you're missing those two other opportunities to not have those pieces of paper stuck together. And so this is adequate. It may be if you're in precinct 9, it looks a little bit different than in precinct 14, but in the end, 3 people have counted, and if they can reconcile it, they're able to say, the machine said 700 ballots, we counted 700 ballots. Yeah. Job done.
Well, we would say that, for all the reasons that have already been argued, they don't have the authority to promulgate the rule in the first place, so it doesn't matter really that this rule is somewhat ambiguous. They're just inventing a new process that the legislature did not, despite setting forth very specifically the way an election is conducted, the way a count is conducted, making very clear that counting of ballots is done as soon as possible and shall not cease. So we don't think that they can just invent a new, slightly or highly ambiguous rule and just throw up their hands and say, we don't have to tell poll managers everything. We can just come up with new stuff and let them figure it out. That's essentially what you've heard today. That is inconsistent with their statutory authority, but it's certainly inconsistent with their obligation to implement rules that ensure an orderly election and ensure consistency among superintendents and ensure uniformity. What you heard was the opposite of uniformity. It's let them figure it out for themselves. And the timing of this is what makes it problematic. Is it possible that, the state election board could adopt some rule that it's otherwise authorized to adopt that has some ambiguity? Yes, but you do that far enough in advance of an election so that you can sort through those ambiguities and you can get Secretary of State guidance and training so that the election is done uniformly. So if there is 2 possible ways to create a control form, let's say, as Your Honor has put out or pointed out, then the Secretary of State under the law, and this is
sources.
OCGA 20-2-50A5, is statutorily responsible for creating all blank forms for an election. So yes, they have identified a form that needs to be made, but there needs to be time for the Secretary of State to also do its job, which is to create the form to ensure uniformity. There isn't time for that.
What was the statute?
This is OCGA 21-2-50A5. And that imposes exclusively within the Secretary of State's discretion the creation of all blank forms to be used in an election.
My ass off at 18. Yes, I did. Embarrassing.
Other questions, and this is as my client listened to the argument, some comments that were made. The question of write-in ballots is of great concern to my client. Write-in ballots.
Of what?
Write-in ballots. So this election, we actually have, I think, 1 permitted write-in candidate.
Oh, write-in ballots.
Yes, write-in ballots. Okay. And so when you cast a voter, at least you type in the name of a person you want to write in, which many voters do. That creates a paper ballot that is essentially a BMD ballot, and that's fed through the optical scanner. But optical scanners, they try to sort between the ballots that are cast based upon solely non-write-in candidates who are on the ballot, and ballots that contain write-in candidates. And the ballots that contain write-in candidates are separated typically and historically, and still sealed and immediately delivered with the memory card to the tabulation center. And then the tabulation center processes those ballots with particular carefulness, because often those require additional levels of review to ensure that a voter is not disenfranchised by not counting the vote for their write-in candidate. Well, this hand count rule doesn't say anything about what to do about the typical process of, a traditional ballot with candidates who are on the ballot form and write-in ballots. And do you just stack them all together in a stack of 2,000? Can you maintain, a separate stack if there are only 5 write-in ballots? Because, you have to count in stacks of 50.
Is
So
the segregation of write-in ballots in the way you described just a best practice, or are there rules or regulations that direct poll workers and superintendents to keep the write-in ballots separate from non-write-in ballots?
That's a good question, and I don't know that I'm sure there are specific rules with respect to write-in ballots, but I'm not familiar with the specifics. But certainly, every county and every precinct faces this issue, and there's no question that, I think the optical scanners that are used are designed to separate them so that you can maintain that difference. And the point here is not, does this rule conflict with some specific treatment of write-in ballots? It simply is silent on how to address the issue of preserving, separating write-in ballots from traditional ballots. And it totally disrupts what has been the traditional process, certainly in Cobb County, of getting all of the election materials together, which include the memory card, which include the paper ballots, and sealing those up, making sure that you have a very solid chain of custody, and you bring those to the central office or the tabulation center, where the election superintendent is ultimately authorized under the law to oversee the process of reconciliation.
Yeah, I'll stream that tomorrow.
This disrupts that entire flow by separating potentially the paper ballots from the memory card, as Your Honor was asking about earlier, and not providing any insight into how to treat the difference between write-in ballots and traditional ballots during the hand counting process, and is utterly unsupported at all in the election code, as noted by the Attorney General. We didn't hear anything about the concerns that we've raised with respect to, well, one other point here. The rule also does not address this question. What if you have a scanner that has more than 750 ballots that have been scanned, and you have a scanner that has less in a single precinct? So then the poll manager under the rule could theoretically choose to count the ballots from the more than 750 scanner the next day, but would have to maybe count the first set of ballots that day. It's just not clear, because the rule seems to pertain to a single scanner and the number of ballots with respect to a single scanner, but many precincts have more than one scanner because, they involve a lot of voters.
Sure. What does your client tell you, or your work on this case tell you? Let's say that was the only issue with this rule, that actually otherwise people hand count, let's do it. It's another check. Why not take another check to make sure counts are accurate? But we have a bunch of precincts where some machines will have 800 and some will have 200. And I just don't know how to manage that. Do I have to do the 800 at a later date? And so we're sending in two different batches. Let's say that was the only issue. Where would your client go for relief and answer on how to manage that?
I think the typical process would be through the Secretary of State and through a training process and through a uniform, consistent understanding where election officials across the state, the election directors from each county, or if the boards decide to get involved because it's an important enough issue, the board itself would combine in meetings that happen, in the year prior to an election. And as Ms. Silas's affidavit sets forth, we start the work to prepare, particularly for a presidential election, a year before. This work started in 2023. And that's the kind of thing that happens. The election officials from across the state get together, often in meetings facilitated by the Secretary of State. The Secretary of State provides guidance, training materials, and other information. And to the extent that there's a sufficient enough ambiguity, then you might go back to the state election board. You might seek declaration from a court of law. But, in a standard process, there's time to work through those things to ensure consistency, uniformity, as required by the state election.
But your understanding is that even though the Secretary of State is not a rule maker, his office might provide training or guidance on what to do with that scenario of one machine has 800 and one machine has 400. That the general approach is X. And I guess if a local election board said, I don't think that's right, ultimately everything could go back to the rule maker to say, there's this piece that wasn't in there. I know you can't contemplate everything, but this is sufficiently recurring in larger counties, Chatham and Macon, et cetera, that we need more specific guidance on what to do when you've got one machine with 800 and another with 400.
Right, and that's assuming that the state election board even had the authority to adopt it in the first place. And
I'm assuming, my hypothetical was the rule is all good, and we're running into, you have highlighted a bunch of areas of ambiguity that are created by the hand count rule. And I just simply want to understand, how does a client like yours navigate it if the rule itself is unobjectionable, it's passed with authority and timely, properly noticed, all those things, but then they're thinking about how we can implement it because it's passed in February. Wait a minute, what about 800 in one machine, 400 in another?
That's right.
How do you solve that? And you're saying you could go to Secretary of State, or it could be that if enough local boards bubble it up to the state board, they could amend again. So you know what? We didn't think through that scenario. So here is a tweak to subparagraph 5. Here's what you do. It's your total count. It's not by a machine. If you have more than 750 paper ballots, then you can kick it to the next day.
I remember that.
That's right. And there's also,
I remember those stories.
Beyond
I didn't understand
sufficient time to have Secretary of State guidance and training, sorting through any other issues. The state election code contemplates that any really detailed issues regarding reconciliation or tabulation are administered and supervised by the election superintendent, by our client, not by individual decision-making by poll managers. And yet this rule, in terms of deciding what to do if you have a scanner with 800 ballots and a scanner with 700 ballots, would leave that question solely to the discretion of either the poll manager or even an assistant.
Well, that seems like a terrible idea.
Mr. Thomas, helpfully for me, pointed out that some of the concerning language for your client in sub 5 is in sub 2, where poll managers, when they're working on the recap form, if things don't reconcile, they should, and it's the same language, determine the reason for the inconsistency, correct it if they can, and then document it. So it's A2 in the tabulating results
using
rule.
what methods?
Paragraph A2.
Is it
you handed
witnessed
it
by
to me.
someone? I have so many questions.
And that doesn't seem to have created heartburn for superintendents around the state before.
So are you talking about, sorry,
and it may be that
7 of the binder that
I don't know. You handed to me independently. Here's the current.
The tabulating results rule.
Yes,
right.
Correct.
I believe that's A1. Right?
A2. Look at A2. The final sentence in A2.
I'm just making sure I'm looking at the same rule.
This is the unamended version of.
I see. The prior rule.
Well, it's the current rule until the 22nd.
Right. That's right. You're exactly right.
Okay, what are we doing? Mic drop, come on.
So as I understand it, I'm looking at this now, the poll manager basically is taking the number of check-ins and providing essentially the reasons for any disparity between the number of check-ins, which is a number already in existence, and the number of scanned and recorded.
Right. I'm not asking you to decide on the fly, but the point is there's a poll manager role that's been out there for at least 2 election cycles that involves some data reconciliation.
Sure,
and if
and
it
that's
doesn't
always been true, no doubt. And look, there are other examples, and we can look at also, other rules in here. I think behind Exhibit 7 is the A1 of that, and it also has examples where poll workers, managers document reasons for inconsistencies. That's in the statute. That doesn't involve the creation of an entirely new form of counting ballots or disrupting an existing process. That is a requirement to basically document information that they are aware of, so that that information is sent to the superintendent. The superintendent has the benefit of any detailed, precinct level information that is a part of the normal existing process. So, I mean, and of course, we have been trained on pre-existing rules in that respect. And perhaps my colleague, if you have specific questions about how we do that, it's certainly true that in terms of the recap form, if there's a poll manager who understands that there's some difference between, the number of check-ins, the number of BMD counts, they would have a way, and they've already been trained on a way of documenting any knowledge they may have about that. But that is far different from creating an entirely new hand counting procedure.
Okay, I appreciate there's a distinction, but one of the arguments you've been making is this usurpation of authority and responsibility by the poll manager. I mean, it's created by the rule. I'm not saying there's been a coup here, but that the rule improperly pulls authority, supervisory authority from the superintendent and gives it to a poll manager. And Mr. Thomas's point was, that's happened before, and boy, there were no lawsuits about that. And that's in A2, where it's not the superintendent's job, but it is the poll manager's job to work through inconsistencies. And so that very same language was cut and pasted into proposed A5. I'm not saying, does it make sense to be handling ballots and the chain of custody issues, but one of your arguments has been the authority to resolve inconsistencies and sort this out. That's a superintendent type job. Mr. Thomas said, well, apparently not always, because look at A2.
Well, sure, things happen on the precinct level. Okay. I read this rule a little bit more as we were engaging, and my understanding is, I mean, the current trained process is you have a series of counts, and I think we heard more from Mr. Varghese about this, but, there's voter check-ins. Then once a voter actually, presses the button to select their candidate and a ballot is printed, the vote is not actually cast yet, but it's printed, and there's and that's called the BMD number. Mm-hmm. And then the voter walks that piece of paper to the optical scanner and then scans the ballot. And there's another number for that. And currently we are well trained on how to include in a control document those numbers. And to the extent there's one more check-in than there was a BMD, we try to figure out if we can explain it. Sometimes a voter does check in and then decide not to cast a ballot.
Right.
And so if we have knowledge of that, we would write that down, because that would explain why there was a check-in, but there wasn't a BMD number. Or if there was somebody who printed a ballot and scanned it, and then, the ballot didn't scan properly or something like that. And, we can try to make sure it's scanned properly and document what we do.
Or if the clowns went crazy
Those are all
and started
things that
killing everyone on the ballot
true
place,
at the precinct level and do involve documentation and do involve the recording of information and are matters that our poll officials have long been trained on and know how to do. But what is referenced in this rule is entirely new. There's a new control form that relates to a hand count. The Secretary of State has not issued that.
Okay, I get the new part. I'm hearing you say, maybe
right.
With training, there'd be less of a concern about this delegation because we already have poll managers doing similar reconciliation.
That's right. And I have a citation for you. So the statute addressing write-in ballots is OCGA 21-483, and this is actually behind tab 11 of the authorities binder.
I don't
and
know.
It provides that write-in ballots are adjudicated differently via duplication panel, and they must be kept separate. So dealing with write-in ballots is simply unaddressed by the hand count.
You said it's 483?
Yes, Your Honor.
Okay.
And that's behind tab 11.
Oh yeah, that's right.
Okay.
What about the mail-in ballots?
The other point here, since we're talking about the substance, is,
I like how
a lot was made of the
Sydney's
suggestion
standing in
that there's
the
some
jury
average. The
box.
average is only some, fraction of our typical precincts. Most of our precincts have more than 1,000 voters, at least as of 2 elections ago. And so there would be situations in which an individual poll manager could make the decision to potentially count later. And that's more than half of our 148 precincts. So,
if everyone voted on election day as opposed to early voting or mail-in.
That's correct. And so if a poll manager decides to conduct the hand count the next day, let's say most of the poll managers of those 80 precincts with more than 1,000 voters make that decision, then those same poll managers, presumably under the rule, have to go to the central office the next day. And then you have a scenario where there are potentially dozens, upwards of 50 different groups of 3. We have not, you have to figure out, well, how do you assess the public access part of this? All of this planning, again, goes back to the point that
Art is really hard,
having
people.
advance notice and doing this consistent with the way things
Very
are
hard.
typically done in elections administration would be much more consistent with the state election code, as well as the authorities set forth in the enabling legislation for the state election board. Your Honor, interestingly, we heard nothing from the state in response to our procedural challenges of these rules. I don't believe I heard argument regarding why it was okay for the board to not notify the public that it was taking a vote on these rules. We also heard no response to the failure by the board to state the differences correctly. That entire issue seems to not have been addressed. I'll conclude with this, Your Honor. I believe it was this morning that you issued your decision in Adams, and in that decision, I believe it was on page 5, you emphasized that the certainty of the electoral process that the laws, meaning the state election code, has long brought to voters has begun to unravel as key participants in the state's election management system have increasingly sought to impose their own rules and approaches that are either inconsistent or flatly contrary to the letter of these laws. You issued that decision in regards to rulemaking on the certification rule that also happened just several weeks or months before this election. I would submit that the rule, particularly the hand count rule at issue in this case, falls squarely within Your Honor's expressed concerns in your order of today and would even further disrupt the administration of this coming presidential election, would lead to disuniformity in this election and inconsistency among the counties. And for that reason, we ask that you today enjoin the rule and declare that not only is the hand count rule, but the other 5 rules are invalid. Thank you.
Mr. Kaplan?
Your Honor, I'm sorry. I realized I did not address the APA, and if I could have the opportunity in maybe 30 seconds to do that.
Okay, and I forgot, there were 2 forgetfuls. I forgot to call upon Mr. Kaufman to present the views of his client as a intervener defendant. So why don't I let him go first, because that may trigger something else you want to cover, okay? Mr. Kaufman, I apologize.
Thank you, Your Honor. My colleague, we're splitting our argument a little bit with my colleague Kevin Preachars.
Okay, your short argument?
My short argument,
All
yes,
right.
Your Honor. I could take a hint, right?
No hint.
No hint. Sort of on a high level, we hear a lot about, well, we don't have any rules, we don't have any guidance, but it's sort of a self-fulfilling prophecy when Blake Evans's letter on behalf of the Secretary of State said, we're not going to issue it until you're finished your litigation. So that's sort of the chicken or egg, and that goes into the issue of the Secretary of State didn't say, we won't do it, we can't do it. He said, we'll do it as soon as this litigation is resolved, and depending on how it's resolved. I would also point out to the court, as the court's already noted, that there's an Attorney General memo. It's not an opinion, official opinion. It doesn't host any of those things. And in other cases, the AG's actually said, look, I have a conflict because of these internal memos. So he's also responsible to the SEB. So I think that's important. The other thing, which ironically Cobb County's brought up, is OCGA 21-248-483, which is counting of ballots, public accessibility to tabulating center and precincts continuing. And that's really where we get into where these rules really apply in 21-243 and 484. The first one, 483A, in primaries and elections in which optical scanners are used, the ballot shall be counted at the precinct or tabulating center under the direction of the superintendent. All persons who perform any duties at the tabulating center shall be deputized by the superintendent, and only persons so deputized shall touch any ballot, container, paper, or machine utilized in the conduct of the count, or be permitted to be inside the area designated for officers deputized to conduct the count. So the statute already contemplates counting of ballots, again, not a result, but a counting of the ballot, to be held at the precinct. There's nothing new here. The State Election Board only promulgated a rule that says this is sort of how we expect you to do it, waiting on the Secretary of State, notably no longer on the State Election Board, to promulgate guidance and training. Of course, only delay is based upon Cobb County's suit, which we can agree with the State Election Board. They lack the standing, and the standing argument is something that Mr. Kucharz will handle. And the second rule, we talked about one of the six, so now we've addressed counting, but the other rule of access, poll watcher access, B, under 483, all proceedings at the tabulating center and precincts shall be open to the view of the public, but no person except one employed and designated for the purpose of the superintendent or the superintendent's authorized deputy shall touch any ballot or ballot container. Again, this rule doesn't violate it. It just clarifies what is already there, that you have access.
Well, except you tripped into one that I didn't hear much from plaintiffs, but they flagged, which is none of these people who will be touching ballots are deputized. And B says no one should touch it unless they've been deputized.
Well, I argue that anyone working at the precinct as a poll manager and poll watcher arguably has been deputized with that responsibility from the superintendent, or the superintendent, it's inferred, needs to go ahead and make that deputization.
Okay, you argue that, but I don't know that that's how it plays out. But I hear you.
Well, it already says that they're there to count, because if you go to 484, which I'll note to the court, this is in the ballot recap form and delivery. It says that upon completion of voting, the manager, meaning the precinct manager, shall prepare and sign a ballot recap form in sufficient counterparts showing, one, the number of valid ballots, including any that are damaged. Arguably, they would have to touch them and count them. Here, again, we've just clarified by SCB rule how those valid ballots are counted. The number of spoiled and invalid ballots, and the number of unused ballots. And then you go on to saying the manager shall then place one copy of the recap form and defective, spoiled, and invalid ballots, each enclosed in an envelope in the ballot container. Clearly, they're touching them already. And if anything, this form that the court has noted, we've yet to see, is only one further way of recording the chain of custody. It's no different than any other chain of custody issue. But there's no different people. It hasn't left a group of folks. So I don't see that as counter. And then if we look at 21-2-485 under responsibilities of poll officers, as soon as the polls are closed and the last elector is voted in precincts in which optical scanners are used, the poll officers shall. And then it lists
We made up a new song too.
a whole
She's a
litany of these responsibilities
warrior.
of what they
It's,
do.
J-Rance's,
None of which we
80s rock
believe
anthem.
is violated by the SCB rules or the SCB rules creating anything new that's outside of the statute. It gives clarifications. I'd also note that the State Election Board's charge is to create uniformity and as well as fairness, correct? And so many counties already are doing these exact things. They already are counting to make sure they have enough. So you have some counties doing it, some not doing it. They already have some counties that are posting per the posting rule online.
I may interrupt you here. So I don't know that you're saying these things. Is there evidence in the record before me that there are counties who currently hand count in a manner required by this rule?
I believe it's in the SCB rule minutes from when they were promulgating the rules that there was testimony from certain counties that they are already doing this. And again, that I think bears light on this whole idea that, oh, it's not feasible. Well, it's clearly
really
feasible for some counties. And
and
we would show that would certainly give credence to the idea that uniformity being the charge of the SCB, there was no rule that says thou shall not do it. So you're in an interesting situation. Additionally, some counties, over about half, post the results on their county website at the precinct level as promulgated in this rule. So again, you're at this idea of uniformity being at issue. And of course, there's a discretion at every precinct on how poll watchers or how close can they get, where do they get to go, what is reasonable access. So here,
I like when my joints
I
tell
believe the
me
SEB
it's
has
time
tried to
stop
fulfill its
smoking right
charge of
now.
creating
Just take a
uniformity
minute.
throughout
I
the
really
state of Georgia.
appreciate-
The next thing I want to
really
address
appreciate flour.
they brought a TRO, which of course is the same standards of immediate, irrevocable, not readily compensable by money, and not violative of public policy. Well, I would argue that the immediacy issue is we're not right up at the cliff at the moment. Yes, we're getting close, but there's nothing that if the court ends this case that the Secretary of State has not said I am unable to make rules and not unable to create guidance or to teach. And of course, most of what we're talking about is stacking things into piles of 50 and counting to 50, which again, we've addressed in 43, 44. I would argue that it's already contemplated under the code. And presumably every poll watcher, poll manager has been vetted and has signed an oath that they are competent, they're not criminals and whatnot. And so I don't think this is a major ask to count. Again, it fills our public policy of having meaningful access to poll watchers so that they can count stacks of 50, gives them an idea of that this is valid versus some massive stack, or here we just never even did anything, just stuck it in one bin to another.
What's the gain of the process if it doesn't become part of the certification process?
Well, I'm not sure it doesn't.
So walk me through how it does.
Sure. Well, for example, in the election code, the superintendent, if they believe that there is fraud, irregularities, misconduct, or errors, they're entitled specifically to summon the poll manager to explain why there is this deviation.
Right. So let's talk about uniformity here. Since the rule doesn't require that the results be reported somewhere or be acted upon, doesn't it then become really up to the superintendent to decide, that poll manager, he never could count anyway, and so I'm going to disregard this report, or I get one and I'm going to take, because I've got one, there must be a problem everywhere. And I think there's a lot of passion behind this, and for good reason. It just was surprising as we as a group suss this out. What's the so what of the rule? And the so what of the rule is a poll manager might conclude there was an inconsistency. There were 800 ballots listed on the microchip, and we only counted 790. There's not a defined mechanism, what you do with that news. And there's no requirement through this rule or any parallel rule that the superintendent must do something about that or anything like that. And so why go through the exercise if it doesn't have that final hook to say, when this happens, if there is an inconsistency you can't resolve, you press this red button and we've got a reason to be worried about it.
Sure. And I think I can answer that question, Your Honor, and that's because there was no need for the rule because there's statute under OCGA 21-493B, which is under the computation, canvassing, and tabulation of returns, investigation of discrepancies in vote counts, recount procedure, pilot programs, and whatnot. And so specifically under B, they talk about overvotes and undervotes with excesses based upon the precinct level. And in fact, it reads, the superintendent, before computing the votes cast in any precinct, shall compare the registration figures with the certificates returned by the poll officers. Again, it's undefined term certificates. I would argue this new one could possibly be concluded, showing the number of persons who voted in each precinct or the number of ballots cast. If upon consideration by the superintendent of the returns and certificates before him or her from any precinct, it shall appear that the total vote returned for any candidate or candidates for the same office or nomination or on any question exceeds the number of electors in such precinct or exceeds the total number of persons who voted in such precinct or the total number of ballots cast therein, such excess shall be deemed a discrepancy and palpable error and shall be investigated by the superintendent.
So it flows into that. The
Correct.
Notice that would come from a poll manager that we had an inconsistency that couldn't be resolved would be a 493B alert.
Exactly. And it specifically continues, it says, and no votes shall be recorded from such precinct until investigation shall be had. And continues on.
I'm familiar.
We're pretty familiar. We
Yeah.
spent a little time with it last week, as
Yeah.
I recall, Your Honor. But to answer your question, that's why. And again, it also fulfills the public policy, which since 2020, the legislature has taken pains to try to give voter confidence in the election. And this is one more step to go, here we go. Additionally, they've isolated it by precinct, again, for the 493B purpose, but also if there is an election challenge, there's evidence that can be found in a much easier and readily available way for a candidate or party, and that's significant because once it leaves the precinct and ends up at the tabulation center and then ultimately dumped into one giant pile, it becomes a very difficult process. And as the court just ruled today, as we all agreed, consented at the Adams hearing last week or 2 weeks ago, that certification is mandatory within the time frame. That now you would be
all agreed.
Well, we agreed on certification. That at that point, then it now will be triggering the challenge purpose. And so that is partly why now you've isolated, because when you have to bring a challenge within 5 days after certification, it's a near impossible process, especially on a larger scale, big county or statewide. So those are all reasons why that rule, I believe, in particular, the hand count rule, has some great validity as to under the public policy. So we don't believe that this rule is violative of public policy. If anything, in joining the rule would violate the public policy that's the overarching, which has been to have more transparency in the election process. And again, they've talked about funds and costs. Well, that's that's compensable by money. So that they are going to fail on at least 3 of the tenets of what is required under a TRO. The last quick issue, because I am trying to be brief with the court, and I know the court's studied up and intimately familiar with this issue, but we've heard this sort of quasi-Purcell doctrine. Well, specifically, Purcell is applicable to courts. It's not applicable for courts to make changes. Additionally, it's an impact on the voters. None of these rules impact the voter. Most of these are having to do with post-election, how we're counting post-election. So it's not impacting the voter. It doesn't cause confusion to the voter. And I would also point out to the court that as recently as 2020, the State Election Board created rules much later in time affecting the 2020 election than what we've had this year in 2024.
How could it be later?
They were last minute rules during COVID and
the day of the election.
Well, it was a little later. And again, these rules have been in the works for long periods of time. They were certainly administrative hurdles due to internal conflicts, between the SOS, the SCB, the Attorney General, but it had nothing to do with the SCB's bringing notice of these rules and going forward, as well as, we've talked a little bit about strict and exact compliance. But at the end of the day, the public was aware, these are the rules, these are the topics. And the SCB has always, they didn't deviate from how it has operated. And I think that's significant. Maybe it's not the best practice of how it should be operating with today we're talking and then we're voting, but there was no deviation. There was no certainly a lack of public notice or comment. We've talked about the thousands of pages and open meetings, and most of these took 2 days and were significant in that nature. So
I don't know that it becomes okay because it was always wrong, and so it was still wrong in terms of notice. I don't know what kind of argument that is. Like, well, we never got it right, so don't hold us on this one, because we never ever told anyone when we were going to adopt rules. We always just said, here's when we're going to discuss rules.
Well, they'd gone through a pattern of practice of giving notice of the rule, discussing it, and then a waiting period and voting. I don't think that none of that has changed here.
But if it wasn't compliant with the APA to begin with, it doesn't somehow, it's not like there's laches here and these folks can't argue that it was inconsistent with the APA because it's happened in the past that notice wasn't provided, that now this meeting, we're going to we're going to vote up or down on the rule. That's all I'm saying. Is it may well be that for the last couple of years, the only notices say, today we're going to discuss these things or we're going to accept comments on. But if the rule is you actually need to be more specific and say, on this day, we are going to vote up or down on this. The fact that that didn't happen isn't okay just because it never happened before. It was always wrong if that's what the rules are. And it was fairly persuasive that you, in fact, need to give notice more specifically than, you know, we're going to be thinking about these things today.
Well, I'm not going to concede that they didn't comply with the APA. My point was that there was no deviation in practice. I mean, if taking that argument to the most extreme, then every rule ever promulgated by the SEB since practice for years should be invalidated.
Or could be. Who knows?
Could be.
Right.
Yeah. I don't think that's really what occurred. This is standard notice. No one has yelled surprise or but for. If I had I known this wouldn't have occurred, or that's not really what it is. And then again, you go into the standing argument as to is Cobb County Election Board or my Democratic colleagues the proper party to even bring that, and that goes into the standing, which if the court doesn't have any other questions, I'll yield the well to my colleague.
Please do. Thank you.
Good afternoon, Your Honor.
Good afternoon.
Kevin Kuchars, nice to be in front of you. And I can be even briefer than I think probably anybody else. I'm going to talk about standing, but before I get there, I wanted to touch on one issue that I anticipated being discussed but hadn't been. And that was the issue of the delegation of authority to the election board. And the way that the rulemaking authority statute has been described has been just providing for uniformity in practices. Well, I would suggest that if we look at the rule itself, it says to promote rules and regulations so as to obtain uniformity in the practices, et cetera, et cetera. But then it goes on to say, as well as the legality and purity in all primaries and elections. Now,
that P word, to me, that's a funny word for, like, what's a that's sort of like, have you had relations with someone before? I don't know that any election is pure. Good luck with that.
It's funny you say that. I had in my notes, I'm like, it's a colorful word.
It is a colorful word.
It's not one I would have used, but I understand.
It's there.
I understand what they mean and what they're getting at. In this context, it has to be read as delegating authority to the election board to promote and promulgate and enact rules that they believe will lead to greater confidence in election security and actually in promoting the integrity of the results that are actually reported. So to suggest that there is no rulemaking authority that's been delegated, I think is frankly incorrect. Now, is that delegation of rulemaking authority too broad? That question is not before the court. There may be a proper action to bring that at some point, but it just isn't that statute is not being questioned here. There's no question. Nobody's standing here today saying that statute is unconstitutional. This would not be the proper action to do that. So based on the law, the election board did have authority to make that judgment call that they needed to take action to promote the purity, we'll keep using that word, of the election process by enacting rules like the hand count rule. And that's really all I wanted to say on that point.
Okay.
Okay.
I'm glad someone brought up purity.
All right, moving on to really just circling back to the motion to dismiss. Your Honor, I appreciate you having read the motion. I know it was filed on short notice, but based on your questioning to the petitioners, I could tell that you understood our arguments, so I can keep this very brief. What we're dealing with here is a request for an advisory opinion. There's no uncertainty as to what they're required to do. There's no uncertainty as to whether the Cobb County Board will get punished for making the wrong decision. They know exactly how that would play out, and there's no uncertainty that needs to be resolved through a declaratory judgment action. The uncertainty that they've talked about is uncertainty as to whether the rules were properly enacted. Well, that's not the type of uncertainty that this particular petitioner could challenge in a declaratory judgment action. They've also talked about there's uncertainty as to whether the board exceeded their delegated authority. I think my first part of my argument covered that a little bit, but again, it's not the type of issue that the Cobb County Board can challenge in this action. going back to, I think it was your first question, what is the legal right that the Cobb County Board actually has here? There is no legal right that I've even heard them claim that they don't have to comply with lawfully promulgated rules of the election board. There is no legal right for them to decide in advance, hey, maybe this rule will get overturned down the line, and we want to go ahead and decide not to enforce it or to get an opinion that we don't have to. So again, it is a fundamental point. The nature of declaratory judgment action, you need to have a legal right. And actually, legal right is also in the sovereign immunity waiver, the 50-1310. So to the extent there isn't a legal right, they don't even have the ability to bring suit here. So in the absence of an articulated legal right, they simply can't bring this action. There may be a proper action in which a proper party could challenge it, but it isn't here. And again, another component is there is no jeopardy. I kind of touched on this, but let's say they make a mistake. Let's say they do something wrong. Nothing's going to happen to them. They point to that one statute that says, well, if we make 3 mistakes over a certain period of time, we could potentially lose our ability to do our job. Well, that statute written into it, there's an exculpatory outlet. They only get punished if they don't fix their mistakes. So if they continue to willfully make mistakes, then they could get punished. But there is no jeopardy that attaches to any right that's been asserted here that would enable them to bring a declaratory judgment action. And finally, I'll say, Your Honor, this case could very well set depending on your ruling, if you rule for the petitioners, I'll probably be citing the opinion in cases where I want to bring a declaratory judgment action, because I think permitting this would significantly broaden the scope of the types of declaratory judgment actions that you could bring. So, the old maxim of expediency or, difficult cases bring bad rulings. I think we're very much at risk of having one here. So,
maybe not the word.
The final point, Mr. Kaufman talked about it, but promoting confidence. You said it yourself, the rules, particularly the hand count rule, were intended to promote fidelity. And, that's why waiting till next year isn't good enough. It would be easier for everybody. It would, resolve a lot of difficulties, clear the court's docket, understandably. But fidelity is an important concern, and it's the reason why just kicking the can down the road just isn't good enough here. Georgia, as we all know, has had its election integrity called into question in the recent past. And certainly, I would suggest that a rule which is intended to promote fidelity in this upcoming election that gets kicked out at the last minute will severely undermine voter confidence. And everybody's watching. This is going to be in the news, and I think it could lead to some bad results. That's all I have, unless Your Honor has any questions.
I'm good, thank you. Appreciate it. Uh-oh. What does your cell phone tell you?
It's well past lunch, Your Honor. No.
Yeah, and my stomach tells me that.
I just would request, you had asked on the agenda meetings, and I would stand on my place to say that the agenda from September 20th says discussion and voting, and then lists the proposed rules. I would ask that we be able to at least keep the record open so we could supplement I believe they're 8038 exceptions, since they're public documents, but I'm happy to send it to all council for their approval if they don't have an objection, to send in the meeting notices from the state election board with the agenda.
Agenda or notice? I'm looking at the notice for the September 20th meeting, and it is to provide the public, this is Petitioners Exhibit 2, we all looked at it.
Yeah.
To provide the public an opportunity to comment upon and provide input into proposed rule amendments. Turns out one of them wasn't an amendment, it was an entirely new rule. But either way, doesn't say anything about voting. If the agenda that's published when? The day of the meeting, the day before?
I think it's a few days before, Your Honor.
your argument is that's the notice to the public?
No, my point is, I think it should be at least that this is the entire notice, and because some of these rules were carried over from the August agenda as well, and so that's why I'd like to put all three of the agendas into the record with the court's permission.
Okay. If you can get copies of those to all the other lawyers, I think it makes sense to have a full and complete record.
Okay, thank you.
You bet. Mr. Thomas, you were reminded of arguments you didn't make by Mr. Kaplan. So yeah, exactly. You were sitting pretty. I'm like, damn, they are scared of those arguments. He didn't even touch them. But now you're going to touch them.
And I'll be very brief.
Okay.
The statute that they're citing, it says prior to the adoption.
What is that statute?
5013-4. Subsection A says, prior to the adoption, comma, amendment, comma, or repeal of any rule. Subsection E is the exact compliance section, and it says, E, that no rule adopted shall be valid unless in exact compliance. It does not say that no rule amended, D, shall be in exact compliance. And the Court of Appeals in Corner versus State, 223 Georgia Appellate 353, a 1996 decision said that strict compliance is only necessary when a rule is being adopted, not amended.
Can you give me that site again?
223
223.
Georgia Appeals.
Yep.
353.
353. Okay.
And it further says that it's not, the question is not only whether they substantially complied, which is what the court identifies as the standard, but also whether there has been a demonstration of, quote, substantial harm. So that's all I would say in response to all of that.
Okay. That second piece is sort of what I was waiting for. I mean, there's exact compliance, but if a comma was missing and there's no harm, that seems like a rather draconian approach. Thank you.
Brief response on that, Your Honor. One citation.
Response to which? I just heard from three lawyers.
Just the citation of Corner versus State.
The 223 Georgia Appeals?
Yes, sir.
Okay.
So that's a Court of Appeals decision. Since then, the Georgia Supreme Court and Outdoor Advertisers Association versus Department of Transportation. Sorry, that's not Supreme. This is also a Court of Appeals case said, quote, failure to comply with OCGA 50-13-4
Stop it.
A1 invalidates the amended rule. So
What's the citation? Is that, I think that you've cited it before, but
yeah, it's 186 Georgia App 550.
so it's an older opinion than the one that Mr. Thomas cited. That's okay. I just 186 Georgia Appeals. The secret last few numbers?
550.
550. Thank you.
Yeah, wouldn't it be new or adopted or cancellations, right? Deletions, I
I'm
guess.
happy to go on, but I think the court can sort through that if unless it would like more argument on those issues.
I would like you or a colleague to share your thoughts about the claim that many
Democracy by loophole.
local
what a
election
great
boards
idea.
countenance and
Great.
engage in the hand counting of ballots already. And also your reaction to 483 really being a proper hook. Because I encourage you to skip past 483 when we were talking about the statutory authorization for the hand counting rule. But in reading it, I didn't read it in the way that Mr. Kaufman narrated it. I don't disagree. He didn't add words to it. I just hadn't thought about it that way. And so I'm curious if you have a response to either, yes, hand counting already happens all the time in lots of places, and then this 483.
Sure, Your Honor. I'm Daniel White again. This is where my history here. My firm's been representing this board for decades. When it was Democrat, then Republican, then Democrat. Like, so we've been doing this a long time. And I've got this history, and I know, and I pay attention to the history of these laws, and I kind of chuckled because when you were asking about purity, if you look at this is a different note, but if you look at purity, that was adopted in 1958. So the connotation of purity when that duty was adopted in 1958 may have had a little more nefarious or unpleasant connotation. So that's the kind of thing you have to pay attention to, is when did these rules come into laws get passed? So if you look at 483, 44, and 485, these are all adopted under the old form of optical scanners in 1981. The last update to them were in 1999 for all three, I believe, or at least one of that was the last update I saw for one of them. And so these were really adopted when you had optical scanners where you're marking it, hand marking it, it's running it through the machine at the precinct. And then so you don't have a machine that's already doing a count for you when you put it in there. So they're going to count it again. And there were rules around when you're using that equipment from 1981 to 1999 before the direct recording machines came in 2000. There were rules around how you do that process, and those were interpreting 483, 484, and 485. Those have not really been, I don't think any of these have been updated to address the new BMD, the ballot marking devices, and the optical scanners that were adopted under OCGA 21-300, which requires uniform equipment throughout the state and authorizes the Secretary of State to basically go out and find the equipment and approve it and certify it and distribute it. But there's no doubt that these are opticals. I mean, that's what this is. It's an optical scanner. It's just that now the optical scanner has the count function built in. So we now have, before this rule came in, we had 4 counts already. You got the poll pad check-in. You got the BMD that's checking the number of votes that are cast on each machine, and you're going to get a printout from those machines. You got the memory card, let's go on to the scanner. The scanner is doing a count. It's going to have a memory card and a tape that it prints out. So really, that's just 4 counts right there. And then the process now, and you are asking lots of questions from Mr. Varghese about this, but for Cobb County particularly, those ballots, as they are under the current process, are taken. The write-ins are handled separately. The regular ballots are taken, put in the sealed container with all of the other materials, including the cards, the memory cards, and taken by the poll officers and a law enforcement officer to the central location. And so that's the current process that Cobb would have to change now before the November election if we're going to go with the new one. And so what this count that it's talking about is not a hand count. At that time it was, because they didn't have a machine that did it. But sort of the new equipment that's been certified by the Secretary of State says, we trust the machine count, and the canvassing that you get into in 493, that's where, you're bringing these back in these sealed containers. They're getting checked in. You're getting a receipt to the poll manager saying, you've given us 4 different counts from 4 different machines, and we're getting a receipt saying we've got these items. And then during canvassing is when the superintendent is doing this investigation of, looks like we had, this says we had 730 ballots, but really we ended up with 750 or 720, and why is that? And it usually is something totally it's like, well, we ran a test batch and someone forgot to reset the counter, and so there was 10 extra ballots. They didn't have any races on them. They're just some test ballots. So that's what canvassing is. What this new rule wants to do is it wants to have all of that addressed before the 11:59 deadline that on voting night that the Secretary or the SEB has put in place in a different rule. So they want to say, we want you to do all that canvassing, reconciliation, and cram it in. We want the poll managers to try to figure out what went wrong and tell us why we should trust these votes by 11:59. Well, 493 in the canvassing process that occurs before pre-certification and before certification the next Monday is where that process happens. And then there's a report given to the superintendent, and the superintendent takes that report and says, we've canvassed, we discovered these discrepancies. Every election director across the county is giving these reports saying, this is what we found during canvassing. What the SEB is asking you to do is to give us all that information before we report the results at 11:59. And that's unreasonable. It's not reasonable. And so that's when the Georgia GOP is citing to 43, 44, and 45 saying this is authorized, it's authorized, but it's already done. It's counted by the machines. Those 4 different counts that are done at the precinct level are then taken to the superintendent. And I want to point out 420, if you look at the structure of the statute, 420, it applies to all the different methods of voting. And you asked earlier, well, don't some counties still use paper ballots? They don't. Everybody has to use the same equipment. These are not receipts, these are ballots. So when they're counting, these are the ballots that they're counting. And so everybody uses the ballots from this equipment, and 420 governs all the different methods of voting. And so when these statutes are adopted, when the rules are adopted, they all have to comply with 420. And 420 says you do it as soon as possible, you get all the materials back as soon as possible, and you don't stop until you finish. And this rule creates an internal conflict with both of those, as Mr. Kaplan pointed out, that you're saying, well, slow down, don't do it immediately. And also you have the option of ceasing counting until tomorrow. So that rule in and of itself creates an internal inconsistency with 21-420, which governs all forms of voting at the precinct level and is still in place and was in place at the time that the new voting equipment was adopted. I did also, you asked questions about the current procedures. There are some counties that have runners who go get the memory chip and go take them to the central office. And then they do it, like you said, they do leave the poor poll managers there to do all the other work and close down. Cobb County doesn't do that, has not done that, has not budgeted for that, has not hired those workers, has not deputized them, has not trained them. So if this rule goes into effect in next week, we now have less than a month to do that. And that's why, in terms of Cobb County's irreparable harm, demonstration of, what's going, this is not ifs and buts, this is what's going to happen. And she's saying in terms of, Ms. Silas counts it in terms of concerns, because if we have to do it, we're going to do everything we can do to comply with it. But it looks to us like it's going to be pretty difficult to comply with it. We haven't had the proper time to train, to hire, to identify. So then we're talking about 444 people to count, plus now 100, because you got to have 2. We're going to have 148 times 2 plus security to go get the cards and run that and repeat that process with the memory chip. So we're being told now to do this. And just going to the ultimate question of reasonableness, Your Honor, and history. You asked us at the beginning, why are we not just slowing this down? As someone who knows the history of how these rules are implemented, these rules are typically implemented in off years and municipal elections. They adopt these rules. You do some test runs. Cobb County gets asked to do the test runs on this stuff all the time. Jenny Nevler, when she was our former director, was always saying, hey, we're going to do this. The Secretary of State's asked us to do this. You adopt them in an off year. You work out the kinks in a municipal election. And if for some reason you need to do it in a federal election year, you start back before the March and May and April primary. Like you start early and you say, hey, we're going to figure this out during the PPP, and then we'll know by the primary and it should work by then, but we're not going to do it. It's not reasonable to implement a rule 1 month before an election.
Get that backup
and
plan
in this case,
place.
2 weeks before an election after it's already started. So that's the history that I think Your Honor might not have been aware just from
BRB, gotta walk
identifying me as an expert. And I think that's probably an upgrade over what I would consider myself, but I've just been around long enough and seen this long enough that that's the normal process. And these rules that they're talking about that were adopted in 2020, that was COVID. And this was a brand new voting system that had been brought in 2020 without a dry run in a municipal election the year before, because we had a federal court say you better go get some new voting equipment. So we had COVID and new voting equipment in 2020. So you can kind of understand why there were some late rules in 2020. We've had this voting equipment for 4 years. There's no reason now that there need to be new rules implemented 2 weeks before Election Day. So I'm sure I lost track of your original questions there, but I was trying to give you some context for that.
That was very helpful. You answered all of them except for Mr. Kaufman asserting, trust me, there are lots of places that hand count ballots now. This rule is just sort of catching up with those in the vanguard. My words, not his, but are you aware from your work and talking with your election superintendent if In what circumstances would there be hand counting other than that which is already contemplated when a discrepancy does arise from things that a superintendent is tasked with doing?
You know, that'd really be probably a better question for Director Fall, but I can't say, we tend to converse along the larger counties. I mean, you'll see a lot of the questions being raised are by the larger counties because we have.
More complicated.
It's more complicated. We have more problems to deal with, but among the larger counties, I'm not aware of it. There may be some smaller counties. And under 43 and 44, like if you see in 45, there's like a distinction between people that can't tabulate at the precinct versus the tabulating center. That's not really a thing anymore because we all tabulate through the machines now. But there may be some discrepancies about who counts at the precinct versus who counts ballots after they return them to the tablet, which we do. I mean, there's just no doubt that these get counted when they get back to the tablet. It's just they use a machine, which is more reliable. And then if during the canvassing and during the audit, if there's discrepancies, that's where it comes in. And so, and there's a lot of different ways that they could ask for a hand count and put it during the canvassing or other things that would have been reasonable. But that's I'm not aware. That's short answer to your question is I don't know, but other people may have those conversations that I'm not aware of, and it's not in the record that I've seen.
Nope, it's not. All right, thank you.
Your Honor, would it be helpful for me to briefly clarify what the status of case law on whether amendments must follow the APA notice requirement? Happy to be told no, but.
Well, I guess that there's a dispute, and the newer case that was cited to me said it does not apply to amendments. Do you have something newer than the
advertisers?
Well, outdoor advertisers, at least the citation I was given, made it older than the case
Right.
Mr. Thomas cited.
Right, and no, I don't have something newer, but I want to clarify what those two cases say.
Okay.
Outdoor advertisers says that 5013-4A does apply to amendments. What Coroner later says is that it talks about a specific amendment, and what it says in that case, what happened is the amendment did not state the statutory authority of the rule, and petitioners sought to invalidate it on that basis. And the court said, well, it's the statutory basis of the rule and it's the amendment, and the rule itself outlines the statutory basis. So under those specific facts, the public was apprised of everything it needs to know.
Okay.
That same analysis does not apply here.
I'll need to read both cases, but that's a helpful distinction. Thank you. No one else should stand up because we're done. I want to thank our court reporter first for taking all this down. And then to all the lawyers and the folks supporting them, this was a mad dash to get here today. That's not anyone's fault. Things are happening quickly. The state election board has been working hard to move forward in the ways it thinks is the right way to make elections fair, legal, and orderly. Some of the steps they've taken, the majority has taken, other folks disagree with, and lawsuits have followed. So we're here because we work things out in courts and not with coups and other things like that. But it has been hectic, and I appreciate everyone's work to be ready, in particular, my friends from Burr and Foreman, because this wasn't on your radar at all until very late, and you've been working on other cases. Fortunately, similar issues, so I'm assuming it wasn't too complicated to pivot, but it was still a rapid pivot. And Kaufman and Kirchhoff, you guys just parachute into all cases now, so you're sort of the shock troop. Same with our interveners. But this has been very helpful. This is an important situation. And I will work to provide a little bit of clarity today, and then we'll see where that takes us. And I guess some of you will then need to navigate what that means for tomorrow at 2. And things will flow from there. Does anyone have a procedural? Oh, I was asked to ask, are there defense exhibits that you meant to admit, or maybe there was this overall stipulation? Mr. Kaplan waved around the giant binder, and Mr. Thomas, you said we don't object to that. And I know we got the plaintiff interveners exhibits were admitted. I want to make sure the record contains your exhibits as well.
We did submit those. There were only 2 exhibits. They related to the statistics from the 2020 and 2022 elections.
Yeah, I hope they're not objected to, because I looked at them last night. That's how I knew where you were coming with hey, most of the votes aren't even on election day. No objection to defense 1 and 2. No. Okay. And Mr. Kaufman, you're free to supplement through defendant interveners exhibits if you get your hands on copies of those agendas, but run them by counsel first so they can be comfortable that that's not something you just ginned up in Adobe or something like that. Okay.
I'm not that technologically savvy, as the court knows, but
Yeah.
we'll have those sent
Okay,
out.
I'm
We have
back.
them already.
Hold
We'll email them as soon as.
Okay.
All right.
Sounds good.
Did I miss anything good?
Mr. Kaplan, anything procedurally from your client?
No, nothing else, Your Honor.
Okay, anything from the plaintiff interveners?
No, Your Honor. Would the court like paper copies of the exhibits we admitted?
We have them digitally. We're good. Thank you. Mr. Thomas, anything else on behalf of the State Election Board?
Nothing further.
All right, thank you for your work. Mr. Kaufman, anything else?
Just I would proffer that to my knowledge, it's Hall, Forsyth, and Paulding County that do the hand count, because I never got that out to the court, but that's.
Right, and what does that mean, they do a hand count? That they will, despite what all the machines say, they also make sure if the total vote in Hall County was 100,000 people voting, they make sure there are 100,000 paper ballots, or only when something funky arises?
So my understanding is they count the number of ballots at the precinct before they send them off as per the rule.
Okay. All right, thank you. Someone needs to settle up with the court reporter, and I will be in touch. Thanks for your time.
All right. Rock and roll. Well, there you go. Thank you, counselors. Thank you, counselors, so very much. Wow. That was a good. Thank you, Gal, for pointing out all the good stuff that was happening this morning. I certainly appreciate it. I love our collage, how that's coming together. Wow. Oh boy. Overwhelming. So well, that was fun. I'm going to go ahead and update this. I will update the description with all of, oh, there's Smeagol. He snuck in there. Look at that. Look at that little sneak. We're going to have him go down there. He's kind of scary. I don't know. Maybe actually I don't want him. I am going to want to hear that interesting bit. Well, then I'm going to roll it back.
And 420 governs all the different methods of voting. And so when these statutes are adopted, when the rules are adopted, they all have to comply with 420. And 420 says you do it as soon as possible. You get all the materials back as soon as possible, and you don't stop until you finish. And this rule creates an internal conflict with both of those, as Mr. Kaplan pointed out, that you're saying, well, slow down, don't do it immediately. And also you have the option of ceasing counting until tomorrow. So that rule in and of itself creates an internal inconsistency with 21-420, which governs all forms of voting at the precinct level and is still in place and was in place at the time that the new voting equipment was adopted. I did also, you asked questions about the current procedures. There are some counties that have runners who go get the memory chip and go take them to the central office, and then they do it, like you said, they do leave the poor poll managers there to do all the other work and close down. Cobb County doesn't do that, has not done that, has not budgeted for that, has not hired those workers, has not deputized them, has not trained them. So if this rule goes into effect in next week, we now have less than a month to do that. And that's why, in terms of Cobb County's irreparable harm, demonstration of, this is not ifs and buts. This is what's going to happen. And she's saying in terms of, Ms. Silas counts it in terms of concerns, because if we have to do it, we're going to do everything we can do to comply with it. But it looks to us like it's going to be pretty difficult to comply with it. We haven't had the proper time to train, to hire, to identify. So then we're talking about 444 people to count, plus now 100, because you got to have two. We're going to have 148 times 2 plus security to go get the cards and run that and repeat that process with the memory chip. So we're being told now to do
There's
this.
also no
And I'm just
procedures,
going to the
uniform
ultimate
procedures.
question of reasonableness, Your Honor.
There's no uniform procedures to resolve the conflicts that these people are supposed to identify. If there's a conflict, they're supposed to identify it, stop the presses, count, or resolve the conflict. That's the terminology I believe they use. So it's a no-win situation. It's a no-win situation. Hi, Val. How are you, darling? No, it's a no-win situation. You can't, because first of all, here's scenarios. You've got rogue election clerks who can, drag their heels investigating anomalies and irregularities, all those ridiculous terms that maggots have clung to over the last few years. And then you've got genuine election clerks that find some anomaly or whatever, or what they think is an anomaly because perhaps they are or are not trained in how to identify certain things. Then they have to stop the presses, and they either don't have the capacity, and that can mean numbers, or it can mean intellect, or not intellect, but skill set. Sorry, I didn't mean intellect. But they don't have the skill set to actually manage that process or execute that process. It's like, that is the most ridiculous. What a fucking ridiculous situation to be in. I just want to see if he gets to that part about the coups.
Honor, and history, you asked us at the beginning, why are we not just slowing this down? As someone who knows the history of how these rules are implemented, these rules are typically implemented in off years and municipal elections.
Economic forum.
They adopt these rules. You do some test runs. Cobb County gets asked to do the test runs on this stuff all the time. Jenny Nevler, when she was our former director, was always saying, hey, we're going to do this. The Secretary of State's asked us to do this. You adopt them in an off year. You work out the kinks in a municipal election. And if for some reason you need to do it in a federal election year, you start back before the March and May and April primary. Like you start early and you say, hey, we're going to figure this out during the PPP, and then we'll know by the primary and it should work by then, but we're not going to do it. It's not reasonable to implement a rule 1 month before an election. And in this case, 2 weeks before an election after it's already started. So that's the history that I think Your Honor might not have been aware just from identifying me as an expert. And I think that's probably an upgrade over what I would consider myself, but I've just been around long enough and seen this long enough that that's the normal process. And these rules that they're talking about that were adopted in 2020, that was COVID. And this was a brand new voting system that had been brought in 2020 without a dry run in a municipal election the year before, because we had a federal court say you better go get some new voting equipment. So we had COVID and new voting equipment in 2020. So you can kind of understand why there were some late rules in 2020. We've had this voting equipment for 4 years. There's no reason now that there need to be new rules implemented 2 weeks before election day. So I'm sure I lost track of your original questions there, but I was trying to give you some context for that.
That was very helpful. You answered all of them except for Mr. Kaufman asserting, trust me, there are lots of places that hand count ballots now. This rule is just sort of catching up with those in the vanguard. My words, not his, but are you aware from your work and talking with your election superintendent, in what circumstances would there be hand counting other than that which is already contemplated when a discrepancy does arise from things that a superintendent is tasked with doing?
I can't, that'd really be probably a better question for Director Fall, but I can't say, we tend to converse along the larger counties. I mean, you'll see a lot of the questions being raised are by the larger counties because we have.
It's more complicated.
It's more complicated. We have more problems to deal with, but among the larger counties, I'm not aware of it. There may be some smaller counties. And under 43 and 44, like if you see in 45, there's like a distinction between people that can't tabulate at the precinct versus the tabulating center. That's not really a thing anymore because we all tabulate through the machines now. But there may be some discrepancies about who counts at the precinct versus who counts ballots after they return them to the tablet, which we do. I mean, there's just no doubt that these get counted when they get back to the tablet. It's just they use a machine, which is more reliable. And then if during the canvassing and during the audit, if there's discrepancies, that's where it comes in. And so and there's a lot of different ways that they could ask for a hand count and put it during the canvassing or other things that would have been reasonable. But that's I'm not aware. That's short answer to your question is I don't know, but that other people may have those conversations that I'm not aware of. And it's not in the record that I've seen.
Nope, it's not. All right. Thank you.
Your Honor, would it be helpful for me to briefly clarify what the status of case law on whether amendments must follow the APA notice requirement? Happy to be told no, but.
Well, I guess that there's a dispute, and the newer case that was cited to me said it does not apply to amendments. Do you have something newer than the
Advertisers.
well, outdoor advertisers, at least the citation I was given, made it older than the case
Right.
Mr. Thomas cited.
Right, and no, I don't have something newer, but I want to clarify what those two cases say.
Okay.
Outdoor advertisers says that 5013-4A does apply to amendments. What Coroner later says is that it talks about a specific amendment, and what it says in that case, what happened is the amendment did not state the statutory authority of the rule, and petitioners sought to invalidate it on that basis. And the court said, well, it's the statutory basis of the rule and it's the amendment, and the rule itself outlines the statutory basis. So under those specific facts, the public was apprised of everything it needs to know.
Okay.
That same analysis does not apply here.
I'll need to read both cases, but that's a helpful distinction. Thank you. No one else should stand up because we're done. I want to thank our court reporter first for taking all this down. And then to all the lawyers and the folks supporting them, this was a mad dash to get here today. That's not anyone's fault. Things are happening quickly. The state election board has been working hard to move forward in the ways it thinks is the right way to make elections fair, legal, and orderly. Some of the steps they've taken, the majority has taken, other folks disagree with, and lawsuits have followed. So we're here because we work things out in courts and not with coups and other things like that. But it has been hectic, and I appreciate everyone's work to be ready, in particular, my friends from Burr and Foreman, because this wasn't on your radar at all until very late, and you had been working on other cases. Fortunately, similar issues, so I'm assuming it wasn't too complicated to pivot, but it was still a rapid pivot.
Thank you. Thank you, Judge, Your Honor. Judge, Your Honor. Judge, Your Integrity. Was that Chicago thing today? I'm starting to get confused about where the fuck he is, because the backgrounds start to look the same. The hostesses look the same. Everybody looks the fucking same. Oh, well, thank you, Oren, for telling. I needed to hear that. That needs to be clipped and shared. Just that little tiny soundbite. We need to put that to a beat. Absolutely. Yeah, caps lock it away. That deserves it. But was the Chicago, was that today? Was that like a day ago? Like, I don't even know. He was in Pennsylvania yesterday, right? And then today he's going to be somewhere else. I don't know. Was that what it was? I guess I'll have to watch that. Oh, my lordy, lordy. Well, I really appreciated the judge. I think he did a great job. I really think so. I can't wait. Yeah, coups. Coups. We'll have to make that. We'll have to. I definitely, we need to put that against it, some kind of beat. I'm probably not the person to do it, but I certainly would try just for fun. Well, thank you for coming to my clam bake. Trump never. Oh, he just rambled. I love that. I love that. I love it. All right. I'm going to grab something to eat. Okay, thanks for spending my morning, your morning, somebody's afternoon, you know, all that, all the above, somebody's nighttime, all of that. Thank you for sharing your time with me, which is so precious. And I hope the rest of your, what is today, Tuesday? Yes, Tuesday. Why, yes, it is. I hope the rest of your Tuesday is good. I hope you have a great day and a great night, and I will definitely see you tomorrow morning at the same time, 6:30 a.m. Pacific, and et cetera, after that. But yeah, I'll see you tomorrow morning. Thank you so much. Thank you, Judge. Thank you. Thanks, Clark. Thanks, everyone. Thank you for coming today. I really appreciate it. All right. I love you guys, too. Take care. Have a good Tuesday.